Chiaro Pisani.
Ready.
This is case number 2018 CA 5321. Starting with the plaintiffs. Let's take appearances, please.
Good morning. Samantha Lawrence on behalf of the Kowalskis with assistance from Greg Anderson, Nick Whitney, and Jennifer Anderson.
Ms. Lawrence, good morning.
Howard Hunter, Your Honor, with Pat Crowell's, Ethan Shapiro, and David Hughes, and Chris Altenburn for Johns Hopkins All Children's Hospital. Our corporate representative today is Dr. Michelle Smith.
Morning. I'm trying to see if Mr. Altenburn is here. Mr. Hughes is blocking him.
I'm here.
I'm sorry, Your Honor, but preliminary matter, we have, I don't want to ignore the doctor in the room. Dr. Kirkpatrick is here. We have him under subpoena. We left a message with his office on Friday, which he acknowledged he got, that said he did not need to appear this morning. And he's here in the courtroom. And we've advised him we don't need him today. We told him on Friday not to come. But he's here. He's not released from his subpoena, so he can't stay in the courtroom. Not sure why he's here, sir, but I wanted to address the issue.
Is he, I'm trying to figure out where he is in the treating expert panoply of experts.
I think the ruling from the court's been clear that if you're a treater, you don't get to, that the thing's been, that the rule's been invoked. If you're an expert, retained expert, it's not.
I thought the court had made a ruling as to Dr. Kirkpatrick in particular that he was going to be deemed an expert as opposed to a treating physician. But if I'm wrong, I'll tell him.
Well, I think Dr. Kirkpatrick, as a treating physician, needs to be outside. If he were to be here all day for not being called as a witness, I mean, I don't know what's going on there.
We are not calling him as a witness today. We told him that on Friday, his office. We are not releasing him from his subpoena. Depending on where the trial goes and what evidence is in, we may or may not call him.
It's fine, Pat. Doctor, you're going to have to step out. Yeah.
I want to begin today, or I guess our next issue today, since we already had a first issue, is to pick up where we were discussing at the end of the day on Friday, which I thought was a very illuminating discussion, but certainly Mr. Anderson and Mr. Hunter weren't in the room. I'm hoping each side has had an opportunity to discuss amongst the individual teams and hopefully with each other the issue that were discussed, i.e. Whether there was going to be a claim for damages associated with Munchausen by proxy from the plaintiffs, and whether the defense had some further statement or clarification as to whether it was contending or not contending that Beata Kowalski did or did not have or does not have CRPS. So who's going to lead us off in this little discussion?
Since I was on the spot on Friday, I will. We filed last night a memorandum in response. I have a paper copy here for the court.
Is this the one about basically moving to conform the pleadings if we start talking about Munchausen by proxy?
As alternative relief, yes, Your Honor. So
I have read that one.
Okay, well then, I'll be succinct. Our position is we are not currently seeking damages for the diagnosis or mere suspicion of Munchausen by proxy. We attempted to do so. That claim was brought for Beata Kowalski in our count 17 for medical malpractice. The defense filed a motion for summary judgment. They prevailed, arguing that they had made no such diagnosis. She was never a patient. Their licensure prevents them from treating or evaluating people older than 22, and that Munchausen by proxy, if it appeared in the records, was a mere suspicion. So for all those reasons, we are not and have not sought damages in this case for Munchausen by proxy. None of our psychiatric experts testified to anything relevant to Munchausen by proxy, the diagnostic criteria, anything of the sort. So we object to the admission of evidence at this point of Munchausen by proxy or documents aimed at shoring up suspicions of Munchausen by proxy. If the defense prevails on this argument, then we do move to reassert count 17 and move forward with a medical malpractice claim for Beata Kowalski.
Please, the court, I'll take these in order if you wish. The first thing I heard was a question of our position with respect to the question of whether there is CRPS here. I'll address that first. Our position is and has been that Maya Kowalski does not have CRPS, that she has a psychogenic disorder of some sort, and that is what we suspected at the time of hospitalization, and that is what we had charted throughout the hospitalization. Throughout the hospitalization, however, we never ruled out CRPS. It cannot be definitively ruled out. As a matter of fact, I'm sure you'll hear one of our experts cross-examine tomorrow with an observation in his report that while he does not believe that she had CRPS, it cannot be definitively ruled out, or at least reasonable minds can differ with respect to that. The point here is, however, and has been, that the treatment rendered for the purported CRPS was inappropriate. That was suspected at the time of hospitalization, and that is our position to this day. The point here is that this patient had a pain syndrome of some sort, and whether it was CRPS or whether she was a victim of Munchausen by proxy and or had conversion disorder or some other psychogenic pain syndrome, the point remains that the treatment for those conditions is the same. The standard of care treatment for those conditions is the same. Whether it's CRPS, a pain syndrome associated with Munchausen's, or conversion disorder, or some derivation of the two or three, the treatment is all the same. That's where we are coming from. That's where we've been. Now, as far as the Munchausen's by proxy is concerned, I would direct Your Honor's attention to what plaintiffs have indicated is the 8th amended complaint. In paragraphs 27 and 28, there is an express allegation that we were remiss in diagnosing Maya with a variety of psychiatric conditions and alleging that none of them were treated. There's also an allegation that with reference to Munchausen by proxy in that same paragraph, and another in paragraph 130. In opening statement, counsel indicated that the plaintiffs were going to prove that the allegations that Beata Kowalski was trying to harm her children, both Kyle and MK, caused her in the end to, quote, lose control of the maternal instinct and resulted in suicide, unquote. There are multiple other references in opening statement to the same type of allegation. The allegation that Beata was wrongfully accused of Munchausen's or of attempting to harm her children or taking inappropriate care of her children goes to the heart of plaintiff's allegations of intentional infliction of emotional distress. The point that is being made throughout here, we think, by the plaintiffs, is that these allegations against the defendant, are the soul of the case. They can't run from that, Your Honor. And preventing us at this point from proving up, as we intend to do today and tomorrow, that Munchausen's was a reasonable suspicion, if not the correct diagnosis, goes to the heart of the defense.
But the diagnosis goes to mom and not to Maya.
That is correct, Your Honor, but it's material to Maya for this reason. Munchausen by proxy may well be, and probably is, an adult diagnosis. It's a diagnosis of the perpetrator. But we have to treat the victim. Maya has Munchausen by proxy. The point is that she's a victim of Munchausen by proxy and or a conversion disorder that is associated with it. That was what was thought at the time. That is what we think today. The question of whether there is a diagnosis of Maya personally, her individually, with Munchausen by proxy is a red herring. The point is that syndrome, we believe there was reasonable cause to suspect and conclude existed, and that it was influencing what was happening and being exhibited in behavior by Maya. That's the point.
And what were the specific allegations in the Eighth Amendment complaint that you referenced?
In paragraph 128, let me make sure I get them all here, Chad. While Maya, under paragraph 128, while Maya was under its care, JHACH failed to develop a coherent treatment plan for Maya, with its doctors and staff consistently denying Maya's CRPS diagnosis and instead diagnosing Maya with a variety of psychiatric conditions, none of which were treated. Even when advised by pain physicians at other medical institutions that JHACH's approach and diagnosis were inconsistent and mutually exclusive, JHACH failed to correct its approach to Maya's care. In early January, as JHACH was hell-bent on painting Maya as a psychiatric patient while still maintaining to the dependency court that she was a victim of Munchausen by proxy, a physician at Kennedy Krieger grew frustrated with the management team and physicians during a call and advised that, quote, Munchausen and conversion are competing disorders and JHACH needs to pick one. That this did not occur to JHACH as they persisted in their unsound approach is a breach of the highest order. Now that,
So I asked what paragraph cite. Can you just tell me what paragraph?
I'm sorry, yes, that's paragraph 128 I just read. Sorry.
Okay, no worries. I just want to know so I can go back and read for myself.
Okay, sorry.
So just tell me
And
whatever
you might-
specific allegations that you want me to look at.
And you might also consult paragraph 129 and 130, as well as paragraph 131 and 132. Now that's in the operative Eighth Amendment complaint. If you refer to the opening statement, you will see the passage that I just referred to, as well as a number of others. We did a word search over the weekend of the plaintiff's transcripts that we have thus far. It's not all of them. We see 64 references to Munchausen's by proxy in the plaintiff's case. The idea, the central point of the overarching allegations, as I understand them to be, and as the defense has developed its case, are essentially twofold. Number one, there is an allegation that we failed to appreciate and honor, if you will, a diagnosis of CRPS that this patient had received from essentially 2, if not 3, outpatient physicians. We were alleged to have been negligent in not recognizing that diagnosis, accepting that diagnosis, and continuing the care of that diagnosis as had been outlined by Drs. Kirkpatrick, Cantu, and Hanna, which that we believed to have been destructive and dangerous. But the allegation is that we failed to proceed with treating her in accordance with that diagnosis and that treatment plan. The secondary allegation is that instead of doing that, we suspected a psychogenic component to her presentation. We suspected a psychogenic component to the way in which she was presenting her pain syndrome, as did, by our count, approximately 40 other physicians at 2 other institutions, at Lurie Children's and Tampa General, that we suspected that there was Munchausen's by proxy and or conversion disorder and or factitious disorder, depending upon which of those you subscribe to, and there's a good deal of controversy about them that Your Honor is about to hear a good bit more about. But the point is that the soul of their allegation against us is that we suspected the psychogenic constellation of presentation symptoms, and that was a deviation from the standard of care in the way we pursued that and allegedly failed to properly treat it.
Let me attempt to articulate some thoughts I had that I've been spending over the weekend trying to coalesce into something hopefully articulable. Assume for the sake of argument, mom had Munchausen or whatever of those terms you wish to apply. So just assume that to be true. Does that change anything with respect to how the hospital should be treating its patient, who is not the mom, but Maya? And I just as, let me back up. The question of whether mom has Munchausen, to me, sounds like something that would have been front and center in the dependency court on the medical neglect, medical abuse case. In the dependency court, of course, that we're not trying the Chapter 39 aspect in this case. Just like the jury knows that DCF was involved and there was a dependency court, it knows that the position of Johns Hopkins All Children's Hospital was that mom had this. But in this lawsuit, do we need to prove whether mom had it or not? And that's what I continue to struggle with, because it doesn't seem to me that it really goes to your medical malpractice case. And I was thinking over the weekend, like, well, does it go to your defense of the intentional infliction of emotional distress count? And obviously, I think the concept that you believed that to be the case, that mom did have it, I think is relevant. But at what point do we need to keep going on and on and on and trying to prove mom has Munchausen? Because even if that's true, how does that change what was done or not done to Maya in this case? Now, I think you've got some traction with me in the intentional infliction count, but what started all of this is a whole series of emails and possible blogs about what was going on with Maya that doesn't seem to have anything to do with medical malpractice, but perhaps it does with intentional infliction. That's kind of the dichotomy. So if you'd like to comment on my rumblings there, I'll give you a chance. Because ultimately I need to make decisions on admission of evidence.
I understand, Judge, and I'm kind of flabbergasted.
Can I make one comment as the person who understands the DCF part of this?
Well, once I do that, Mr. Altenburn, then I'm opening up, and I was trying to keep us more focused on proceeding forward. Mr. Hunter.
Let me start by noting that based upon Your Honor's rulings, this is not just a medical malpractice case. A lot of it is a medical malpractice case, no question. But it's a battery case, it's a false imprisonment case, it's a negligent infliction of emotional distress case, it's an intentional infliction of emotional distress case. Over and over and over again, we have heard from the plaintiffs this evidence sponsored, that evidence admitted on the basis that it went to the plaintiff's or the decedent's state of mind. The decedent's state of mind is what caused, allegedly, her to commit suicide. Her state of mind was created, allegedly, by what? By her daughter's disease? Probably. But the allegation against us is that we created her state of mind. And we created her state of mind by doing as was suggested in opening, and that is that we were suggesting that her actions and her approach to her child's disease was harming the child. We're accused, they, that includes we, and there's been confabulation about that. They, we, are accused of separating the child from the mother. Why? Because of the allegation that the mother was doing harm to her child. That allegation is based around Munchausen by proxy. The defense of this case, with all respect, Your Honor, whether it's malpractice, whether it's false imprisonment, whether it's any of these things, all of the defense of this case rests upon the proposition that the pattern and practice of therapeutic and maternal behavior here was dangerous and inappropriate to this child. And that is why reports were made. And that is why suspicions were hatched. And that is why we attempted to act as we did with respect to the discharge of the child or the lack thereof and the circumstances under which we attempted to treat her and to transfer her elsewhere for more treatment in accordance with the standard of care. But we cannot defend our case, Your Honor, without the idea being a centerpiece that it was reasonable for us to suspect that there was a Munchausen by proxy or a factitious disorder by proxy going on here, and that we were reasonable in suspecting that, and that we were reasonable in acting upon that as we did, and attempting to treat this patient as we did. That is central to the defense of the case. If you emasculate that, you've emasculated our defense. And I don't know what I can tell you beyond that. What you're going to hear today is from a witness who months before we ever saw this patient suspected the same thing. We believe that to be directly relevant to what we did, what we suspected, and how we did it. You're going to hear from our treating physician, Dr. Elliott, one of our employees, about what he encountered, how he responded, what he did. You're going to hear from an expert tomorrow that will pull all of this together, we hope. But I have to tell you, Your Honor, this is inimical and central to what they've alleged against us and to our defense against it.
Let me hear from Mr. Whitten, and I will tell you what I'm hearing about, at least with respect to the intentional infliction of emotional distress count, that there may be some need for some of the evidence that was being discussed on Friday afternoon. So, Mr. Whitney, let me hear from you, and then we'll move on.
Well, I'll start there with the intentional infliction of emotional distress. The contours of the hospital's conduct and Ms. Kowalski's conduct and what was not allowable and what was allowable with respect to her visitation or their supervision all goes to Chapter 39. So what we've brought forward on intentional infliction are things that have nothing to do with Munchausen by proxy. Catherine Beatty sitting in on phone calls. Catherine Beatty telling Jack to divorce his wife. Catherine Beatty saying that she's going to adopt Maya and be her mother. None of these things have to do with Munchausen by proxy. Listening to Mr. Hunter, the phrases that he uses give away that the Munchausen by proxy is wedded to Chapter 39 proceedings. He talks about justifying the separation. Justifying the separation is what they were doing in the dependency court. And those orders separated the mother and child, but there's no need to justify the separation unless we're going to relitigate the Chapter 39 proceeding. He talks about suspicions. He talks about reports, hotline reports. These all go straight to Chapter 39. Even the allegations he points to in our medical malpractice claim in paragraph 128, Munchausen and conversion are competing disorders. When we tried to introduce that note out of the risk management file, it was excluded because it was central to Chapter 39. In paragraph 130, the mention of Nurse Ashley stating that Maya exhibited textbook Munchausen. Yes, that's in our claim, but the court's been drawing lines, and one of the lines it's drawn is that the hotline reports are out. Nurse Ashley's characterization as textbook Munchausen is in the first or the second hotline call. That's not part of this case. Even if the defense was allowed to put in all of this evidence, they can't close the loop. They have no expert on causation. They have no expert on it. They don't have an adult psychiatrist. They would need an adult psychiatrist. There's no dispute about this. The DSM-5 says the perpetrator receives this diagnosis. It's the adult. They would need an adult psychiatrist to come in here to close the loop. The context of 64 references to Munchausen by proxy in our case. There's no specific citation, and I did not review the transcripts that they have. But the court will call the Munchausen by proxy term is what was thrown around in that transfer diagnosis to Nemours in the midst of the dependency proceeding. So I'm willing to wager that 95% plus of those references to Munchausen by proxy are specific discussions around that transfer diagnosis and the reasons that Jack and Beata declined transfer under those circumstances. Nothing about our experts getting on the stand and making arguments or opinions about whether Munchausen by proxy was or was not the appropriate diagnosis. And lastly, on the psychogenic constellation of Maya Kowalski. The psychogenic constellation of diagnoses of Maya Kowalski does not include Munchausen by proxy. It cannot. The psychogenic constellation of Maya Kowalski has to do with what their psychologist diagnosed, Dr. Katzenstein, who I think we hear from today, psychological factors affecting other medical conditions. That's the DSM-5 diagnosis of Maya Kowalski, confirming that she has CRPS, but she has a psychogenic overlay on that. The other diagnoses they entertained for Maya Kowalski in this psychogenic constellation are factitious disorder, not factitious disorder imposed on another, but factitious disorder of Maya Kowalski, and conversion disorder. So there are at least 3 diagnoses of Maya Kowalski that they threw around that compose this psychogenic constellation. None of them are Munchausen by proxy. They go specifically to Beata. So again, if Mr. Hunter's argument persuades this court, we move to reassert count 17, because now they're claiming they did make a diagnosis of Munchausen by proxy. They want to argue all about it, and so we want Beata Kowalski's medical malpractice claim back.
One other point.
Are there other issues, because it's getting close to 9 o'clock, other issues that we have to address before we bring in this jury?
I don't believe so, Judge. I just point out that as counsel just made reference to, an inimical point of the false imprisonment claim is the fact that there was a transfer offered, there was a transfer that was put together, you're going to hear more about it tomorrow morning, and it was refused. Why was it refused? Because of that diagnosis. Because of the because to almost directly quote, we would be admitting to Munchausen by proxy to child abuse if we signed off on those transfer papers. They put this in the case from day one, Judge, and they can't run from it now.
But okay, how does you proving that Maya did or did not have it change Beata's state of mind as to her decision not to sign the transfers concerning or when there was any sort of possible reference. And I think, though, that came later as opposed to the October date.
Yes. Correct.
So, let's try not to conflate those. I'm having enough trouble keeping those two apart in my mind myself. But, I feel like I've clipped the plaintiff's wings very hard on trying to keep Chapter 39 out. And it just seems that now that I've done that, the defense wants to make this case in trying to prove that Beata had Munchausen, which seems to be the heart of what was going to be in the dependency court, which is what I was not letting in the plaintiff's case in chief.
With all respect, Your Honor, you have ruled on the Chapter 39, and to be honest with you, I have yet to understand where the dividing line is on this. But what I do know is this. What I do know is that the remaining case against us, whether it's the false imprisonment or the intentional infliction or the negligent infliction of the malpractice, is all bound up in in what we suspected and what we did and how we ruled on it, and the impact of that on Mrs. Kowalski's state of mind and on her conduct. And that's, I mean, if Your Honor tries to carve that out of this case, it eviscerates a major portion of the defense and puts us in a completely untenable position. I would suggest to the court that Mr. Whitney's argument is for the jury. It's not for admissibility. And I would urge Your Honor to let this go forward and let us try our case.
Are there other issues that we have to address prior to the jury coming in?
Well, Judge, the first witness is on this issue.
On Beata's, whether she has...
No, Judge, the first witness is Dr. Elvin Mendez of Fort Myers. Dr. Mendez saw this patient in October of 2015 and December of 2015. He was consulted regarding immunotherapy, and after 2 visits with this patient, he indicated in one of his conclusions that Munchausen by proxy should be considered, and he advised Dr. Wasenauer of that fact in a copy of a letter to him. The point of his testimony is exactly this, and the point of his testimony is, frankly, a point I thought I tried to make an opening, and that is that we stumbled upon this trail and followed it. It was not a new trail.
Mr. Altenberg.
2 completely unrelated things. I'm only here for a little while, hopefully, to find out, A, if you've looked at the instruction that you're contemplating on the visitation at all, because Mr. Elegant and I need to kind of get closure on that, because by Wednesday we really need to have had that instruction read. The other thing I was waiting to see was how many counts were going to be gone or not on directed verdict, so I can finish the jury instructions.
Well, I don't have time to address that right now. Hopefully, after lunch, we can close the loop on some or all of the DV motions. So I don't know if you want to hang out until after lunch to see
I've
if
got a room I can type in all morning long. So.
And Mr. Whitney, anything else?
Well, 2 things. On Beata's state of mind and the relevance, the state of mind of Beata Kowalski that's at issue in this case is the irresistible impulse, effectively. And I would point the court back to their motion for summary judgment, again on count 17 at DIN 1933, in which they made a big point of pointing out that she was admitted to Sarasota Memorial Hospital the day of the dependency proceeding when she fainted in court, and that at that time she denied ideation, and that as of that date she did not have ideation. So her state of mind deteriorated over those next 3 months, irrelevant and irrespective of what Dr. Mendez may have thought in October of 2015. I think we need to argue this Dr. Mendez issue.
Well, I think with Dr. Mendez, I'm going to be consistent with what I did with the prior treaters that saw Maya prior to the admission to Johns Hopkins All Children's Hospital and kind of let that type of testimony in, because it does set the stage as to how Maya presented at Johns Hopkins All Children's Hospital in October of 2016. So I think the historical stuff, at least I'm going to continue to rule like I did with the Lurie's doctor and the Tampa General Hospital doctor. I'm just going to stay consistent. If I'm going to change how I'm doing something, I'll let you know. But for now, I'm going to remain consistent as to how I ruled with respect to those 2 hospital visits.
May I make a record on that?
Sure.
Well, we believe, again, this is Chapter 39, issue 403, and irrelevant to the claims in this case. I'll point out again, at the time Beata Kowalski was hospitalized at Johns Hopkins All Children's Hospital during the false imprisonment first week, they did not have any knowledge of Dr. Mendez's records.
I don't think it's going to false imprisonment. I mean, I know it's been banning about, but I don't see how it goes to false imprisonment. I am, frankly, the only place it really seems that it possibly fits is the intentional infliction count. I still don't understand how it would fit with medical malpractice with respect to Maya.
All right.
But, I mean, I do think, and I do have some belief it does go to the defense of your IIED count.
Understood. We disagree, but we understand.
Okay. So are we ready to bring in the jury? Let's bring in the jury. Good morning.
All rise. Jurors entering.
Okay, welcome everybody. How are we doing on a Monday morning? Great. Glad to hear it. And were the best birthday festivities fun?
Yes. Thank you.
I want to confirm, while you were away over the weekend, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct?
Correct.
And since you were last with us, has anyone seen any news accounts of this proceeding? And has anyone approached you about this case since we were last together? Mr. Hunter, your next witness, please.
Okay, please score with the honor. The defense calls Dr. Elvin Mendez.
Face the clerk and raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do. Right this way, sir. See that witness standing over there.
Good morning.
Good morning.
Would you tell us your name, please?
Elvin Mendez.
And what is your occupation, Doc?
I'm currently a physician with Lee Health in Lee County and Charlotte County.
Okay. And where is your practice?
We have 2 locations, one in the Port Charlotte area and a second in Cape Coral.
Okay. And what is your specialty, sir?
Allergy immunology.
Would you give the jury the benefit of your background and training and education starting with undergraduate school?
I trained as they call a foreign medical graduate, so we do undergrad and med school in one 7.5 year stretch. So this was done in the Dominican Republic. I came to the U.S. Trained in pediatrics in Long Island, and then moved on to Einstein and did allergy immunology. After that, I joined private practice for 4 years, joined the non-for-profit for another 4, and then we headed south to Fort Myers. We've been in Fort Myers now, Charlotte County for about 21 years now, and joined Lee Health in 2015.
And I'm sorry, Dr. Amos, where did you do your residency?
In Albert Einstein College of Medicine, New York.
In New York City?
Yes, sir.
Okay.
I'm sorry, that was my fellowship. My residency was done at Nassau University Medical Center in Long Island, New York.
So you did both your residency and your fellowship training in New York
New
City?
York, yes.
Okay, in Greater New York. And what are you board certified in, sir?
I was board certified in both allergy immunology and pediatrics. After years of allergy immunology, I decided to give up my board certification in pediatrics. For no particular reason, I just continued doing allergy immunology through the last 20 years.
Okay. And could you tell us what allergy and immunology entails?
Okay, so from an allergy standpoint, it's we deal with a variety of different organ systems that have an allergic or immune mechanism involved. So, for example, make it easier, head to toe, sinus disease, nasal symptoms, sneezing, congestion. That's the one that we see most commonly in the offices. We also deal with skin disorders, but they have to be specific allergic skin disorders. From the lower airways, in other words, further down, then we deal with asthma and asthma-like symptoms. There are some occupational lung diseases that we may deal with when they're exposed to certain chemicals. And certainly there are other organs that are involved specifically with allergy, for example, GI or gastrointestinal system. There's a variety of not only food allergies, but also diseases that are associated with that. That's the bulk of the allergic side. The immunologic side is a little more complex. There are mechanisms that we deal with that encompass both the allergic and immune world. It's not just immune deficiencies. There are a lot of overlaps with rheumatology, so there's some autoimmunity that we may deal with. Certainly, it gets to a point where we then end up referring to rheumatology. So immunologically, it's predominantly immune deficiencies that we deal with in pediatric and adults. Bless you, sir. And from a allergic standpoint, there's often an overlap between one and the other, because some individuals with immune problems may present with what appear to be allergic problems. Okay. But it's one same field.
Okay. And does it also deal with immunodeficiencies?
Yes, sir.
Okay. Has there come a point in your practice with Lee Memorial Health System that you became involved with the care of Beata Kowalski?
Yes, sir.
Okay. And when did that take place, sir?
I saw her twice. The first time was in October 28th, 2015.
Okay. And do you have your notes with you, sir?
It's in my head. Yes.
Okay.
Yes, sir.
Okay. Well, if for the record, that is Defense Exhibit 3031, and it starts with 002. So if you want to put that up, I believe that's in evidence. And if you need to refer to that to your records, if you'll let us know, we can scroll down through.
Absolutely.
But for now, could you tell the jury how it was that the Kowalskis came to see you in your practice?
The original visit on the schedule was for a second opinion for immune deficiency.
Okay.
Do you want me to dwell on that, or?
Yes, sir.
Okay. So, so this is my. Just looking for a date here because we saw her twice. So this was our first visit, and there was a different reason for the second visit, and we'll get to that later, I'm assuming. But for the first visit, it was on schedule as a second opinion for immunodeficiency.
Okay. And what was your understanding of where the patient had already been with respect to immune deficiency questions?
I'm sorry, could you elaborate on that question? More specific.
Well, you were asked for a second opinion, and I'm trying to find out who the first opinion was, I guess.
So when you call our offices, we're going to want to know why you want to see us. Someone offered that information to our staff. That's all that was on our schedule. It actually says second opinion for immunodeficiency. Okay. The idea is that they're coming to see me because they are perceiving they may have a problem with immunity.
Okay. So when did you take a history from this patient, and was she accompanied by her mother?
I'm sorry, was
she accompanied by her mother?
Yes, just her and her mother, yes.
Okay. And did you take a history from her?
Yes, sir.
Okay, and what did you find out from the history?
Overall,
Yes.
complex. There were a lot of things going on.
Okay. Generally speaking, what history did you get from them?
You want me to be specific, sir?
Yes, sir.
Okay, so we cover quite a bit. Just because someone comes in with a concern about immunodeficiency, there's a lot of questions I ask because, like I said earlier, immunology and allergy do kind of overlap. So you'll see in the notes, or perhaps I don't know if it's been discussed before, that there are questions that don't seem to even correlate with what they originally came in for. But there are reasons why we do that. So to answer your question, we covered quite a bit of organ systems. So that's a review system we do and we cover. And if there's anything striking within that review system, we will dwell on that particular problem. So she did all the talking. She was a great historian, I gotta say. She was very bright. So it was easy. I hate to tell you, an immunologist is not an easy thing, but she was really good. So I was able to obtain the history on her part with regards to, because I did ask why a second opinion. And she said she wanted information on her daughter's immunodeficiency. Unfortunately, I had nothing at the time, just her history. So I had to request records.
And did you conduct an examination of the patient that day?
Yes, sir.
And what did you find, if anything?
So two things. The first thing that was striking was that she appeared to be in pain and a lot of discomfort. She was wheelchair bound, by the way, in my office. And I remember her very well because she was sitting literally next to me. And the mother was just facing me here. And she appeared to be in pain. And the only way I can say this is because she was kind of moving around on the wheelchair and some sounds were made as if she's in pain. So, but I was able to examine her. I did not elicit additional pain. I do recall that because I'm very cautious about pain. But I did not perceive or rather induce any additional discomfort during the examination.
Okay. Did you find out in the course of all this what other immunologists or allergists she had seen?
Yes. So at some point during the history taking, it appeared that she had already seen actually 2 additional allergists.
Okay. And did you get any understanding of why it was or how it was she had come to see you?
No, sir. Her answer to me, and again, this is recollection from my notes, not recollections that because this was about 8 years ago, was that she was just seeking an answer to her daughter's immunodeficiency.
Okay. So at the end, well, did your examination include an examination of the skin?
Yes, sir.
Did you find anything unusual or untoward?
No, sir. That I can recollect, no.
Okay. And what, at the end of your first consultation with this patient in October of 2015, what was your plan? What was the follow-up, if anything?
Several things, because there was a lot. It wasn't just immune concerns, so obviously I needed those records from the other allergists she had seen before. There was also so when we look at an immune deficiency, we want to determine if we can figure out what the cause is. You know, is this something that she's had since she was born? Is this something that she has acquired since she was born? So we need to inquire about things that may induce what we call a secondary immune deficiency. So other medications that she's been on. So we requested records from other physicians that had seen her at the time. So I have a sense of whether this was induced by other things that may have been given to her. What was striking in her history is that she had been through numerous ER visits, numerous physician visits, and a lot of steroids. And that's, you know, to an immunologist, that's striking because steroids are a double-edged sword. They solve a lot of problems, but they also can induce a lot of problems. So I wanted to make sure that this wasn't secondary to medications. So to answer your question, it wasn't just focusing on immunity and getting records from the allergies she had seen in the past, but also perhaps some of the other areas that she visited that may provide me some information and some insight, especially lab work.
Okay. Now, when you took a history from this patient, did you get any indication that she had been in Tampa General Hospital for about 4 weeks?
No, sir.
Did you get any indication that she had been seen and worked up at Lurie Children's Hospital in Chicago?
So that's a tough question. So yes, and we talk referring to prior to moving to the state of Florida or after?
After.
No, I was not aware of that.
When did you see this patient in follow-up?
It was the second week of December of 2015. Actually, it was on her birthday,
Okay. And I believe that's Defense
December
Exhibit
10th.
3031-007, not the James Bond, but the page number. If you need to look at your note, Doctor, I believe you'll see it there.
Yeah. Okay.
When you saw her in follow-up in December, what additional history did you get at that time?
So the first part of the that page just gives you kind of a summary. I tend to do that for providers that might want access to the notes. So I kind of just summarize what has transpired in the initial visit, and then I move on to anything that's new since we've last seen them. At that point, we did have records received because we had requested several, and I believe it was at that time that I may have received notice between the first allergist she saw and the second visit to the first allergist, which was Dr. Wyndham. There was a lot that went on in that period of time. And someone wrote a note that she had been to Lurie Children's for another opinion. I think it had to do with her cortisol level. So there was some concern that there may have been adrenal suppression. When you go on high-dose steroids for extended periods of time, you will literally suppress your adrenal gland. Your natural cortisol is produced by an organ within your gut cavity. The brain sends signals to that cavity, to that organ, to tell it produce more, produce less. But if you give it outside long enough, it'll stop sending that signal. The problem with that is if you stop administering that steroid, you'll go into adrenal shock. So it's a dangerous situation to be in. So I'm assuming that they were seeking a second opinion at Lurie Children's because that was the hospital when she was a child and growing up in Chicago. But I'm not sure if that was true because I don't have any records of that.
Okay, so you never saw any records from Lurie Children's?
Just mentioned on one of the notes.
And you were never told what the discharge diagnosis from Lurie Children's was?
No, sir.
Okay. And I'm assuming you were never told what the discharge diagnosis from Tampa General was?
From?
Tampa General.
I wasn't aware of the Tampa General. I'm sorry, let me correct myself. All I heard was that she had undergone rehabilitation at Tampa General.
Okay, and were you aware of the discharge diagnosis?
No, sir. I just was told there was rehabilitation at Tampa General, and it had something to do with her cortisol level.
Okay. When you saw her on this day in follow-up, did you do an examination at that time?
Yes, sir.
And what did your examination reveal?
Completely normal physical examination.
Okay. Did you note any color changes or rashes on the skin?
No, sir.
And did you get any history of any episodes of dizziness or weakness or lightheadedness with the patient?
The second visit, I don't recall that coming up as a part of the history. The first, there was a persistent headache throughout the visit, on the first visit, and I believe there was also dizziness described.
Okay. Now, did after you had conducted your examination and your history and physical, and you looked at some records, I'm assuming, from her past care, did you arrive at any opinions or conclusions regarding her immune status?
First or second visit?
Second visit.
Okay. Yes, sir.
And what was that?
That she... May I explain?
Yes, sir. Yeah, you're the only one who can.
Okay. So...
Objection to narrative response.
Overruled.
There are numbers that we follow in any lab work that you have done. I'm sure some of us have had those done, and there are some values that are considered above normal or below normal, and the lab does that. It gives you a certain range. So if you go to one lab, you're going to get one range. You go to another lab, you get another range, and typically we follow that as a tool. It helps guide us to determine whether it's a problem with your liver, spleen, or an immune problem. with immune deficiencies, there are international standards that we follow or try to follow. There are also some national standards that we follow. The numbers, when you look at a lab, may appear to be grossly abnormal. Okay, so you'll have I'm just going to make a number up for y'all folks. Let's say, the normal for a 9-year-old of an immunoglobulin G should be, according to the lab, 600 to 1200. That's what they'll put on as a normal. 600, low, 1200. Now she's at 550. Is that considered abnormal? Okay, so that's the question that you ask the immunologist. My short answer is it's not abnormal. And the reason for that is because there's very specific criteria that we have to follow to determine whether an individual has a deficiency or not. And if I may, just briefly to the jury.
And while you're doing that, I'm going to ask that 3031-009 be put up. That's where your lab values are, in case you need to refer to those.
Okay, so
down at the bottom.
Right, I see that. Okay, so I want you to see that there were two numbers that were given to us. And the reason two numbers during the same lab draw are different is lab. So one lab, the same lab did the total IgG, the immunoglobulin G, the total, and then something called subclasses. So total IgG is broken down into 4 components, and they're numbered 1, 2, 3, 4. Okay? So one set of numbers gives you a low total with a low IgG 1 and 2. That was the subclasses that were done. On the other hand, the doctor also ordered separately a total IgG. Now we have 2 discrepant numbers. One same draw, same person. So we have a 575 on one number, and we have a 603. I see those numbers and they're staggering because there's a significant difference between one and the other. One of them appears to be not grossly abnormal, but just decreased, and the other one appears normal. So just for the record, these 2 numbers are normal for an immunologist. But so criteria number 1 is you take that, you measure that value. You want that immunoglobulin G. Yes, you can order the subclass because oftentimes one of them will drag the total down, right? Because the top is the sum of all the little ones. But the general consensus, and these are international Immunology Society regulated rules.
Sustained.
They have to repeat it again.
Hold on a second. Let Mr. Hunter ask another question.
You can't make reference to outside sources.
I'm sorry. Apologize.
So if you just tell the jury what these labs meant based on your experience and training.
Sure. So based on my experience, a single digit is just a reason for me to wait, based on current standards, a minimum of 2 to 3 months and repeat them again. Because standards are, there has to be a minimum of 2 separate draws with a minimum of 2 to 3 months between each. But that's just one of 3 criteria.
Okay. So at the close of all this, and your second visit with this patient, and the labs and records and so forth that you had the opportunity to review, did you arrive at any opinion or conclusion that you were able to share with the patient and her mother regarding whether or not she had an immunodeficiency?
I was, yes, sir.
And what was that opinion?
My opinion was that either Maya had something we call transient hypogammaglobulinemia of infancy and childhood, which is a transient type of deficiency we see, and it normalizes over time, or that she did not. Personally, with a normal immune response to the vaccines that she had and the rest of her lab work, to me, she was normal. She had no other immunodeficiencies. Typically, you have other immunoglobulins that are reduced. You don't have an adequate vaccine response. Those are the other 2 criteria that are required for you to be diagnosed as a immune deficient. So I explained this to her at that visit.
And to state that a different way, did you determine that she had any immunodeficiency that required follow-up treatment?
No, sir.
Okay. Did you arrive at any other opinions or conclusions regarding her condition and matters that should be addressed in her care?
Yes, sir.
And what were those?
Okay, so the first is, we'll start from Morgan Systems. The first is this asthma history. We deal with asthma. That's part of our training as well. We rely on tools to help us make a determination whether someone has a disease or not. We do that with every disease. The reason why we rely on tools is because we have to have not only the history provided by a parent or a child, but also we need to have some objective measures. You have to always have something to help you guide you and determine whether there's a disease there, because there's a lot of mimickers of asthma, lots of them, and nothing added up here. Pulmonary function tests were normal. I was only unfortunately able to see one, that Dr. Kreisman, who's a pulmonologist, or I'm not sure if he's still at All Children's, put on in the records. And there's also mentions of normal pulmonary function testing throughout the visits. So from a respiratory standpoint, unfortunately, I could not make an intelligent decision that she actually had asthma. That's the first thing. With regards to the allergies, yes, Maya had allergies based on skin testing performed by an allergist, but to me that was secondary. At the time, I think we were dealing with much bigger medical problems that I think needed to prioritize over allergies.
Okay.
And then the last item, with the concern about the chronic the CRSP, is that I'm not a neurologist. She talked about RSD. She talked about a lot of problems, neurological problems that might be wrong with Maya. I specifically told her that was way outside of my wheelhouse, and I'm out of my lane, and I'm not an expert on that, and she'd have to talk to her primary care or neurologist about that.
Okay. Were you aware that her primary physician was Dr. Wasnauer?
So I only was aware of Dr. Wasnauer because his name comes up. Our records, we provide all primary doctors with notes. Whether you refer them to us or not, as a courtesy, every primary doc gets a letter. Sometimes the patients will not provide us that name, so it's just left blank. But as a general rule, they do give us the name, and we provide them with a letter. So that's the only knowledge I have of him, because he did get my letters. We did request records from him and never received.
Okay. And did you send him any information about your consultations with this patient?
Every visit, yes, and in our assessment, yes.
Were there any other considerations that you called to his attention?
Yes, sir.
And what was that?
So physicians are trained to be alert on anything that might be of, should we say, harm to a child. Right? Any risk, any concerns that may come up during a visit. It could be a variety of different things. The one item that was of concern at the time because of some events, some things that I saw during the office visit with her, from my reading of the documents I received prior to her second visit, I can only use the word did not add up. And so my concern was that this might be fictitious and not true events that were occurring. Either way, I wanted the primary doctor to dwell further and see if there is a neurological problem with her or not. I was basically telling him, hey, you need to find out if this is true or not, because this is harmful for her. She's wheelchair bound. She's in pain in my office, and that's the last I've heard of the Kozlowskis.
And so, what specifically did you call to Dr. Wasnauer's attention in that regard?
I'm sorry.
What specifically did you call to Dr. Wasnauer's attention in that regard?
So I was concerned about Munchausen by proxy at the time.
Okay, and why was that?
Because the symptoms, the physical examination, the objective tests that I review in medical records did not correlate with the story I was getting from mom.
In what respect? Can you be more specific?
So there was a constant. The first is the numerous lower respiratory complaints, the asthma picture, the severe asthma. And that was used a lot in a lot of the notes. Severe asthma, severe asthma, severe asthma. Like I said, in my experience, we have someone with severe asthma admitted to a hospital for a few days and comes out with normal breathing tests, completely normal spirometry. The lung doesn't work that way. I'm just being honest with you. When you get to a severe case, there are maybe some changes that take place within lung tissue. Your lungs will start over time sort of scarring within the bronchial tubes, That's why individuals that are not treated early on adequately will get worse over time. You can improve their ability to breathe with medications, but the breathing test was always going to show you some degree of changes in the lungs. There's always going to be there. I looked at the PFTs, the doctor from Old Children's, Dr. Kreisman, provided in his notes, and they were completely normal. So, and that was just one event. There were other severe asthma, and the most striking and most concerning was the numerous steroids utilized, both inhaled, oral, and in injectable forms in various ER visits, clinic visits, provider. And in fact, she actually had access to, I believe, to steroids at home that she could provide her at will.
Motion strike.
Okay, members of the jury, you are to disregard the last comment about home steroids. Mr. Hunter, you may continue.
Doctor, have we ever met?
I'm sorry?
Have we ever met? You and I ever met?
No, sir.
Have we ever spoken?
No, sir.
Your witness.
You gave a deposition in this case, you recall?
Yes, sir.
Right. And I guess I couldn't help but notice how emphatic you were here in front of the jury. You wanted to really convince the jury of what you were saying, right?
I'm sorry. Can you ask that question again, please?
Yes. I noticed you were quite emphatic. You were trying to convince the jury of things you were saying, were you not?
That's not correct, sir.
All right.
I'm going to sustain the objection.
After the deposition, when the different lawyers were still on the line for ordering the deposition transcript, I want you to tell the jury whether you had a discussion with one of those lawyers in which you said words to the effect of, "I did my very best for you. I hope I helped." Did you say that to him?
No, sir.
Objection, Your Honor. Proper impeachment.
I'm going to sustain the improper impeachment objection, but you can continue along this line if you want.
Did you, I'm just simply asking you, sir, did you have a discussion with the defense counsel at the conclusion of the deposition while the lawyers were talking about ordering the depositions where you said words to the effect of, "I hope I helped you, I did my best to help you," or words to that effect?
Objection, Your Honor. May we approach and maybe show the witness what he's...
I do not recollect those comments.
The answer is we don't need to approach on that. Overruled the objection.
And you are aware, are you not, that...
He said he didn't recollect, so are you going to refresh his recollection, or are you moving on?
I have other evidence that will be as part of our rebuttal.
All right.
Witnesses. And you are aware that Munchausen by proxy, that reflex sympathetic dystrophy, and you know that's also known as CRPS, right?
Mm-hmm.
You're aware of that?
Yes, sir.
And you are aware that it is often misdiagnosed as a psychiatric condition, particularly in children, right? Are you aware of that?
So I understand the question correctly. You're asking me if I'm aware that CRPS is often misdiagnosed as a psychiatric condition. Is that the question?
Especially in children.
And my short answer is no, because you mentioned the word often. and I'm not sure that that's accurate.
All right, well, certainly then you do keep up with the laws that come into effect regarding, I'm going to have to approach before I finish this question.
You may continue, Mr. Anderson.
But you are aware that Munchausen by proxy and other psychosomatic, that CRPS is often mistaken as a psychosomatic condition, a psychiatric condition.
So again, I respectfully disagree with the often confused with, and I'm not sure it's often.
Okay. Well, you are suggesting that you saw signs of Munchausen by proxy. Is that right?
What I said earlier was that I saw signs of symptoms that did not correlate with the treatment plans that have been provided in the past.
All right. And where did you get that information from?
From the records that were reviewed by that were sent to me by other physicians that had seen her.
Including Dr. Kreisman?
Yes, sir.
And Dr. Kreisman, I assume you determined, was the primary prescriber of the steroids?
I disagree with that comment as well. I'm not sure he's the primary prescriber. I just know he's one of the treating physicians.
Well, was he a prescriber of the steroids or not?
On the notes that I read, I do not recollect that, no, sir.
Okay. Now, if you needed to know about whether a child had asthma, actually witnessing it would be a good idea, right?
No, sir.
You don't need to witness the actual cough to know whether or not a child may have asthma?
There's a lot of other causes of cough, sir, that are not necessarily asthma.
Mm-hmm. So if I were to show you an actual cough of the child, would that allow you to see whether or not this child had asthma?
Would not, even if you showed it to me.
Okay. So would a diligent parent seeing a very disturbing cough be doing the right thing to bring it to the attention of a physician?
I totally agree, yes, sir.
Overruled on that one.
And then, if we could, with the courts, it's in evidence, show Exhibit 2616.
If it's in evidence, yes.
Get your neck flat, please.
While you're finding it there. Okay.
Be strong.
Now, with a 9-year-old girl exhibiting a cough like that, you would agree that it would be reasonable for a parent to want to search for any possible causes, would you not?
Yes, sir.
So, Beata Kowalski, by trying to find the solution, if you will, that is the correct diagnosis and treatment, that would not be unusual, would it?
I'm sorry, can you repeat the question again?
Beata Kowalski, as a parent, hearing a child with that level of coughing, it would not be outside the bounds of normal parental behavior to try to find out the source of that cough, true?
Would not be, no.
And it would not be beyond the bounds of normal parental behavior to try to find a treatment for that cough, would it?
You're talking about professional treatment? No, not at all.
And so, in going after and trying to find this out, she would not be doing anything that you felt was inappropriate, right?
At this point, from the way that I heard that cough, I'm moving forward? No.
All right. Okay. So, what is certainly you've talked about here and felt strongly enough, I guess, to write a letter. But by the way, did you ever talk to Dr. Kreisman about your concerns that this might all be psychosomatic?
He's not the primary physician.
Did you ever talk to Dr. Wasserman?
I sent him a letter twice explaining that.
Well,
the first, second time, rather.
If you were really, and so you didn't get a response, right?
Did not, no, sir.
All right. And you never called anyone from the state, did you?
just because I suspected, with the information I had, I personally at the time I did not feel I had to report it. I wanted the primary to be aware of it.
My question then is, did you call the primary care physician and have a discussion with him?
No, sir, that's not customary of me. Not in that situation.
I thought you testified on direct that it was customary, that you would contact.
I specifically said, if we go back to what I said, is that every physician, primary care physician, receives correspondence from me on every visit that I see in my office. The only exceptions are when a patient does not, or parent does not give us the name of the primary care physician.
Tell us then what the facts there that you took from the history with Beata Kowalski that were significant to you, that she uttered to you there, either visit.
So I want you to explain to me what you mean by facts, sir.
Well, what were the key facts in the history that you found pertinent to trying to come to some conclusions, including this one?
That she has, her daughter has always been ill, that her daughter has been in pain from some neurological problem, that she has severe asthma, that she has an immune deficiency, and what else? And that she has allergies.
All right. And so, allergies. All right. And first, with allergies, did it come to your attention that other physicians had diagnosed her with allergies?
That is correct, yes, sir.
Did it come to your attention that other physicians had diagnosed her with asthma?
I did not have evidence to substantiate that.
Subsequently, did you obtain evidence of that?
I obtained evidence that did not show that she had asthma.
Did you ever talk to any of the physicians at Johns Hopkins All Children's Hospital to see whether asthma was listed as one of her illnesses?
My role in all this is to determine whether Maya at the time was immune deficiency. The rest of the information available in history taking is to determine whether there's some correlation between diseases and her apparent immune deficiency. So the answer is no. We do not proceed with any other disorder that I might encounter during my history taking. That is passed down to the primary care physician in writing.
I understand. And then she told you the child had pain, correct?
Pain and cramping on the legs, I believe it was.
And you said you inspected her. Counsel asked you about her skin. Did you look at her lower back?
No, sir.
Did you look at the inside of her thighs?
No, sir.
Did you look on the inside of her ankles?
Yes, sir.
Did you look then on her neck or upper back?
No, sir.
The inside of her arms?
Anything that was visible during office visit is what we usually put down. I'm not a dermatologist. My role is strictly what I can see. I'm not going to address a patient and do a full physical. That's out of my scope of my job.
So whether she had CRPS lesions at that time or not, you would not be in a position to state. True?
I'm sorry, whether she has...
CRPS lesions, you would not be in a position to state.
I am not familiar with CRPS lesions.
All right. And so then what was the final one there? The daughter had been sick, right?
Correct.
And you knew that the daughter had been taken, among others, to Johns Hopkins All Children's Hospital for various emergency room visits, correct?
I do not have that information, no.
Right. So, out of all of these, can you tell us now, do you know what DSM-5 is?
That's the most recent DSM, yes.
And what is DSM?
So the American Psychiatric Association has a manual, so to speak, that provides you with diagnosis code of various behavioral and psychiatric diagnoses.
Yeah.
They're up to the 5th edition.
All right. But what does DSM-MD stand for?
Oh, if I can recollect, again, I'm not a psychiatrist. It stands for, oh my goodness, and I don't recall off the top of my head. I apologize.
All right. So having been raised concerns about this, tell us which of the 4 factors you focused on to come to the conclusion that Munchausen syndrome by proxy must be suspect.
Objection, proper impeachment, Your Honor.
Overruled. You can answer.
So which of the above is what you're telling me that I derived on? Obviously, the main reason for the visit was...
Maybe I misstated. I'd like to know under the DSM-5 categories, the 4 primary categories for diagnosing Munchausen by proxy, or now factitious disorder on another.
Your Honor,
Which
objection.
ones did you focus on?
One,
Your Honor.
And which one was that?
where there's no correlation between the symptoms and signs presented by the parent and the objective findings that you may have, whether it's radiology or lab work or whatever objective labs or procedures you have available.
The parent told you the child was ill, correct?
That's correct.
The child was moaning.
I'm sorry, the child was?
Moaning.
That's correct.
You had confirmed with other physicians that there are allergies.
What does moaning and pain have to do with allergies? I'm sorry, I lost that.
All right. Well, I'm just trying to find out which of these 4 now, we're talking about the DSM categories, which of these 4 are you saying that Beata Kowalski lied to you about?
So if you all read my notes, both notes, and I have to expand on this, Your Honor, if you don't mind.
Go ahead and answer the question.
To answer the question, I have to explain. See, he's looking at a very narrowed comment. You have to look at the whole visit. There was a change from moaning and discomfort on the first visit to normalcy, which I thought was striking. The first time I get it, there was something wrong with it. That's why we requested records. The second time, it was complete opposite behaviors. Wheelchair bound, on a laptop, very happy, very distracted with whatever she was doing at the time. And I remember specifically, this is where it hit me, when I talked about how the workup that I had done did not prove immunodeficiency, and I wasn't aware of how I could explain everything else going on, and then she went into this phase of crying, and my ear hurt, and I have a headache. So after that was over, and I tried to find out what was wrong with her, and I tried to ask Mom, "Are you okay?" Then when the visit was over, as she's wheeled out to the waiting area, everything normal again. So you asked me about that narrow comment you made. I'm looking at a whole picture that led me to believe there's something not right about this. That's all.
Well, tell me then what the primary symptom then is under DSM-5. Strike it. Do you have any information whatsoever that Beata Kowalski falsified any fact?
I'm sorry. Okay, let me reframe that question. So you're asking me if I'm
simply
aware
asking you,
that Mrs. Kowalski
Sir,
lied about...
Doctor, what I'm asking you is whether you have any direct evidence that Beata Kowalski, based on your 2 visits with her, falsified to you any fact.
No, sir.
And can you remember whether the first element of Munchausen by proxy leads off with falsification of physical or psychological signs?
Objection,
Do you
Your Honor.
remember that off?
For use of an authoritative source.
Would,
I'm going to sustain that one.
would it refresh your recollection to show you the DSM-5 in that regard?
So you're giving me one of
Objection,
4.
Your Honor.
So just to...
Why don't, hold on, before you answer, why don't you all approach?
First, do you recognize the Diagnostic and Statistical Manual of Mental Disorders, DSM-5, as authoritative on Munchausen by proxy, now known as factitious disorder imposed on another?
I believe that the term utilized now is known as medical child abuse, that it's not fictitious. So I believe the more recent diagnosis is different. But I'm not familiar with the manual as it is outside of the scope of my practice.
So you, all right. So whether I showed this to you or not, you wouldn't know what the elements were.
You can tell me what the elements are, but it's beyond the scope. All I can tell you is we are trained, if we see anything that we may perceive as harmful to a child, that we have an obligation to pass out that information to someone. And my first person was to the primary care physician, who knows that patient more than anyone else.
Would you like to see, would it refresh your recollection to see the very first words on the diagnosis of a factitious disorder imposed on another?
Objection, proper foundation.
I do not feel that just looking at one item of 4 is going to help us change our gut instinct of us feeling that you may have in a child in your office that you feel might have been in danger. And I'm being honest.
Mr. Hunter? Members of the jury, any questions? Okay, given the number of notes being submitted, once all the notes are collected, I'm going to ask you to go back to the room. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All rise. Jurors exiting.
Jury's out of our presence. Dr. Mendez, I need you to step outside. Thanks. Let's get Dr. Mendez as well while we're working at it.
All rise. Jurors entering.
Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation, received no information. Is that all correct? Correct. And none of you saw any media accounts about this case since you were last with us? And no one approached you, is that correct? Correct. And just to remind you, I did discuss these questions with the lawyers outside the presence of the witness. Doctor, the jury has several questions for you. Did the doctors at All Children's Hospital think that Maya had asthma and treat her with it?
Are we referring to the pulmonologist, Dr. Kreisman?
Do the best you can to answer the question.
So I don't have records from All Children's Hospital. I want to be clear. The only records I received was from Dr. Kreisman from the visit after she was discharged from the hospital. And then the question is, do I have evidence that she had asthma?
And did the doctors at Johns Hopkins All Children's Hospital think that Maya had asthma and treat her with it?
So based on the records, there's a normal spirometry, meaning breathing, the pulmonary function test was normal, but he had advised to continue on a inhaler that was prescribed in a course of tapering corticosteroids.
Before you saw Maya, did you know what CRPS was and how it affects people?
It's a great question. To some degree, I have a lot of veterans in my practice. I see adults and pediatrics. That's the treating we have. It's not just pediatrics. So we would have folks that come in with some complex pains that I would hear from the VA notes of the possibility that they may have CRPS. But I wasn't familiar with the disease. I just know they complain about kind of phantom pains and burning sensation on skin. That's my only recollection of that disease.
Did you notice any signs or lab numbers that showed Maya was getting ketamine treatments?
That's a great question. So let me try to explain So I wasn't aware she was receiving ketamine treatments until the second visit. Was there anything that I would expect? I have no idea. I'm not familiar with ketamine treatments in the U.S. to begin with. I was surprised that she had gone to Mexico to have that done. So my short answer is no. I'm not aware of any abnormal labs that might be linked to some treatment she received outside of the country.
Did you ask or know why Maya was in a wheelchair?
Yes, sir. We did on the first visit, and she did tell me that there was pain and spasms, is what she was describing. She did mention she mentioned the word RDS when we first met. However, I wasn't familiar with the disease. I had an idea of what it might be, but I clearly said it's outside of my scope, and I think I alluded to that in my notes. Have follow up with primary care or neurology for these because I don't know how to manage those.
The next question. I see you had concern of possible Munchausen syndrome by proxy enough to document in Maya's medical record. As a mandatory reporter in the state of Florida, did you call and report this to CPS?
That's a great question, and the reason I didn't do so, and I apologize if I didn't allude to this in the past. You can have hunch instincts of things. I'm the one guy who's seen this person twice in my office with an extensive medical history, and I reached out to the one person who would know from any other specialist that has seen this child will have an idea of what's going on with her. I'm just, like I said, one small part of her life in that year, less than a year that she was having these symptoms. So my reach out was not to the state, sir. It was actually reaching out to the primary doc. Listen, is this something that you've considered? That was all. I don't want to report something like this where I'm not 100% certain that that's what's going on. It was a red flag, basically, is what I'm sending out there.
Well, he already answered the why not question, so we'll move on to the next one. Doctor, you mentioned your training and specialties. In any of those specialties, was CRPS, or the older term that it is known as, was this CRPS part of those specialties?
Good question, and the answer is no. Understand, we're referring to the allergy immunology, we're referring to both allergy and pediatrics. I'm not sure, but let's assume we're looking at both. The short answer would be no. RDS, to be quite honest with you, at my time of training, probably was just like fibromyalgia, other diseases where we think there's something there, but we don't have evidence of substantiate or objective ways of treating it. So my short answer is no, we do not.
And this next question is similar to another juror's questions. Upon your first meeting with Maya in October 2015, Maya was in a wheelchair. Do you recall what was Maya or Beata's explanation for the need of a wheelchair?
Well, similar to what I said earlier, I wasn't given a diagnosis until towards the end, where she mentioned RDS. But she was doing we do a review of systems, so we kind of go over each organ and ask questions. And that came up as part of her neurological, that she does have spasms and pains. And also, I think she mentioned headaches. And she corrected me and said that headaches are part of RDS.
During the December visit, was Maya in a wheelchair on that visit?
Yes, she was. Unlike the previous visit, she was in no pain or distress. She was on an iPad. I remember it clearly because I thought it was pretty neat that she was actually doing a Word document. So I don't know if she was writing the story or something. It just struck me as a young kid doing that. That was pretty neat.
On this December visit, was were any pain issues mentioned like the visit's initial daily interview?
I'm sorry, can you repeat that question?
Yeah, let me just read it verbatim. On this December visit, was any pain issues mentioned as possibly the visit's initial daily interview?
No, it was not. That did not come up. The purpose of the second visit, as it always usually is to follow up on anything that I do and to review the records. And she did bring additional records to that visit, but it was not mentioned at all. She did go into, like I said, some sort of a spasm towards the end of the visit when I was giving her a summary of my findings, and I thought that was kind of odd.
When you said spasm, you mean Maya or Mrs.
I'm sorry,
Kowalski?
Maya did, yeah.
During the December visit, did you see any signs of dystonia?
No. So so assuming we're referring to dystonia as muscle cramping or some changes associated with muscle cramping, usually the lower legs are the more common. I'm assuming that's what we're referring to. I did not. There was a physical examination done on both visits, and both visits did not correlate with any. Again, from the best of my abilities, I don't do a full neurological exam. I'm not a neurologist, but I did not see any joint aches and pains when I examined her. I did not see from visible skin lesions at all. So my short answer is I did not.
Was Maya in long or short pants?
Ooh, that's a great question. I'm trying to remember. I remember I was able to see her ankles. That's all I can tell you, and I believe she may have had not long or short pants. What do they call them? Capris? So short, yeah. That's what I remember. It's 8 years ago. I'm sorry, guys.
Was she wearing socks, shoes, sandals, flip-flops?
Do not recall that part, no. And I don't believe she was wearing footwear, but I just don't remember the top of my head.
Next question. And this was prefaced as a yes or no from the juror. You mentioned that based on your examination of Maya and reviewing of testing results, you came to believe Maya suffered from Munchausen syndrome by proxy or similar term?
And you're asking for a yes and no
Well,
answer?
you can expound, but why don't you first start off with yes or no?
It cannot be a yes and no answer. I can only say suspect, and I'm required to raise a red flag somewhere. I have to reach out for somebody to help.
How many cases of Munchausen by proxy had you encountered up until 2015?
This is probably my second in my career, so that would be 2.
That completes the asking of the juror questions. Mr. Hunter, do you have anything in follow-up? Mr. Anderson, do you have anything in follow-up?
So you defer to Dr. Wassenauer on as to whether there really was Munchausen by proxy or not? True.
In my letter, yes, sir.
Thank you.
Any follow-up to that? Members of the jury, any further follow-up? Okay, may this document be released?
Yes, by plan.
Yes, sir, Your Honor.
Sir, thank you very much. Defense, your next witness, please.
We call Dr. Jennifer Katzenstein.
Can raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Well, come this way.
Yeah, please. Good morning.
Good morning.
If you could introduce yourself to the jury, please.
My name is Jennifer Katzenstein.
Okay. And what's your profession?
I'm a pediatric neuropsychologist.
Okay. So let's talk a little bit about what the road to becoming a pediatric neuropsychologist.
I'm sorry to interrupt, but I have a question.
Yeah, so you might need to...
Get closer?
Yeah, sit a little closer to the microphone, pull it near you. There you go. Start at basics. Let's see if everyone can hear you. Introduce yourself to the jury.
My name is Jennifer Katzenstein.
I think that's going to work.
Better? Okay.
A pediatric neuropsychologist, where did you go to undergrad?
I went to undergraduate school at Lafayette College.
Okay. And what did you graduate with?
Bachelor's of Science in Neuroscience.
And then after you graduated with your Bachelor of Science in Neuroscience, where did you go to school next?
I went to graduate school for my master's and my doctorate degree at Purdue's campus in Indianapolis.
Okay. And did you achieve your doctorate?
I did.
Not to age you, but I got to ask, what year did you graduate?
2008.
Okay. And after you graduated, where did you go next?
I went to fellowship, which is a 2-year placement at Texas Children's Hospital in Houston, Texas.
Okay. Maybe you could look to the jury and explain to them what is a fellowship training? What does that entail?
So for psychology, it's similar to physicians. We spend 1 year as an intern at a placement somewhere across the country in order to get your degree. And then after that, you have to have a number of supervised hours to be able to be considered license eligible across the country. And so for me and for pediatric neuropsychology, we're required to have a 2-year placement in order to be board eligible. So that was my 2 years of training after my degree was completed.
Did you achieve board certification?
I've achieved board certification by the American Board of Professional Psychology in both clinical neuropsychology and subspecialty in pediatric neuropsychology.
And you retain those board certifications today?
I do.
Okay. What's your focus?
My focus as a pediatric neuropsychologist is on how the brain impacts behavior and cognitive functioning, and how we can best support children in determining their educational and vocational needs based upon their cognitive strengths and weaknesses.
Okay. So, how long have you been working at All Children's Hospital?
I've been working at All Children's for just over 8 years.
Okay. So if we work backwards, do you remember when you started, what year?
July 2015.
Great. All your work is in pediatrics?
All of my work has been in pediatrics.
Are you familiar in general with the diagnosis of pain as a component of pediatric disorders?
I am.
What percentage of your practice is devoted to working with children who have pain?
That's challenging to say because kids have varying levels of pain throughout multiple different types of medical treatments. So I would say many of my patients have some level of pain as it relates to their medical history or their current medical treatments.
Okay. So we're going to talk about what your role is, but I'm going to try to let the jury understand from you what your role would not be. You're not a medical doctor that makes a medical diagnosis. Is that fair?
I'm not a medical doctor.
Okay, so I think one of the things the jury might want to know, are you going to be telling this jury whether Maya has or does not have CRPS?
I will not be speaking, confirming, or denying any medical diagnosis.
Okay. So let's talk a little bit about pain scores, because the jury's heard a little bit about pain scores. How do you take a pain score from a child?
So with kids, it's more complicated because pain is subjective and pain is very specific to the individual. So for kids, and for many people, we have a scale of 1 to 10. For kids, it has little faces next to it as well, where we say a 1 would be no pain and a 10 would be the most pain you've ever felt, and ask them to give a rating or point to the smiley face along that pain scale.
Okay. So is it subjective?
It is subjective.
Okay. What do you normally see in a child who's reporting 10 out of 10 pain?
In a child who would be experiencing a 10 out of 10 pain, that should be the most significant pain they've ever had. And so that would be, from my observation, something like lying on their bed, maybe curled up, not willing to speak, maybe feeling nauseous, vomiting, not even being able to speak, maybe even screaming because of the pain that they're experiencing being so severe.
You've had a chance to evaluate children who deal with chronic pain?
I have had some children with chronic pain in my practice.
Do children with chronic pain generally report higher or lower scores of their pain?
It really depends. Our pain is specific to who we are and also our perception of that pain. And so when maybe someone says, I have a really high pain tolerance, they might rate their pain a little bit lower because their worst, most significant pain or their perception of that is higher than maybe someone who doesn't have that same perception of pain or understanding of their own pain.
So I'm going to ask you about some of your interactions with Maya and her family. Okay. We're going to start, Clay, with Joint Exhibit 1001-3748, which is in evidence. If you could put that up, please. And we can probably focus in where your psychology consult note begins. Just sort of talking about this note, if you can tell the jury, what was your purpose of trying to meet with Maya on this day?
Yeah. This would have been the day that the consult would have been received by the psychology service to complete this request by our medical team. In this initial note, I'm looking here, I was meeting with the pain team to discuss the plan of care, and I introduced myself to the family. Oftentimes in these situations, there's numerous providers in and out of the room, so we were working to schedule a time so that we could speak all together.
And just so the jury's aware, is most of your practice on the campus inside the hospital, or is it off campus?
For my practice, primarily, I'm an outpatient provider, meaning that I do clinics that are in a separate building from the hospital. However, at this time, we had 3 psychologists, and we each rotated on call every week. And so when those times came up and a consult was received and I was on call, I would be inpatient for those required appointments, consultations, needs for my patients, and also outpatient during my clinic time as well.
Okay. So during this first time that you had spent with the Kowalskis on 1010, did they ever express to you a desire to leave All Children's?
No.
Okay. I'll talk to you about your next note. It's on Joint Exhibit 1001-3832. Sorry, yes, it's 1001-3832. And if you could pull out where her note begins, this would be the next day, October 11th, is that correct?
Correct.
There's a statement in here about the interview history, about why you were being consulted. Can you tell the jury why you were being consulted on this day?
Initially, my understanding of the consultation was that Nemours wanted to have a measure of cognitive functioning, or IQ, completed as part of the transfer request. But as I became involved and met with the medical team, that had evolved over time to supporting the family during the hospitalization.
Okay, so we'll talk about your role in terms of supporting the family and supporting Maya going forward, but there's a discussion of Nemours. Did you have some familiarity yourself in terms of what Nemours could provide?
I did. About 6 months prior to this, myself and another anesthesiologist had traveled to Nemours to observe the program. We were interested in putting together a business plan to do something similarly, and spent the day with the team at Nemours observing their physical therapist, occupational therapist, their psychological therapist, and then also working with their physician to get an overview of the components of the program and then how the day was set up for each patient involved.
In your note, on the second sentence, it says, this has evolved to provide supports for the family and discuss the importance of cognitive behavioral therapy and pain management. Do you see that?
Correct.
Can you explain to the jury, what is cognitive behavioral therapy?
Cognitive behavioral therapy is a therapy that we use as psychologists and therapists. It's evidence-based. It actually has quite a bit of support behind it as the standard of care for many psychological conditions, and can help with the stress and anxiety related to medical conditions as well. But what it is we look at how our thoughts impact our feelings and our behaviors. And so we talk through different coping strategies, an understanding of the interplay between our stress, our anxiety, our mood, and those thoughts, and then work to address the thoughts to in turn improve our mood, our feelings, our behavior.
From your perspective as a neuropsychologist working with Maya to provide cognitive behavioral therapy, does it matter the source, meaning whether it's psychogenic pain or an underlying illness?
Interestingly, for many conditions, psychological and otherwise, cognitive behavioral therapy is a strong therapeutic technique regardless of diagnosis.
Okay. Let me turn to the next page, Clay. It's 3833. And this is page 2 of your note, and I'll direct your attention to the top. Do you recall, or does this help refresh you, that you had met with Maya and her father the previous day?
Mm-hmm.
So you're coming back the next day. What is the goal? What are you trying to get?
My goal was to meet with everyone together.
Okay. And does your note reflect whether you were able to eat with Mom, Dad, and Maya all together on this day?
I was not yet able to meet with everyone together.
Okay. It looks like you tried to call Mom to arrange it, and for whatever reason, she just wasn't available at that time.
Correct.
Okay. So we're going to direct your attention now to the next note, the next day, which is Joint Exhibit 3829. And this is now the third day. And just backing up, and I'll cover this for each day, on October 11th, for any interactions they had with the family, did anyone express a desire to leave all children?
No.
Okay, so let's talk about 10-12s. The next day, this is your third attempt to meet with all the Kowalskis, is that right?
Yes.
Okay, so let's go to the next page, which is 3830 at the top. And again, it looks like the second paragraph, you were trying to meet with Maya's mom again, is that right?
Correct.
And for whatever reason, she was unavailable to meet with you at this time?
Correct.
Okay. And then you discussed, well, take a look at your note. Did you discuss with the nurse some techniques that she could employ with Maya to help her?
Yes.
And what would those techniques be?
I spoke with the nurse about different ways that she can help Maya calm down, including utilizing deep breathing, some meditation, so again, that calming process for our body. And then sometimes for our kids in the hospital, there's a lot of people in and out of the room. And to give them some control of who comes in and out, we put a stop sign on the door so that maybe for 20 or 30 minutes each day they can say, I don't really want anyone in the room. I don't want to be bothered during this time, because there's so much happening medically. Then that way they can put that stop sign out there and really control who's in and out.
It looks like, according to your note, you called mom to meet with you?
I did.
Okay, and at least says that this time you didn't receive a call back. Is that fair?
Correct.
And Clay, just because we've covered this, but if you can scroll down a little bit on this page where it says medical history, we'll stop there. There's a number of diagnoses here with the medical confirmed. Can you tell this jury how that gets on your note?
Yes, those are entered by the medical team, and when we write notes in the electronic medical record, oftentimes there are pieces of the medical record that automatically come in. And so those pieces of the note are brought in by the different software program and then are not made by me, but are presented by the medical team.
And I think we talked about this at the start of your testimony, but whether these diagnoses exist or do not exist, that's not something that you get involved in. Is that fair?
Correct.
Okay. So let's talk about the next day. You made it looks like another attempt, which is the fourth attempt to have a family meeting, and that's at 1001-3824, please. And we can expand on it a little bit there. Okay. Did you have a chance to meet with the family on this day?
I did.
Okay. All of the Kowalskis?
Correct. Well, my mother and father.
I apologize, right. So it was mom, dad, and mine.
Correct.
Okay. It looks like, at least according to your note, you spent a significant amount of time in conversation?
I did.
Okay. At any point during this meeting on October 13th, did anyone express, and did either Jack or Beata Kowalski express to you a desire that they wanted to leave the hospital?
No.
Objection, straw man.
It looks like you had a long conversation of some of Maya's medical history. Do you see that? In terms of the homebound and
Oh, yes, just scroll a little bit further.
okay. We'll flip to the next page, Clay, which is 3825, please. And take a minute to review your note if that helps you refresh. I'll ask you a couple of questions about this.
Okay.
You have a comment about halfway down the first paragraph where it says that the school transition caused significant anxiety and exacerbation of her pain. Do you see that?
Yes.
And then the next sentence says her parents reported understanding that anxiety and stress are directly related to her pain.
Yes.
Can you explain from your perspective as a neuropsychologist what the interplay is of that mind-body connection with pain?
Absolutely. So when we have increased anxiety, stress, or other psychological functions, we can see an increase in other physical symptoms as well. And in this case, Maya's parents understood in our discussions that having increased stress and anxiety about having to return to school was related to an increase in pain.
The return to school, did you have an understanding as a neuropsychologist what that meant in terms of how many hours Maya would be receiving at home versus now what she was being asked by the school board to come back to?
Yeah. So in my experience, hospital homebound services means that a teacher comes into the home pre-COVID in person for 2, 3, maybe 5 hours in total per week. And then there's other assignments that the student is doing throughout the week. So going from hospital homebound with a few hours per week of individual teaching supports back into a full school academic setting, I understood could be stressful because that's a big transition.
Okay. In the next paragraph, where it starts with her parents went on to describe the stress, there's a comment at the end of it about mom directing you to a blog and a fundraiser. Mm-hmm. Do you see that?
I do.
Did you have a conversation with Mrs. Kowalski about whether you should be reviewing the blogs and the fundraising pages?
I recall her offering those to me to provide a better understanding of Maya's condition. However, I indicated that I don't utilize the internet or social media or any other sources for my families because I want to gain that information directly from them.
In the next paragraph, you were discussing your observations with the Nemours Pain Clinic.
Yes.
And I know you gave the jury some understanding of what you knew about it. Would it have been your recollection that you would have recommended to the Kowalskis this being a program that they should consider?
Yes, I continued to recommend that, the duration of the hospitalization.
Okay. Let me direct your attention to the next page, which is 3826. Under the histories, it says history limited by. Can you read that for a moment, doctor? What did you mean by altered mental status and Maya's pain and emotional status?
So as a part of every consultation, we do a mental status, so I can report back the current functioning of that individual child. And at this initial consult, where all family members, mom and dad, were present, Maya appeared to have an altered mental status, as she wasn't able to report or discuss with me at that time, and mom and dad were providing all of the responses.
Okay. And having met Maya prior, when it was just her and her dad, and now meeting Maya when her mom's present, was there a difference in Maya's affect?
In previous meetings, I had spoken with her, and she had been conversational, and she was not at this meeting.
Let me turn you to 2 pages deeper. It's at 3828. Under the appearance section, what did you know?
I wrote here, Maya was poorly groomed, and her parents reported this to be a change in her demeanor, as she usually takes great pride in self-care.
And then under the social emotional, what did you report?
Anxiety, depression. Maya's parents report significant anxiety and stress exacerbate Maya's pain. In addition, they discuss that she appears more depressed, and that her mood has changed because of her pain.
Clay, if you'll scroll down to the assessment and plan to the bottom where there's a diagnosis. What was your diagnosis as of this day after having the family meeting?
At initial meeting, I diagnosed psychological factors affecting other medical conditions severe.
What does that mean? Can you explain that to the jury?
Per the medical record, there were medical diagnoses, and in discussions with parents, they noted that anxiety and stress exacerbate the pain that is related at that time to the medical condition. Severe means hospitalization. So there's different levels, and per our diagnostic and statistical manual that we utilize to diagnose, severe equates directly to hospitalization.
The next line, you have something that says rule out somatic symptom disorder. Can you tell the jury what your thought process was here?
Yeah. Pain disorders, psychological components of pain are complicated, and so in this section of our manual, there are multiple different diagnoses. Somatic symptom disorder is one of them, and what it means is that the physical manifestation or the symptoms related to the medical condition are out of proportion with what the individual is perceiving. And so it might be excessive focus on the symptoms. It may be that the symptoms and the condition become part of one's identity, and that treatment has really taken over their life and become who they are. And I wanted to explore that further as we continued our time together.
The jury's heard at various times a diagnosis called conversion disorder. Are you familiar with what that is?
I am.
Can you explain to the jury what conversion disorder is?
Sure. So also in this chapter is conversion disorder. That's when one or more physical symptoms can't be related to a physical or medical condition. And so it's thought that maybe anxiety, stress, psychological factors are manifesting a physical symptom, and it's not purposeful. This is really a complex interplay of how our mind and our body work, and sometimes related to that, you can see that a patient has a reinforcement for those physical symptoms. And again, our minds are creating these physical symptoms, even though that patient isn't purposefully creating them.
Yeah, and you bring up a good point, doctor. In conversion disorder, that doesn't necessarily mean the patient is faking it. Is that true?
Correct.
Sustained.
Does conversion disorder in your training mean that the patient is faking it?
In conversion disorder, many times the symptoms are real. What's happening is real. It is very much not being rooted in a medical condition, but that, or faking it, or pretending. These are real symptoms that are happening.
Can you explain to the jury or expound on the concept? You talked about the subconscious level of this. Mm-hmm. What is the interplay of conversion disorder and the subconscious of a patient?
Yeah. Conversion disorder really is in the subconscious. So these symptoms are coming through as a result of significant stressors, psychological or emotional factors. So it is, again, that deeper interplay in our mind where the physical symptoms arise.
Let me direct your attention to 3829, which is the last page of your note, and just if you could go to the top, Clay. You made some recommendations. What did you recommend to the family at the end of this family meeting?
I would remain available to the patient during the admission, and I'll continue to follow Maya during the admission. And then I was requesting continued follow-up with her outpatient psychotherapy provider, utilizing evidence-based practices, including biofeedback and cognitive behavioral therapy, and then follow-up with Nemours Day Treatment Pain Program.
What was Nemours asking you to do or someone to do on Maya's behalf before transfer?
My understanding for the reason for my consultation was to get a measure of IQ, of cognitive functioning.
Was that task performed by you or Dr. Lewis, or what ultimately happened with that?
Ultimately, that was completed by Dr. Lewis.
Okay. Can you tell the jury why you didn't independently repeat that?
Yeah. So when we utilize measures of IQ, per the standardization of those IQ measures, you can't repeat them within a year. And Dr. Lewis, at that point, was involved in the case. He would be doing an evaluation, and so it wouldn't be within the bounds of each intellectual ability measure to be able to repeat that within a year, let alone a few weeks.
Let me ask you about the next time you saw Maya. We'll go to 3821. And just to orient you at this point, the shelter order had been in place. Is that right?
And 1014.
Just so we're not getting, I'll represent to you that after this meeting, as of 1014, that there was a shelter order.
Thank you.
Okay. Were you attempting to see Maya the next day to continue cognitive behavioral therapy?
On 1014, I attempted to see her. She was not available, and I'd follow up on Monday.
Okay. So your plan after the 1013 meeting was to continue to see her for cognitive behavioral therapy, but she was in a procedure or something where you can... Okay.
Correct.
Plan was to come back Monday?
Correct.
Got it. Okay, so let's talk about the next time you saw her, which would be 3816. And you can just note the date of the time, and I'll just direct you to the page 3820. If you can go to 3820. And you were able to perform cognitive behavioral therapy with Maya on this day?
Yes, on the 17th.
What did you notice about her appearance at this point?
She was appropriately dressed and groomed.
And what did you notice about her orientation?
She was oriented to person, place, time, and situation.
I'm going to direct your attention next to 3813. And I'll note it's at the bottom, Clay. It shows that you attempted to meet with Maya again 2 days later on the 19th. What was the purpose of this meeting?
To continue to consult and provide support.
Okay. And would that also include cognitive behavioral therapy?
Yes.
Let's go to 3814, please, the next page. And if you could focus on the interval history.
Mm-hmm.
And were you able to provide cognitive therapy on this day?
I was not. Maya was not in her room.
And what was your plan?
I would plan to follow up the next day, continue to provide CBT and some guided journaling.
Okay. Let's go to 3810, which is your note from the next day, 1020. And I'll just note that the date of the note. Let's go to the next page, which is 3811. Were you able to meet with Maya this day to provide cognitive behavioral therapy?
She was not in her room.
Okay. And what was your plan?
I would plan to follow up the same day if I had time, or the next day, and continue to provide CBT and guided journaling.
Okay. So let's go to the next day, which is at 3807. Now we're on October 21st. Were you able to connect with Maya on this day?
I was.
Take a look at your notes. Is this the what are you doing for this section of cognitive behavioral therapy?
Initially, in cognitive behavioral therapy, we start with what's called psychoeducation. So education and information surrounding how symptoms of pain interact with our moods, our emotional functioning, our stress and anxiety. And we started to discuss the role that our thoughts play in physical outcomes, especially tensing up prior to physical therapy, as she worries it will be painful.
In the next paragraph, you have this comment about her pain in the second sentence about her pain being expressed to be a 10, but you have a comment about her affect. Can you describe to the jury what you meant by this?
Yeah. Her affect was quite bright and didn't match what I would perceive a 10 to be, which would be that significant extreme pain.
You were able to complete cognitive behavioral therapy sessions with Maya on this day?
I was.
So let's go to the next note, which would be on October 26th, and Clay, that will be at 3803. Would this be the fourth session of cognitive behavioral therapy you were able to perform with Maya?
Yes.
And was she present to be able to participate?
Yes.
You have a comment here about, in the second paragraph, about scary movies and our time in Mexico. Can you describe to the jury what that conversation was?
Yeah, and part of our guided entry into her journal, we were talking about different questions. So a guided journal entry would be a question that we were answering together. And so we were completing an entry together of what she was most afraid of. And she indicated that when she was in Mexico receiving treatments, she saw a scary movie, The Ring, and that she was very afraid of that movie.
I'm going to take you to the end of your note at 3806. And you have some recommendations here, Doctor.
I would continue to follow Maya while she was inpatient and provide CBT. And then as discharge was considered, it was highly recommended that she be placed in an inpatient pain program where she can receive frequent cognitive behavioral therapy and biofeedback from a psychologist.
It looks like you attempted to meet with Maya next for cognitive behavioral therapy on October 31st, Halloween. I'll take you to your note at 3799. And if you just look at the interval history, can you tell the jury whether you were able to do cognitive behavioral therapy on this day?
I was not. Her father was present for a supervised visit.
Okay. And what was your thought process?
Yeah, I wanted to honor their time together and allow them that time to be together, and I could come back the next day or another day.
So let me direct your attention to your note of 11-2, 2 days later, which is at 3795. Were you able to spend time with Maya on this day? Well, actually, let me direct your attention to the second page of the note. And at the top, in terms of interval history, you document a conversation with the social worker.
Mm-hmm.
How does that work at All Children's in terms of the liaison of DCF and social work?
Yeah, our social work team is the primary liaison between DCF and our hospital staff.
Did you make any recommendations to Kathy Betty of social work in terms of what Maya might need after discharge?
So oftentimes when there's a shelter of a patient, they're ready for discharge from the hospital far before the court has made a decision about what the next steps look like or where the child can go if they can go back to the home. So what we do is we provide recommendations for what those next steps should look like should they not be able to be reunified with their family. So in this case, what I was recommending was first going into some type of rehabilitation or pain management program, and then if the decision still had not been finalized by the court at that point, she would be going into a foster care setting, and there's different levels of foster care setting, and I want it to be the most appropriate level for her needs. So in this case, it was the medical foster care with the mental health component so that they could understand her medical appointments, any potential medications, and the complexities of what was happening.
Let me direct your attention to the next note, which is at 3791. Did you attempt to meet with Maya on this day, 2 days later, for cognitive behavioral therapy? Clay, you can go to the next page at 3792.
So again, her father was present for a supervised visit.
Okay. And did you, again, just to move things along, you decided to honor their visitation time and come back another day?
Correct.
Let's turn to your next note at 11:8, which Clay will be at 3787. And were you able to provide, we'll do it at 3788, which is the page of your note. Were you able to provide some cognitive behavioral therapy with Maya in this case?
Yes.
And were you able to, would this be cognitive behavioral session number 5?
This would be number 5, correct.
So let's go to the next note, the next day on 11/9. Did you attempt to meet with Maya for cognitive behavioral therapy? Clay, it's at 3783.
Yes, I did.
And let's go to the next page, which is 3784. Per your note, were you able to provide cognitive behavioral therapy session number 6?
Yes, on 11/9.
And what types of things are you discussing during this session?
She's discussing wanting to go home. She was up all night worrying and crying about the outcome of the court hearing, and she described her pain to be a 10.
Let's talk about the next note, which is at 3780. We'll go to the second page of this. This isn't a cognitive behavioral therapy note, but it discusses some interaction that you had with risk management with Kowalski's. Is that right?
Yes.
Okay. Do you recall what the circumstance of this was?
Yes.
Okay. Why don't you tell the jury what the circumstances were at this point?
We had received a court order from the court to provide family therapy. I am not a family therapist, and on staff, none of our psychologists were family therapists. I wanted to provide the information to risk management of how to proceed, given that we did not have a psychologist on staff with family therapy experience to be able to complete this request.
And it looks like in the second paragraph you provided your cell phone number to Mr. Kowalski.
He provided his cell phone number to me. I subsequently provided the direct line to my office.
Okay. So you provided Mr. Kowalski a number that if he wanted to talk to you and contact you, he could reach out to you directly.
Yes.
Objection here. Leading.
Overruled. Let's talk about the next time that you saw Maya, which would be at note 3776. Were you able to connect with Maya for cognitive behavioral therapy on November 25th?
Yes.
Okay. And at least on the first page of the note, would this be cognitive behavioral therapy number 7?
Yes.
Okay. And again, you're reinforcing the types of activities that you would recommend for these sessions?
Correct.
Okay. Let's talk about the next attempt. Would that be on December 2nd at note 3773?
12/2, I attempted to see her.
Okay, let's go to the next page. What happened? Where was Maya?
She wasn't in her room.
Okay, where are, I don't know if you remember specifically, but for a patient like Maya, where would she be?
Yeah, there could be a couple places for physical therapy and occupational therapy. We have a gym where the kids can go to, so they're doing more activities and there's more place to be.
Objection, speculation. Overruled.
Or in the activity center, we have an additional place where our patients go, that Child Life staffs, where different activities are happening.
Okay. Let's go to the next attempt to meet with Maya for cognitive behavioral therapy, which would be at note 3769. And it looks like she, again, was, at least per your note, in physical therapy and not available. Is that right?
Yes.
Let's go to the next attempt to meet Maya, which would have been on December 14th at note 3766. And did you attempt to provide cognitive behavioral therapy again on this date?
On this day, yes, her nurse let me know that she was in the activity center, so I went down to the activity center, but she was working on a group activity with other kids and wasn't interested in speaking to me.
Okay. Do you remember what the activity was?
I do not.
Let's go to the next time you tried to meet with Maya for cognitive behavioral therapy 2 days later, and that would be at note 3763. Do you remember where Maya was?
She was not in her room. I do not know.
You note that you had a plan to discuss rewards for goals. What is that, doctor, if you could explain that to the jury?
The physical therapists were looking for ways to help engage her in physical therapy, And so oftentimes we put together a behavior chart and we set goals. We want them to be small and achievable to start. And then those are linked to rewards. So at home, it could be things like choosing what the family has for dinner, extra time before bedtime. In the hospital setting, we're looking for what things can be reinforcers to help her to engage and feel motivated to engage in those physical therapy activities.
Let's talk about the next time you visited with Maya, which would be 4 days later at note 3758. Were you able to connect with Maya on December 20th?
Yes.
Okay, let's go to the next page. And just to speed things along, it looks like you're summarizing the rewards plan. Is that right?
That's correct.
How did she react when you discussed this potential rewards chart?
Yeah. At first, when I walked into the room, she appeared frustrated and down. But once I mentioned we'd be discussing rewards, she quickly brightened and was cooperative, outlining the list that you see here.
So talk to me about this list on potential rewards. Clay, you can scroll down a little bit. How does this list work?
So it's an opportunity for a patient or child to tell us anything that might be motivating for them. And then we take it back to the team, our child life specialists, to determine what could be feasible. Could we have someone come in and do hair and makeup or manicure or pedicure? Or could we figure out a way to do an individual tour of the helipad or have her play the piano in the lobby? What can we do? What can work?
What is a child life specialist?
A child life specialist is someone trained in normalizing the hospital experience for our patients. They're there to provide activities, talk through medical procedures, and provide support to the patient and their family.
And did all children's have people that could come into the hospital and help fulfill some of these rewards or requests of the child?
Yes. Pre-COVID, all of these things were on the table.
So let's talk a little bit about the next time you saw Maya, which would be 2 days later, 12/22/16, if we could go to note 3755. Looks like you, in the note, she gave you some more ideas for rewards. Is that right?
She did.
Well, I don't know what gelato from Pasiugo is. What is it?
I'm sorry you don't know that.
What am I missing out on?
It's a gelato place that is in St. Pete and multiple places that has multiple different delicious gelatos.
Okay. Do you have a recollection of whether the hospital was able to help with that?
Yeah, I do remember Pasiugo gelato coming into the hospital for Maya.
Okay. Let's talk about the next visit on 1001-3751, please, Clay. This was the 9th cognitive behavioral therapy session that you were able to accomplish with Maya?
Yes.
And you talked to her about coping strategies as she went through her process. Is that fair?
Yes.
Not to dwell on it, but the jury knows that shortly after this, her mom passed.
Yes.
Were you able to meet and provide some bereavement services for Maya?
On the day of Maya's mother's passing, I was present at the hospital to provide support if needed. However, our chaplain went in. I was not asked to go in. And then the next day I followed up with the family and Maya in her room.
Just a couple questions before I yield to Mr. Anderson or Mr. Whitney. Did Maya ever complain to you while in the hospital about any negative interactions with Kathy B?
No.
In fact, did Maya ever complain to you about any concerns she had with mistreatment in the hospital?
No.
Did
Mic off, please.
Conversation's going to take me a little bit longer than just a couple of moments, so I'm going to ask you to retreat back to the room. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We'll see you in a few minutes.
All rise. Jurors exiting.
Okay, the jury is out of our presence. Everyone can be seated. Madam Court Reporter, this is going to be designated as a proffer. Doctor, there's going to be some questions that are asked. We may or may not ask these questions in front of the jury, but for now, Mr. Anderson.
Dr. Constantine, in your records, you had put down, you had hundreds at
1001 3817.
1001 3817. There we go, bottom of the page. You put, she denied a history of sexual abuse. Do you see that?
Yes.
She stated that one time previously a doctor had looked at her private parts but did not touch her, and it made her feel uncomfortable. You see that?
Yes.
And then she denied suicidal ideations. Upon receiving a note from this child in the context, and would you agree with me that the context you had set up was a history of sexual abuse? Would you agree that that was the first way, the lead into the next question?
I asked the question of all my patients if they've experienced abuse.
Right. And immediately after that, a 10-year-old girl says, one time previously a doctor looked at her private parts but did not touch her, and it made her feel uncomfortable. You see that?
Yes.
What is repression or suppression of sexual incident in children? What do they do if they have something bad happen to them sexually that they don't understand?
In some cases, when a child has experienced a sexual assault, they may not remember it at that time. In this case, what I saw here, when my discussions with Maya, where she said she had previously at another organization had a doctor look at her private parts, but it was part of a medical examination and that individual did not touch her.
Well, doctor, would you agree with me that a 10-year-old child, or perhaps even younger child, may not know exactly what constitutes sexual assault or sexual battery?
In this situation, a physician looking at the private parts of a patient would be part of a typical medical examination.
And are you aware of the prior proffer of Maya Kowalski in this case?
No.
All right. Well,
I
in a
don't know.
circumstance... Okay,
I don't know what you're speaking of.
Sure. Well, Maya Kowalski, your patient that you were describing here, if it was such that Maya Kowalski actually had a physician come in, a male physician, described specifically by height, weight, what the physician had on, a name tag, everything else, who came through the door and said, and walked up to her without a chaperone saying, "Can I take a peek?" And then went and pulled her drawstrings down below her vagina, pulled her panties down below her vagina, and stared at her vagina for a period of time long enough for the child to feel uncomfortable, and then turn around and left saying, "Thanks." Would that be the type of information that you would find necessary to report?
That was not what was reported to me.
I'm not asking you that, ma'am. I'm asking you if that set of facts came to your attention, would that be something you would have to report?
If there was a hypothetical situation where a patient presented to me a concern where any team member in our organization made them feel uncomfortable, outside of typical medical care, because sometimes medical care is uncomfortable, then I would talk to our risk management team, and if it met the statutes for potential abuse, neglect, abandonment per the Florida statutes for a report to DCF, I would make a report.
Well, you don't necessarily have to have risk management to do that. You are a licensed reporter. You would have to report no matter what risk management said. Isn't that true?
If it met the criteria for abuse, neglect, or abandonment.
In this, you say, Maya told you, she stated, one time previously, a doctor looked at her private parts. She did not say a doctor at another hospital, did she?
She said previously, which meant for me at a different organization.
She had been at Johns Hopkins now for over, what, 10 days? Right? Did you know of any other organizations or hospitals she had been at?
Yes.
All right. How did you distinguish then between all of the doctors that had come and gone in Maya's life from the time she came in on the 7th, or even previously visits at Johns Hopkins from non-Johns Hopkins doctors?
I utilized the word previously in my note because it meant at a previous organization.
And why would it matter where it was if the child's comment there let you know someone stared at her privates and made her feel uncomfortable?
It would be for comprehensiveness of my documentation.
Well, it wouldn't really matter, though, would it? It doesn't matter whether it's a Johns Hopkins doctor or if it's a doctor from down the street or anyone. That's still a reportable offense, is it not?
This is not a reportable offense.
But the point is, you didn't follow up to find out if it was, did you?
This is not a reportable offense. This was part of typical medical care. There was no abuse, neglect, or abandonment.
How could you possibly know what was going on in that child's mind based on just that statement?
I asked her the questions. She told me that she felt uncomfortable and that she was not touched.
And 10-year-olds don't even really know what sexual abuse is in many instances. True?
In many cases, 10-year-olds do know what that is and are openly reporting it.
Yes, but in many cases they do not.
In some cases, I cannot speak to this situation. I wrote down what she reported to me.
Particularly in an instance where a child is being held, let's say, at a hospital, and a lot of doctors come and go in there. That child may not know what's appropriate and what isn't appropriate. Correct?
Each situation would vary. She had been to a number of hospitals and organizations.
If this was not a reportable offense, tell us the specific date, time, and circumstances of this encounter between Maya and a doctor.
I do not know, previous to her hospitalization with us.
You're a licensed reporter, are you not?
Everyone in the state of Florida over the age of 18
You're
is
a
a mandated
pediatric
reporter.
Sorry, excuse me.
Let me stop. Let me stop you. Can you relay to me your encounter with Maya Kowalski about this incident?
What I have written here is what I recall from that.
Well, did you follow up with questions about the incident, or it's just she made the statement and then you moved on?
Well, this would have been a summary of my discussion with her. So I would have asked, were you touched? Did that physician touch you? No.
So I'm trying to ask you to relay as best as you can remember your discussion with Maya Kowalski that generated this note.
Mm-hmm. So in my discussion with her, I would have asked about potential sexual abuse in the past. Back and forth in our conversation, she declined that that happened. She described a situation at a previous organization where a doctor had looked at her private parts during a medical exam and that she was not touched.
And the conclusion that it was a previous organization, is that what Maya said, or is that a conclusion you drew?
I utilized the word previously, which would have been that she told me it happened at another organization.
Okay, so she didn't say it was another organization, she just said previously.
Not here.
Did she say not here?
I have previously, which means to me it meant not at Johns Hopkins All Children's.
You can continue, Mr. Anderson.
Isn't it true that previously that term could mean the day before, or it could have meant the month before?
I would have considered it all to be in the context of the current hospitalization.
I'm not asking you that now. I'm just asking you as a matter of the English language. The term previously could have been from the day before or a month before. True?
Previously means prior to that time.
And prior to that time, for the 10 days before, where had Maya been?
She was at the hospital.
And all the doctors that she saw would be at that hospital, right?
Yes. Well, not necessarily. They may have medical staff privileges, but they may not be employed by the hospital.
The vast majority of them would be Johns Hopkins doctors. And yet, with that knowledge, you still did not pursue with this child any further details, did you?
This description that she provided would be similar to what we call a Tanner staging. So a physician for a child between the ages of 8 to 10 would be looking at puberty, they would be looking at pubic hair development, breast bud formation. So my understanding was this was part of a typical medical examination in which a Tanner staging was being completed.
You were aware that Maya had not reached puberty at this point, were you not?
I'm not a medical doctor, I wouldn't be looking into that.
You didn't know, as you talked to this young girl, whether or not she'd reached puberty?
I hadn't asked her about menses.
And isn't it hospital policy? Isn't it, in fact, most hospital policies? Isn't it, in fact, most every doctor's hospital policy that when you go in to see a young female child, if you're a male, you have a nurse or other chaperone?
I can't speak to the policies of all those organizations.
Is that not the policy at Johns Hopkins?
It is not part of my standard practice, and I am not aware of the policy specifically because I do not do that.
You're female. I'm talking about male doctors.
Object to the lack of foundation.
Right? Male doctors going in to see a female, especially a young female patient, especially when there's going to be disrobing involved, have some female proctor or whatever you want to call it, nurse, observer. True?
I can't speak to that. That's not my practice.
Did you see in any of Maya's records a doctor write the term, what was it, Tanner?
Tanner stage?
Tanner stage?
I do not recall. I have not reviewed every single record.
Did you look?
No.
Isn't it true that it could have been just as easily another doctor at that hospital who had come in and disrobed exactly the way Maya Kowalski previously testified?
I utilized the word previously, which meant prior to the current hospitalization.
Based on your opinion of the term?
Based upon what I reported in my note here.
Does the defense wish to have any questions for purposes of proffer?
Yeah, sure. Dr. Katzenstein, we're talking about your use of the word previously. Not what it means generically. Is what you're telling this court, when you put down the word previously, you meant that specifically to signify that whatever was being described did not happen at All Children's?
Correct. It meant previous to the hospitalization.
And what was described to you, what you wrote that day, was based on your conversation with Maya that day?
Correct.
Nothing in your note is in quotations, is it?
There are no quotes in that note.
Doctor, can I have you step outside for a few minutes?
Sure.
The doctor's outside of our presence. We're here on the objection to the question having to do with, did she report any abuse while at the hospital or something along those lines?
I think it was more broad than that, Your Honor. I'd have to have the court reporter read it back, but it was just, did anybody tell you anything?
Any complaints?
Any complaints about Maya?
Any prior mistreatment was the phrase.
Okay, whatever it was in follow-up to merely just establishing her interactions with Kathy Betty, the social worker. From her perspective, were fine, and she didn't hear any complaints regarding Maya's treatment. That's all it was meant to do. It's not meant to open this door wide open. And I don't think the jury got any impression about anything related to that. I apologize if this cracked the door on this. I had no idea that this was going to lead to this, but certainly in open court, it's important for the organization to hear from Dr. Katzenstein. I'm sure he was going to proffer her what she said.
Your Honor, this jury, it takes extraordinary levels of notes. They are on to everything happening here. The jury has now been led by counsel's intentional questions to a conclusion that nothing involving any type of assault, any type of, what was the term again, mistreatment occurred at this hospital when there has been clear evidence in a proffer of something and other evidence in court, evidence of what Kathy Beatty had done. But the problem here is the question wasn't limited to Kathy Beatty. This was an open-ended question in which the witness, and if I'm given a moment, I believe I can find the actual Florida statute, criminal statute, about this behavior as sexual assault. This describes an act of sexual assault if it was even the slightest follow-up to it. And with all due respect to the doctor, the term previously does not give license to all of the conclusions that the witness brought to bear. As a licensed reporter, she was absolutely obligated under these circumstances to explore this and to see what would happen to this little girl, and she did not. Then, capitalizing, I guess, on this, the defense now has this witness testify that nothing of the sort happened, leaving the plaintiffs with the dilemma of how are we going to go and cross on an extremely important point without getting over into an area that so far has been excluded. This puts the plaintiff at a great, great disadvantage in this case, because now it makes it sound like there's an issue of fact here about whether or not Maya was telling the truth on any of it. And so we would move the court to reconsider the whole issue as to the sexual molestation of Maya Kowalski, at least insofar at this point of being able to ask the same questions of this witness before the jury that we ask in proper, and the court asks in proper. And I think that is the only fair way to resolve this. I see no way an instruction could clear this up for us. I just don't.
If you need a response, the jury knows nothing about this.
That's the point.
How could a generic question about, did you, whatever it was, see any untoward conduct about Maya, anywhere close to suggesting to the jury about alleged sexual abuse, non-sexual abuse? It was a generic question about just her general observations. It was not meant to drill down and try to prove or disprove something they may bring in a collateral lawsuit. I mean, we're doing our best to toe the line. I didn't show the note. There was nothing intentional about this. There was no emphasis to this question. I just strongly disagree that somehow a question that at best was mildly inadvertent in attempting to capture this somehow poisoned this jury with the impression that Dr. Katzenstein raised her right hand and is attesting that she reviewed the hospital record from A to Z and never saw anything untoward.
Here's where I'm at. I think I asked 2 or 3 questions.
Yeah.
In that 2 or 3 questions, I was able to deduce that she wrote the word previous. She made an assumption that it was at a previous organization. She didn't ask any follow-ups. And she, being this doctor, didn't, and perhaps in her mind she just assumed it was this, whatever, the Tanner, whatever. But it didn't sound like she made any sort of follow-up question as did this occur here? She just made a conclusion that it was previous. And I got that in 2 or 3 questions. I'm talking that. So, the question you asked was something along the lines of whether Maya had relayed any abuse to Dr. Katzenstein. And I don't think the word abuse, what was the words, Mr. Whitney?
Had she reported any concerns of mistreatment was the term.
So, it seems that the answer no gives the impression to the jury that Maya did not relay any impressions of mistreatment, which probably isn't the correct case, isn't the correct answer. If the assumption is that, or if the assumption is Maya's disclosure was talking about something that was occurring at Johns Hopkins All Children's Hospital, and what day did this occur? 10 days after admission.
It was the 12th, I believe. 17th. Sorry, I keep thinking of
So
17th.
now I'm in a pickle because the defense did not want to get into this issue. I excluded this issue, and now you're asking a question that gives the witness the opportunity to give the impression that Maya didn't say anything.
May I call her back and proffer to clarify this? Because,
I asked a couple of questions on that specific issue.
but her testimony is going to be that if Maya had told her that that happened at this hospital, she would have investigated it further. And the reason why she didn't do a further investigation, because it was very clear to her in talking to Maya that what Maya was reporting was something happened at a previous organization. I apologize if that was.
We have done the proffer at this point in time. What should I do at this point, folks?
Well, if the question, Judge,
It's Mr. Shapiro.
yeah, I truly believe in my heart there's no way this jury heard that question and thought that there was any implication. I was trying to narrow it to this witness. If it would, I don't want it to happen because it would seem to imply that there's something greater, but I guess the cure to this would be as if Your Honor would tell the jury to disregard the last question and answer, which would be very damaging to the defense.
Well, the jury knows nothing about the alleged sexual assault because I've kept that out.
Right. So,
At your request.
Right, I understand. I guess the cure would be to just tell the jury disregard the last question about I'd have to talk with my defense team. That would seem highly prejudicial, but I guess that would be the cure, but I'd have to talk to it. It's fine. Yeah, okay, then we would.
I'll take 5 minutes. We'll be back in 5 minutes, and hopefully you'll have an idea as to how you want to proceed.
All rise. This court's in recess.
present, so is the doctor. Any further thoughts?
Yes, the question we had the court reporter mark was, did Maya Kowalski communicate to you any concerns of mistreatment in the hospital? Again, I had no intention of implying anything other than the course of action regarding her therapy sessions and what she observed. I did not mean to open the door to this whatsoever. I do not believe anything about that question would bring or allow this court to be derailed into a new cause of action. If the court wants to bring corrective action, they can ask the jury to disregard the last question and answer, which obviously would be some prejudice to the defense, but we would accept that.
Well, the plaintiffs move the court to, again, we believe the defense should be allowed to finish their questioning, but that the plaintiffs during cross-examination be allowed to follow up on the denial of Maya stating anything having to do with mistreatment in the hospital as no, and further cross-examination as it leads up to and includes whether there are any claims by Maya Kowalski, as set forth in her records, that someone had done this, that someone had peaked, that someone had done these things. And we should be allowed, based on the proffer of Maya Kowalski, to explore the specifics of what Dr. Henschke documented in her records, and we believe either should have been or known to this witness and simply not put down or never explored. And the problem we've got here is the jury now hears from the one person out of everybody that was available to Maya at this point, because she couldn't see her mom, she didn't trust Petey. So now we've got the psychotherapist here that she's seeing regularly. And the one person that she would be more likely than not, Judge, to report something to is saying, no, she never said anything to me. And that inference drawn from that is far-reaching in these circumstances, because they've already heard Dr. Henschke testify about how Maya would open up to a female therapist. Now we've got Dr. Kastenstein putting us in a real box here, and I see no other way than to be able to explore the full circumstances of what happened with that notation she put in her records. Elsewise, I need to be able to ask, well, did she report to you about Kathy Beatty doing this, doing this, doing this? Did she tell you about another doctor? Exactly what I asked there. I'm not going to say, depending on the answer, though, I should be able to go fairly far into the specifics of the facts as testified to by Maya in order to test the witness's knowledge of these things. And that is the only way that we would be allowed to correct this wrong. This is a seminal issue in this case.
I will say that the suggestion that we start talking about the alleged sexual abuse is an invitation to do this entire trial again. Full stop.
I understand.
That has either a mistrial or a reversal written all over it. I go back to the issue of the alleged sexual abuse was not in the pleadings. It was not disclosed to the court prior to us seating the jury. We did not discuss the questions we ordinarily would have asked with respect to sexual assault with this jury. So I've got no way of knowing whether I would have had any cause challenges with any of our seated jurors or alternates as to whether or not they would still be on this jury. Now, I agree that there is an impression that the question asked that is detrimental to the plaintiff. I think the only cure that I can do at this point is the statement that Mr. Shapiro was saying is I would instruct the jury to disregard the question and answer as to whether Maya Kowalski disclosed any mistreatment in the hospital to this witness. And I'm going to have to tell the jury to disregard that. And I'm assuming, Mr. Shapiro, you're not going to follow up on that issue.
No, not on that question, Your Honor.
Your Honor, we asked...
Since I am doing a curative instruction, there's no reason for the plaintiffs to drill down that issue in front of the jury.
This is going to be tough, but we would ask the court
not only to instruct the jury to instruct the jury to disregard the question and answer, but they are to draw no inferences from having heard the question and answer.
That's
I think the instruction, the court directs the jury to disregard the question and answer as to whether Maya Kowalski disclosed any mistreatment in the hospital. I think that is sufficient. I don't think I need to go any further than that. So that's what I'm going to do. Now, we only have 5 minutes before. How much longer did you have in your?
Two. I'm
Two
sorry,
mi- two
2
questions?
minutes, Your Honor. I can finish my direct. And then
So why don't we finish the direct, and I'll send the jury to lunch. Let's go get Dr. Katz's. So patient with us. When I bring the jury back in, I'm going to tell them to disregard the question and answer as to whether Maya Kowalski disclosed any mistreatment in the hospital. And then we're not going to follow up on that issue in front of the jury. So we're not going to talk about it, okay?
Okay.
Let's bring in the jury.
All rise. Jurors enter.
Jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, did no investigation, received no information. Is that all correct? And you have not been approached about this case. Is that correct? And you've seen no media coverage. Is that correct? Okay, members of the jury, I'm going to instruct you to disregard the question and answer you heard last, which was whether Maya Kowalski disclosed any mistreatment in the hospital. So you were to disregard that question and the answer. You may continue, Mr. Shapiro.
thank you, Your Honor. So just to recap, it sounds like the last time that you saw Maya in the hospital was for some bereavement counseling, I think on January 9th. Is that right?
Yes.
Okay. And then just to orient you, Maya was discharged shortly after that. Did you have a chance to see Maya after discharge?
It wouldn't be my practice to follow up after discharge.
Okay, and why?
Because I don't follow patients typically outpatient for therapy unless they're following up with me for a full neuropsychological evaluation, which she was not.
Okay. That's all the questions I have at this time, Your Honor, and thank you, Doctor, for your time.
Thank you.
And members of the jury, since you have been sitting there for so long, it's actually time for lunch. And I would normally say, let's go forward, but I actually have a meeting that starts in 6 minutes. So the reason that we can't proceed is because I've got a meeting. So I apologize. So we're going to pick this up, have them ready to go at 1:30. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And enjoy your lunch.
All rise. Jurors exit.
Okay, the jury is out of our presence. Doctor, you're in the middle of your testimony, so you can't talk about your testimony with anyone, including the lawyers, okay? We'll be back at 1:15, unless you think we need more than 15 minutes.
No, Judge, I would, I'm sorry.
I am going to try to make some statements about the DV motion, so that's coming.
That's great.
The only other thing I would ask for the plaintiff is we do intend to play Dr. Hannah soon, if not tomorrow. I don't know if we're going to get any cross designations of his testimony, but if they don't plan to cross designate, that's fine. We filed our designations some time ago.
If you want to
I gotta look into that, Judge.
I'm sorry, should I just go with
Yeah, you can, or you can keep waiting if you want. You're free to go.
Thank you.
Let us check on that, Judge. I would be surprised if we didn't, but
We will be back at 1:15. You can tell Mr. Elegant and Mr. Altenburn that I'm going to try to make some rulings on DVs at that time.
Okay.
Okay, thank you very much. We'll be in recess till 1:15. Okay, please be seated, everybody. Let's talk about directed verdict motions and rulings with respect to directed verdict motions first.
Okay.
As it relates to the battery count, and which is count 5, and that portion of the battery count that deals with the transport to the EEG room and the time period in the EEG room, I did not see any evidence of a battery occurring during that discrete time period. And so I did see there was clips that were identified, but I did not see a battery occurring in those clips, nor in Maya Kowalski's testimony. And therefore, that portion of count 5 that deals with the EEG transport / in the EEG room, I'm going to grant the directed verdict motion as to that variant, and because I'm directing a verdict as to that portion of count 5, obviously the punitive damage motion with respect to that portion of count 5 will be granted as well. Obviously, this does not impact the false imprisonment claim associated with the 2 days within the EEG room, but that's a different tort than battery. And the other counts, 6C, 14C, and 18, I'm going to go ahead and deny those counts, finding that that the plaintiffs made a prima facie case with respect to those counts. And just to be clear, if I have not already granted a directed verdict on something, just to wipe the slate clean, I will deny as to anything that I have not physically and specifically addressed. Mr. Altenburn.
I just wanted to get clarification. Did you deny the directed verdict on the fraudulent billing claim?
No, on count 18, I am not denying. I am denying it. I am not granting it. I am denying it. So the only one that I granted today was with respect to count 5, that portion dealing with the EEG room transport and during the time in the EEG room and the corresponding punitive damages. Everything else got denied.
And there's 2 punitives in my notes. I'm not sure if you did make rulings or not. I had sort of that you were still deciding on punitives as to the battery in the chapel area, or did you? You might have made a ruling that there were no punitives, but I'm not clear on my own records on it.
The hugs and kisses / instance, I already granted as it relates to punitive damages.
All right,
and then
on the ICU,
I denied it for the photo session, so there will be punitive damages for the battery. And then I just denied it, I just granted it with respect to the EEG room transport. Now, in false imprisonment, I denied the motion for punitive damages as to the EEG room, and so the jury will get punitive damages for false imprisonment associated with the EEG room.
and do they get punitive damages as to the first week in the when we did not release the child from ICU? That was the other one I was a little.
I don't think I ruled on that, so I'm going to deny.
Okay.
Okay. And since you're up, Mr. Altenburn, let me pivot to your question from this morning. On the proposed instructions relative to the time frames and with the dependency court. I've got some thoughts either we can do one of two things. I can kind of tell you concepts that I want to see, and then you can do another one, or I can spend some time and try to get something tonight and be able to send it out tomorrow. I can do either of the two.
Whichever you think is, at this point in time, would be more productive is what I'm happy to do.
Well, I also, and then I need to know from the lawyers what I need to rule on tonight. And I will tell you, yesterday I was, I had first appearances, and then I was ruling on a trial from before. So, the 14 hours I spent working yesterday, I did not work on your case yesterday. I worked on it on Saturday, but yesterday I was over at the jail and doing another case. So I don't remember what you need me to rule on next. I saw some things about deposition designations, but then I got emails saying wait, and I haven't followed that.
If I can clarify that for you, Judge. So I believe that was on the Malik deposition, and what occurred is that the plaintiff had sent that to you, inadvertently didn't copy us. We, meanwhile, were getting a deposition highlighted and to send to you. So on the Malik deposition, you should have received this morning a highlighted deposition. And the only thing, we have one objection, I think, that needs to be addressed. And I think there might be 5 or 6 objections from the other side that needs to be addressed so that we can then edit and play that deposition. I don't think it'll take the court that long. The deposition itself has been significantly cut down.
So I need to do Malik tonight. Are there other depots I need to review?
Yes, Judge. Well, we have a deposition issue. The plaintiff is declining to give us their counters or objections to Brandon Alexander Depp. They think that first the court has to rule on the admissibility of the deposition itself. And so I'd like to address
when are you trying
that.
to play that one?
We're running out of time.
Yeah, we're getting scrunched here, Judge. As soon as we can. I do have the depth so the court can make a preliminary ruling. I don't think it'll take long. Or I can give it to Your Honor to look at while.
Sure. I'm trying to figure out how much time I need to spend on these other issues
other
tonight
issue-
so I can answer Mr. Altenberg's question.
The other issue, Judge, is we need rulings on the exhibits that the court took home. And we're going to have additional exhibits tomorrow, so we need some rulings on those.
I don't think the exhibits is going to take me that much longer since we had the discussion this morning. I should be able to, tomorrow morning, just be able to come in and say X, Y, and Z is in, ABC is out. And I think I can just make an announcement. But I don't think that's going to take me much time tonight.
Okay, all right. And I don't believe we're waiting on cross designations for Dr. Hannah's deposition. And like I said, the Brandon Alexander, I think there's going to have to be a preliminary, apparently, legal argument with court. We could do it perhaps when the jury leaves today. It won't take long. So that they can then get us their cross designations and objections, and we can move forward on that deposition.
Okay, so we will do that when the jury leaves today.
That would be great.
Even if he gives you the cross designations this afternoon or this evening, I'm probably not getting them tonight anyway.
No, understood,
Yeah.
understood. But we need to get the process moving.
So to answer your question, Mr. Altenberg, why don't I take a draft? Now, what I will be giving is not a ruling, but it's my effort to send this farther along. Now, has Mr. Elegant seen?
Yes, I said that to him actually shortly before I sent it to you on Friday.
Okay.
And I've got nothing yet back from him, but I pinged him this morning that we were going to need to start working hard.
Conceptually, I want to call the actions in the dependency court just the dependency court.
Okay.
I want to try to avoid some of the passive voice.
Okay.
And I want to try to tighten a lot. And well, that's the types of things. I mean, from a content standpoint, I think mostly I'm okay with. There's a lot of instances where we repeatedly say Johns Hopkins is not responsible, Johns Hopkins is not responsible, I'm not going to do it like that.
Okay.
It will probably be more of a statement, at the beginning or the end, but I'm not doing it every other sentence.
I think I only did it 2 or 3 times, but all right. All right.
Well, 2 or 3 times on the first page.
Yes. There's 2 on the first page we can combine for sure.
Okay. So I will do that tonight, and I will get it out to you, you and Mr. Elegant in the morning sometime.
Super. We'll do it.
Anything else on that issue before we go on to another issue?
Your Honor, we'll all have a chance to look at the proposed orders, even as lowly trial counsel?
No. This is appellate lawyers
Back
only.
at me for the defense argument. I just needed to know that.
Of course. My assistant will be happy to send it to anyone that you all designate. I just assumed that it primarily is a Mr. Altenberg and Mr. Elegant
That is true, Judge.
conversation.
I just want to make sure some of the minutia of the orders gets in, so we'll do it.
Mr. Whitney, you're standing, so I guess that means you're next.
Thank you, Your Honor. We've received their witnesses for tomorrow, one of which is Dr. Elliot Crane, who is one of their experts. So I don't know if the court would prefer to do that this evening or tomorrow morning, but we need, at least as to Dr. Crane, a ruling on our motion to limit his testimony to specialization and his report.
Okay, well, that sounds like something we'll do after the jury leaves for the day.
All right, thank you.
Anything else before I bring in the jury since it's...
Yes, Your Honor. I wanted to, and this is trial exhibit 2093-002, if you want to bring it up, Danny. And it's the order of, it's the order of November 10, 2016, this one. And it's specifically, the language on paragraph 6 of page 2, and I can read it to the court, and then Danny's bringing it up. And it says, upon the invitation of the child's treating mental health professionals, the parents and Kyle are authorized to attend therapy and counseling sessions with Maya. And I just don't know how much I'm allowed to use these orders in terms of impeachment or refreshing.
Judge, they're not
At
in
all.
evidence. They're not in evidence.
They're not in evidence, but
Who's the witness again? Remind me.
Katzenstein, the psychologist.
Was there ever any evidence that they attempted to have a therapy session after that order was entered?
Yes, I mean,
She testified on direct about her effort or lack of effort to facilitate these family therapy sessions.
Here's the thing: we're not talking about the orders. You can ask the question if she attempted to have a therapy session.
I just so it's clear, her testimony on the subject was very clear. This order got in her hands somehow, and she went. I showed her the note. She went to risk management and said, "What does this mean? I'm not a lawyer." And they told her something to the effect of, "The order authorizes family counseling sessions," and she said, "I'm not a family counselor, so I can't do these sessions with the family." That's her testimony on this.
Okay. So what's the specific question, Mr.?
I was going to ask her, were you during this period of time the treating mental health professional for Maya Kowalski? And if she says, yes, I am, I'll say, well, you testified on direct about some meetings and counseling sessions with Maya and her family. Did those ever take place? No. And I guess then her response would be, because I'm not a family therapist.
I don't mind you asking the question if that occurred, but let's not talk about the court orders or referencing, well, the court said you could do this, or the court gave you permission.
Hence my questions. That's one. And then there's also, I was going to...
Mr. Shapiro, that concept, assuming Mr. Anderson constrains himself to what he just said?
if he's only going to ask her, did you perform any family counseling sessions? And she can repeat what she said to me on direct and why she didn't, because she's not a family counselor. I agree with Your Honor. I don't think you can ask the next question. Well, the order authorizes X, Y, and Z. So I think you just can ask the question. I don't have a problem with the question.
Well, the next one would be, why not? And she would, I guess, say, because I'm a family counselor. And then my question would be, but wouldn't those have to give the opportunity for Beata Kowalski to see Maya?
Well, I don't think that question's allowable.
Okay. Then the next one.
Just think of all this time I'm saving.
I'm learning. It only took me like 3.5 weeks. Then this is Trial Exhibit 2263-001, and it's not for admission. I'm just going to use it to refresh recollection.
Can we see what it is?
It's an email dated to, you know what? Hang on.
What's the number?
It's 2263-001, and what I'm trying to figure out here is whether she has knowledge of this. And yes, she does. So I needed to ask her a question about this. So it's not admitted at this point. I think it's become relevant in the case. If it's not, I'd like to mark it for identification, and then move it in. Try to move it in my rebuttal case.
I don't know how this would be relevant to Dr. Katzenstein. The responsiveness is unfortunately the clinic won't be able to attend.
Yeah, I know, but mine's a little different question.
What are you attempting to ask her about? What are you trying to refresh her recollection of?
I'm just trying to refresh her recollection that Sally Smith was on the treatment team.
No.
Well, that is a theory of their case. And this.
So he's going to ask Sally Smith for a legal conclusion on whether Sally Smith is on the treatment team?
I think, he was using this to refresh her recollection, if she needed it, and I don't know if she needs it, as to whether Dr. Sally Smith was trying to get a whole bunch of providers together to talk about Maya Kowalski's future care.
Yeah, and I guess, not to turn this into a long didactic lecture, I thought the only thing that we were responsible for Sally Smith for her parent agency was any treatment that she was giving to Maya in the hospital, right? Not which her function was for this.
That's correct.
So what would this establish?
She's part of the treatment team that manages all the treatment at the hospital. I mean,
say that one email where Sally Smith would like us to get together is going to establish that Dr. Katzenstein and Dr. Sally Smith was part of the treatment team for the entire hospitalization. For Kathy B. For Kathy B.
The answer is this seems highly relevant, Mr. Anderson, and you will be allowed to refresh her recollection if she needs it.
Thank you.
It is not in evidence.
It is not in evidence.
That's why I said to refresh her recollection.
I want to make sure Mr. Anderson heard.
And just so we're clear, do you have this document in paper form so we don't have to worry about me turning off the
Right here.
turn off the public systems and all that and the jury systems?
Until you hopefully will just say, yes, Sally Smith was on the team. I won't need to.
Yep.
Can I be heard on this just because I don't, it's what the so Sally Smith's inquiring of people at all children about Maya's future needs for the purposes of where she's going to go in terms of the dependency action, right? Because that's what's going on.
That says as a treatment team.
Right, but it says, I'd like to talk to the treatment team to figure out what Maya's future needs are, because Sally Smith's going to take that information and go to Judge Hayworth and say, all children's, per their records, shows that Maya has these treatment needs, so the cross-examination or the redirect I could have is, what do you want me to get into with this witness? All Children's doesn't direct the dependency court. Sally Smith's making her own independent.
No.
Let's blow the door wide open to all of this. It seems to me.
Again, the fact that Dr. Sally Smith was involved even before the first call was because she was consulted, right? And there is an allegation here in this complaint that Dr. Sally Smith's actions or inactions constituted medical negligence, and that the hospital is responsible. And what I think the plaintiffs are trying to show is that she's actually part of the dependency team. Now, she's wearing two different hats, I agree with you, but the hat to which she is a provider, to the extent the jury were to find that she were a provider, and I'm not here to say she was or wasn't, that's the jury's decision, that's allowable. On the hat that she is wearing as a investigator for the dependency court, that's not allowed. So this seems to be evidence that would suggest that Dr. Sally Smith was also wearing the hat of medical provider.
But under the statute, Sally Smith is allowed to consult with the medical providers at all times.
You can keep saying it. We can do this again and again and again, but I think I've been consistent on this issue that to the extent that Sally Smith is providing or appears to be providing medical care and treatment as opposed to beyond her role as a child abuse investigator, it's going to be admissible. Not the email, but the line of questioning that Mr. Anderson.
Mine's very simple. So it's the final one. I just want to make sure I'm okay on this. This is not in evidence, but it's Trial Exhibit 2277-253. We've tried to move it in a couple times. I want to use it to refresh your recollection. This has to do with Ms. Beatty. This is Debbie Salisbury's letter of November 18th, 2016, directly to Jennifer Katzenstein, PhD, in which Debbie brings to her attention the fact that there were concerns over Ms. Beatty. So maybe she'll remember it, maybe she won't, but if she doesn't, I wanted to use this to refresh her recollection.
Well, I want to be clear. For refreshing somebody's recollection, if you need to refresh someone's recollection, you can pretty much use anything. But we're not going to... Members of the jury, I've got this note, and show it to the jury as you're walking past them to hand it to...
I shall not.
Okay. And we're not going to read from it.
No. It's hard not to use some of the words, but I will not read the sentences.
Judge, more specifically concerning is that he wants to get into what's going on with the attorney for the dependency action, complaining about things happening in the dependency action.
And I don't know what specific questions he is going to ask.
Well, that's what this letter's all about.
The question would be, Dr. Katzenstein, you are aware that questions were raised about Ms. Beatty insisting about being on a lot of these telephone calls and other issues concerning her conduct. Not really. Well, did you receive any writings about that? I can't really remember. Would it refresh your recollection? Yes, it probably would. Here, having your memory refreshed, now can you tell us whether you ever received any notification there was a problem with Kathy Beatty? Boom.
From the attorney representing the Kowalskis in the dependency action?
I'm not throwing in the attorney.
But that's who it's from.
That's what's on evidence.
This is not an evidence.
To the extent the witness needs her recollection refreshed, he can use the letter. That does not mean the letter is coming in, nor does it mean he's going to be able to ask specific questions off of this letter.
But
I anticipate that if there's a question that's objectionable, you're going to object.
But just before we open this, am I allowed to could I redirect Dr. Katzenstein and say the letter complaining, the complaints about Ms. Beatty's care were coming from lawyers for the Kowalskis?
Does it matter whether it comes from Mr. Kowalski or the lawyer?
To me, it does.
Why?
Because she's getting a letter from a lawyer complaining about Ms. Beatty's conduct that were the same complaints that they were bringing to the dependency court.
Based on hearsay.
Based on hearsay. I mean,
I am being asked to rule on hypothetical questions and redirect to questions that have not yet been asked. So it's very difficult to make that ruling. All I'm saying is the witness can be shown this letter to refresh her recollection if necessary. I'm not necessarily saying that the question that he's going to ask is going to be allowed. And this letter obviously is not in evidence, nor do I anticipate it's coming in evidence. Okay. Anything else, or can we bring in the jury? Let's bring in the jury. Let's get the doctor.
Judge, the letter's still up.
Yeah, let's get the letter down, please. The letter is off the screen, and the jury is not yet in.
All rise. Jury is entering.
Okay, please be seated, everybody. Did you all have good lunch? I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And no one approached you about this case. Is that correct? And you did not see any media coverage. Is that correct? Okay. And we're now in cross-examination, and Doctor, you're still under oath.
Now, Dr. Katzenstein, you are a PhD, not a medical doctor, correct?
And Katzenstein.
I'm sorry, Katzenstein. Dr. Katzenstein, reviewing your records, it looks like you just had a couple of actual diagnoses, if I'm correct. And is it true that during this period of time, this 97 days that Maya was there at the hospital, that you were the only therapist working with Maya? Psychological therapist, that is.
Psychological therapist, to my knowledge, yes. There was a music therapist as well.
I understand. But in terms of the psychology of meeting with Maya and trying to work through that, you were the only one.
Yes.
Is that right? And you met with her approximately, 8 times, actually meeting with her?
I think in total, per my notes, 10 times with her.
Okay. But were some of those just for like a minute or two?
No, I have 10 notes with documented time.
Of 20 minutes or 25 minutes, is that right?
Correct, or more.
Okay, one or the other.
20 minutes or more.
Okay, well, it says 20 minutes on all of them, does it not? Specifically, except for one that says 25 minutes.
I have a 35, a 21, a 25, a 25, a 20, 20, 45, plus a 60 initial.
Okay, so you got 60, 45. So all in all, did you ever total up approximately how many hours you had?
I did.
And how many hours?
In total of time that was documented, in which I did not document time on 7 notes, I had 5 hours.
5 hours. And this was over 97 days?
This was over the period of I believe less than that, because I wasn't consulted until the 10th meeting with the family on the 12th.
So, take a week off, maybe 90 days, 3
90
months?
days.
All right. 5 hours. All right. So if the jury were to go back and take a look at the billing records from Aetna, then they should really only see approximately 5 hours of your time for counseling. Is that right?
I haven't seen my billing records, and I don't always bill based upon time, because certainly some minimum amount of time would not have reached the standard to drop a bill.
Well, you billed under certain insurance diagnosis codes, did you not?
I would have billed CPT codes, which are the billing codes.
Right. And if we could pull up, if this...
It's in evidence.
Say again?
It's in evidence.
All right, and it's in evidence. Insofar as what you actually billed for, would you agree with me it was complex regional pain syndrome?
I would have to see the bills. I don't know.
Sure. Would it refresh your recollection to see an email back from Aetna, the health insurance carrier, about the specific diagnosis code you used?
I would have to see the bill that was dropped related to the note, because that changes with the insurance carrier.
I understand. But we're talking about, and in evidence, are the billing records from Aetna Health. You understand that?
I don't see them.
That's okay. And so what I'm asking you is, insofar as what you billed under for Aetna Health, will you agree with me it was complex regional pain syndrome?
I don't know. I'd have to see the records.
All right. Would it refresh your recollection at all to see an actual message back from Aetna to, in this case, Beata Kowalski during this time, which sets forth exactly what code and what it meant?
If you could provide the CPT code, that would be helpful.
Sure. Can we bring up then what's in evidence is Trial Exhibit 2438-003? And I recognize it's kind of hard to see, but if we could focus in a little bit on that code down there. It's like in the center. G90, is that a 90.50?
Unfortunately, this is still the ICD code. It's not the CPT code.
Okay, and what's the difference?
The CPT code are the billable types. So my billable CPTs are the way that you define what you did during that session, whereas the ICD code is what's presented here, and that's a specific diagnosis code. So there's two pieces to each bill, an ICD code and a CPT code. So you need the diagnosis plus what you did in combination.
So here, do they not specifically address Jennifer Katzenstein and a specific charge for professional services on a specific date, that being October 13th, 2015?
I see that, but I would have to see what I billed, not what the insurance company is passing along.
All right, so you think it's an insurance company's mistake that it's complex regional pain syndrome?
Objection, argumentative.
Sustained.
I can't know without seeing what I billed.
Did you ever check that?
I did not check that.
All right. And so are you telling the jury then if they go through it and they see a bunch of G90.50 on the Aetna billing that is not complex regional pain for you?
Objection, foundation, argumentative.
Sustained.
I would have to know.
Maybe you don't need to answer that question.
I'm just trying to figure out how, looking at the billing, the jury would figure out how much you actually billed Aetna for your services, particularly for complex regional pain disorder.
Yeah. So to understand billing, what you have highlighted here is an amount that would have been associated with the CPT code.
Okay.
So in order for me to understand what I had billed and recall what I had billed from that time, I would need to see both numbers, that ICD code of the diagnosis and the CPT code of what services I billed.
That's what you would need, correct?
What I would need per what I entered into the electronic medical record.
Through the course of this, then, I see that you really had one reoccurring diagnosis here, and that was psychological factors affecting other medical conditions. Is that right?
Yes.
And that was the diagnosis you traveled under?
That was the diagnosis that I gave at the initial visit with the family.
And that stayed as your number one diagnosis throughout your records, did it not?
It maintained to me that there was a psychological component to an ongoing medical condition.
Well, right below that on your record, you say rule out somatic symptom disorder as per medical record. Is that right?
I don't have the note up, but yes, I believe that's correct.
And when you say rule out, that means you've ruled that out, correct?
Rule out means it's something that you're keeping on your radar. This is my first visit with the family. I spent 1 hour with them, and oftentimes it takes many visits to determine what the appropriate diagnosis is. So when you leave a rule out on your diagnostic list, it means that it's staying on your radar as something to think about.
All right. And so I never saw anywhere in your records where you ruled out that Maya was not having CRPS as a primary diagnosis. Is that true?
That would be beyond my scope as a psychologist.
Well, in your records it continuously says CRPS is one of the diagnoses. Did you ever generate or receive any of the medical records that said we're ruling out CRPS?
Objection, compound, foundation, the state senate.
Overruled. You can answer that question.
I did not, although it would be beyond the scope of my role as a psychologist to make that determination.
And you had to rely on others, right?
Correct.
Okay. And if they come in and say she has CRPS, then you're going to rely on that, right?
I rely on the medical team with me.
And so when you're talking about ruling it out, now once you have the diagnosis here and it remains CRPS, now you're in a position to rule out somatic symptoms to the extent you haven't already. True?
I'm sorry, I don't understand.
You don't understand?
I don't understand what you're asking.
Well, if you're trying to rule out something based on the medical condition, because you don't know it, right? Or you're not sure of it.
Correct.
And then you become sure of it or you know it, you can rule it out, correct?
I'm not sure at this point in time if I was sure or not sure of it.
Of the diagnosis of CRPS or ruling it out?
Either one, it wasn't within my domain to do that.
In any event, psychological factors affecting other medical conditions, that is a distinct and different diagnosis than factitious disorder or conversion disorder, at least under DSM, right?
In the DSM-5.
And do you accept DSM-5 as authoritative source for
At
you
the time
in your
that
profession?
at the time that it was current, yes.
All right. So now, this involves factors with, strike that. So now, the other things you found were that there was no, from the time, the history you took, and the time you spent with Maya and her parents, you did not find the parents having disruptive behavior or oppositionality or harm towards others, did you?
During my first visit with the family, they were cooperative and engaging.
And they continued to be cooperative and engaging, did they not?
I only spoke with Dad after that time, and he continued to be cooperative.
Well, Mom was also invited to, or should have been invited to go to the cognitive behavioral therapy.
Objection approach.
All right. And
The objection is sustained.
so you did receive some notice that Kathy Beatty was potentially a problem in supervising, if you will, Maya, did you not?
It has been discussed.
Say again?
It has been discussed, yes.
You did know?
Not
was
at the
raised.
time, but after.
Well, did you know by, say, mid-November?
During the hospitalization, I wasn't aware of any concern.
Okay. Would it refresh your recollection to see a writing directly towards that?
Yes, please.
May I approach you?
Yeah, show it to Mr. Shapiro first.
Again, I just ask for projection.
You can review it, but don't answer anything right now.
Have you had the opportunity to refresh your recollection, ma'am?
I have.
And would you agree that as of
Ma'am,
November?
At this point, turn it over.
Oh, sorry.
Thank you.
Thank you. And at this point, would you agree that you were advised there were some problems with Kathy Beatty being involved?
Per this letter.
Object again to, objection foundation.
Overruled. You can answer.
Per this letter, it indicates that there were concerns about Kathy and the supervised phone calls.
You did or did not?
I'm sorry?
You did or did not?
I just read that in the letter.
Okay, so you did know?
I thank you for refreshing my memory. I apparently knew on the date that I would have received that letter.
Okay, and that's all I was asking. And so now, following this, do you have any memory of actually checking to see how well things were working out between Kathy Beatty and Maya Kowalski?
There were team meetings and conversations, and I hope that I would have brought this up, but I don't have recollection of it specifically.
And did you ever do any background to check out whether Kathy Beatty was an appropriate person to be around this child?
Object your Honor approach.
I'm going to overrule the objection. You can answer the question.
Can you ask the question again? I'm sorry.
Sure. Do you recall ever looking into whether Kathy Beatty was the appropriate person to be supervising Maya Kowalski directly?
Not at that time. I did not provide the staffing to social work at that time.
All right. And would you also agree with me that Sally Smith, around this time, was part of the treatment team that was treating Maya Kowalski?
Objection foundation correct.
Overruled.
Sally Smith was an external provider contracted by DCF.
That's not really my question.
She was not
ma'am.
treating the patient in our organization, to my knowledge.
She was, I didn't catch it. She was or was not part of the treatment team?
To my knowledge, she was not treating the patient in our organization. She was part of DCF.
So does that mean she was or was not part of the treatment team at Johns Hopkins?
DCF is a separate entity, and she was contracted separately.
All right. Would it refresh your recollection to see an email regarding this from Friday, December 9th, 2016 to you?
Yes, please.
Can I approach you, Honor?
You may, but show Mr. Shapiro first.
Does that, I'm sorry, go ahead and read.
Okay, you can turn it over once you're finished
Oh,
reading.
thank you.
Does that refresh your recollection as to whether you or others thought that Sally Smith was part of the treatment team for Maya Kowalski?
Objection speculation foundation.
Well, also stated as it relates to or others, what her knowledge is what.
To her knowledge.
Or you said or others, so I'm sustaining it because you said or others.
Oh, I'm sorry. That she thought, or strike it. Did you then, having your memory refreshed, remember that Sally Smith was indeed part of the treatment team?
I do not recall this email. It was quite a bit of time ago, but in this statement, she was gathering the treatment team. I don't know that that makes her a treating member of the team.
So she was just gathering them together.
Have a conversation about what's been happening and gathering information.
All right. And so as of, let's see, it would have been, you started really treating on October, 8th, 9th, 10th, 11th in there?
The consult received on the 10th. The first time I was able to meet with the family was on the 13th.
All right. And so as of the 13th, your diagnosis was the same thing we talked about, the psychological factors affecting other medical conditions. Is that right?
Correct.
And that diagnosis in and of itself does not present a danger to the child, does it?
That
Objection again. I need to approach on this.
Mr. Anderson's going to re-ask the question.
Well, that's going to be very interesting to do. Would you agree with me that at this point, the time you reach this diagnosis, psychological factors affecting other medical conditions, that diagnosis, the diagnosis that you reached, did not involve any danger to Maya Kowalski?
Same objection, Your Honor, and same record.
Overruled. You could answer that question.
So in that case of that diagnosis, that is specific to the patient. And at that point in time, what I was seeing was stress and anxiety that were exacerbating the symptoms of pain.
And at that point, based on the record that you mentioned, with Maya not being in any, now I got to figure out if I can ask this question. And finally, you testified previously about potential rewards for Amaya, I guess, cooperating, trying harder?
For working with the behavior chart where we would set clear goals.
All right. Well, in point of fact, she didn't receive a single one of those, did she?
I honestly do not remember.
Never checked to see whether she actually got a henna design on her hand or a coloring book, Hopkins, makeup, any of those?
I believe she did receive some things. There were a number of coloring materials, Shopkins, and at the time, again, before COVID, we had people coming into the hospital to do haircuts and be able to do those types of things. So I can't say with certainty that she did or did not receive them, except for the gelato. I do remember the gelato.
You never saw any of those things except for the gelato.
I saw the gelato.
Dr. Katzenstein, I think you mentioned earlier from your perspective, Dr. Sally Smith was conducting her own investigation separate and apart from what you were doing at All Children's. Is that fair?
That is correct.
Your medical evaluation, let me clarify, your neuropsychological evaluation was independent and your own, true?
Yes, that is true.
Okay. That's all I have at this time, Mark.
Anything based on those couple of questions?
From the plaintiff, no.
Members of the jury, do any of you have questions?
They're already packed.
You know what to do to get a break.
Okay, do not discuss this case. Do not,
All rise. Jurors exit.
do not discuss the case. Do not do any investigation. Receive no information. We'll see you in a little bit. It's okay, the birthday girl gets to sit down. Okay, please be seated. Okay, members of the jury, want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you did not receive any information. Is that correct?
Correct.
And has anyone approached you about this case? No. Have you seen any media accounts? No. Okay, members of the jury, I'm going to be able to ask almost all of the questions. Dr. Kastenstein, I said that properly.
That was
right?
perfect, thank you.
The jury has a few questions.
I see.
What was the date of the letter regarding Kathy Beatty?
Oh, thank you for your questions. I have them up here. Am I allowed to refer?
You can look, just tell us the date.
Okay, November 18th, 2016.
And was that letter directed to you?
It is addressed to me, yes.
That's all I'm going to be able to ask as to that. Next question. Why was Maya's statement about being afraid of the scary movie she saw in Mexico significant?
Yeah. Thank you. That's a really good question. When we were doing that guided journaling, I asked her about her biggest fear. And she's in the hospital right now, separated from her parents, and in her perception, quite a bit of pain, and receiving PT and cognitive behavioral therapy with me. And when asked what her biggest fear was to write about, she chose the movie The Ring.
Next question. Why did you not make... Okay, let me reread it again. Why did you not make an appointment to see Maya instead of just showing up?
Oh, this is a very good question because it's how our lives function when clinically you have a full outpatient schedule and you need to be in the hospital. So think about when you go to a doctor's appointment and your doctor is back to back to back all day long. I'm trying to find time, honestly, to squeeze over, to run over to the hospital to be able to do the consultations that need to be done for my census, and then get back to my desk either for my next patient or meeting or to follow up on clinical work. So when you're balancing the two of those, sometimes they're unpredictable. And if you have a no-show, then you have time to run over, but that can be challenging. Sometimes you can call over and say, is Maya available or are parents there? But then also sometimes when you come over there, you're more likely to even find them because they might run to get a cup of coffee or something might be happening. So you're balancing trying to track the family down versus everything else that you have ongoing outpatient.
Next question. Would you expect a medical doctor to own a DSM?
Oh, that's another great question. A psychiatrist is a medical doctor, and sometimes that can be confusing because I'm a psychologist, which means I have a PhD, and a psychiatrist would have an MD. So yes, I would expect an MD to have a DSM. However, not all physicians, not all MDs and specialties would I expect to have that, and many I would be very surprised if they did.
What is the current DSM?
The current DSM is the DSM-5 text revision. So the one that was current at the time of this admission was the DSM-5, and since that time there's been an updated edition of the text revision. It says DSM-5 TR after it.
What was, or when was it released, the DSM-5?
Gosh, that's a very good question. Probably 2.5 years ago, 2 years ago. I don't know exactly, but it came out during COVID, which is really just a time. No.
The question is, wouldn't allodynia make an henna application painful?
I can't speak to that. I personally have not received henna, so I can't tell you how it feels or it doesn't feel, or what someone's perception of pain might be in that situation.
Why did Nemours require an IQ test to transfer?
That's a great question as well. Our transfers, when we go to another organization to ask for a patient to be accepted, have different requirements, and so I can't speak to why Nemours would require that, but I was asked to do it because I make the assumption that that's part of the criteria they're asking for in considering the transfer.
Do you know, with your background, does CRPS have a component of stress/anxiety?
For CRPS and other pain conditions, there is often stress and anxiety, and that is why cognitive behavioral therapy and working with a therapist or a psychologist is a key component of the treatment plan.
How many children with CRPS have you treated or been involved with their treatment at the time you were involved with Maya's treatment?
At the time of Maya's treatment, I had no other patients with a diagnosis of CRPS.
You were asked by counsel if the Kowalskis asked to leave the hospital prior to meeting with you. Would you know that if you had not met with them?
I may or may not know that in a typical situation. However, in this case, I was not aware of that.
Who was in charge of giving Maya the reward she earned, and when did that go into effect? What date?
So unfortunately, per my recollection, we weren't putting the behavior chart together with the clear goals as quickly as we would have liked. And so typically in that situation, our child life team members, along with myself and physical therapy, would get together to discuss that. But we weren't able, to my recollection, to put that together and put it in place.
At one point in your written report, you mentioned that Maya, quote, was in an altered state of mind, end quote. Is that correct?
Oh, I would have to see that note. Altered mental status, I believe, is the words I would have used.
I also believe you said that was when Beata was in the room. Is that correct?
In my first time meeting with the family, that is when she did not participate in the session, and I did note in my mental status that she had an altered mental status, and Mom and Dad were both present.
Okay. Did you say that Beata was answering your questions to or about Maya, and Maya was, well, in a different state of mind? The term you used, quote, altered state of mind, end quote, sounds a bit Twilight Zone-ish. Could it be that Maya knew her mother could best answer in a more knowledgeable and coherent way than Maya could as a young child, so Maya was just occupying herself in, quote, kid things, end quotes, while the adults talked, and was not in, quote, in an altered state of mind, end quote?
It's a great question. In many cases, when I am working with children in this age, they let their parents answer because their parents have typically answered or because their parents have the words and the information. However, in this case, I noted it because she had been conversing with me previously and was not engaging. And the altered mental status means that she didn't seem to be present as much with us. And so even if I have a patient who is coloring or playing a lot of times with toys that we have in the room, then a lot of times the kids are still listening and present with us.
I recall you stated that you worked for All Children's Hospital. Is that correct, in 2016?
In 2016, I was employed, yes, by All Children's Hospital.
There were a number of meetings that seemed to be missed because Maya was elsewhere. This therapy being important, was there any reason why other staff had Maya out when she was to see you?
Thank you. It's difficult to manage everyone. Again, our physical therapists are coming in when they have time and they're managing a significant caseload. I'm coming in as I have time. So it's a great opportunity, of course, to make a schedule that everyone can abide to, but unfortunately it doesn't always work out that clearly.
Okay. Were these meetings on a patient schedule or calendar?
No, there was no patient schedule or calendar, to my knowledge or recollection.
And I apologize, I didn't finish the rest of the question.
Sorry.
No, I thought that was the end of the question. Let me just re-ask it. Were these meetings on a patient schedule or calendar so staff at All Children's Hospital would know to have Maya available?
That's a great question. That's something that we really worked towards. Unfortunately, at that time, we didn't have a really clear system in place to be able to do that, and we continue to work on that even to this day.
Any follow-up?
Just briefly, Dr. Katzenstein, on the very good question about trying to get a regular therapy session. Was that one of the reasons why you were advocating or recommending to the Kowalskis transfer to Nemours?
Yes, it was difficult for us. We did not have a comprehensive pain treatment program at that time that would have scheduled appointments and have OT and PT and cognitive behavioral therapy coordinated, and Nemours was doing that, and they still do it really beautifully.
Thank you, Your Honor.
At that point, Nemours did not have an inpatient CRPS treatment program, did they?
My understanding at that time, they had an intensive outpatient program.
It was outpatient. They did have an inpatient psychiatric program, did they not?
I do not know. Currently, to my knowledge, Nemours does not have inpatient psychiatric treatment.
All right. When you said an altered state of mind, the fact that a child doesn't respond to you, that doesn't warrant a diagnosis of altered state of mind in and of itself, does it?
There is no diagnosis of altered state of mind.
Because you don't have any answers from the child, correct? The child just doesn't answer.
I'm sorry, can you ask?
Wasn't your concern that the child was not responding to you as well?
My concern at that first appointment was that Maya was not engaging as she had previously.
Right. She was not engaging with you, for instance, because she was happy to see her folks. That could be a reason, true?
That could be one reason.
Right. She could be not responding to you because she was tired.
That could be a reason.
She could not be responding to you because maybe she didn't trust you as an agent of Johns Hopkins.
All of these are options, reasons why. However, in that situation, she had previously spoken with me.
It could be that at the time she was on so many different meds, it was hard to tell exactly what her base level was. True?
I can't speak to that. I haven't seen her medications, and I'm not a physician.
Well, hang on. You didn't look to see what medications the child was on at the time you were examining her?
It would be beyond the scope as a psychologist to be managing medications.
I'm not asking about managing medications. I'm asking you whether you were aware, for instance, that Maya at that time was on tramadol.
I would have to see the notes.
Valium.
I would have to see the notes.
Ativan.
The objection, lack of foundation.
Sustained.
Is it true that any one of those have significant psychological potential impairments?
I can't speak to that. I'm not a physician. I do not prescribe medication.
And you don't think it's important to know whether the child has got multiple mind-altering substances in their system at the time you're interviewing it?
Objection, foundation.
Overruled. You can answer that one.
I was interviewing her. She had been in the hospital for a period of time, and she had been interactive with me.
But you had no baseline because you never saw her without all of those drugs in her system. True?
I can't speak to the days prior in which I did engage with her.
Any further questions?
Just very briefly. If you could bring up Joint Exhibit 1001-3826. And for the sake of expedience, Dr. Katzis, I'll represent to you this is your note of October 13th when it comes up. Okay. 10013826.
Sorry about that. I had to push the button. That was all me.
So I need 10013826, please. And then under the histories, do you see this? I just wanted to see if you could clarify the jury. There was discussion of what terms you used. Can you describe what you meant by altered mental status in this note, Doc?
I wrote altered mental status. Maya's pain and current emotional status impacts her ability to report. Her parents provided history described below.
In previous or subsequent interactions with Maya, were you able to determine that she was very interactive and conversant regarding her medical care?
Yeah.
So is what you're describing here a change from when her mom's in the room versus when her mom is not in the room?
Objection, leading.
Are you just, let me just ask you, based on your observations of Maya, did you notice a difference in Maya's interactive level depending on who was in the room?
On this date, I noted a difference. I did not make assumptions beyond pain and current emotional status.
I appreciate your time. Thank you.
Anything further, Mr. Anderson?
No.
We've got some more questions. How many do we have coming? Okay, we'll just stay here. Doctor, just to clarify, the Hopkins and gelato treat you testified Maya received were not part of the reward chart you created with her because it actually never got put into place.
That was my understanding, that it didn't get put into place, but also our child life team is pretty fantastic and they knew things that she would like, so they may have just been things that they got her at that time. But to my knowledge, that behavior chart did not get put into place.
Do you know where the Hopkins and the gelato came from?
I do not. We have a number of very generous people who donate to the hospital, and there are rooms and rooms of toys. And so I'm assuming that it came from one of those places.
Thank you very much.
I have one question.
Sure.
This is on Joint Exhibit 1001 3759. 3759. I'll represent to you, Doctor. This is your note from December 20th. And these were the potential rewards that you were setting up for Maya. And was this part of your plan of incentive behavior?
Yes.
And I just think as the jury had the question, this would have been about 3 weeks or so before Maya was discharged from our children's.
Will you remind me the date?
Okay, yeah.
I trust you. Yeah.
This was towards the end of her hospitalization.
Okay. Yes, this was in the second half to later third.
That's all.
In truth, you have no idea where the Hopkins came from.
Is that the question?
That was my question, and she said, I think no. She did not.
I said correct. I didn't know exactly where they came from.
May I ask one more question? Last one, I promise. Was the list of rewards, those are what Maya had conveyed to you that she had wanted?
Yes, they were directly from Maya.
Okay, thank you.
May this witness be excused at this time?
Yes, sir.
Yes, but still under.
You need to remain under subpoena, which means you can leave for today, but you might get called back.
Okay, so nothing, no media.
I'm sorry?
No watching anything, no
watching.
Okay, thank you.
Defense, your next witness, please.
That was going to be a few minutes.
You're suggesting this is a good time for a break?
Yes, sir.
Members of the jury, let's try to keep this to no more than 10 minutes. Do not discuss the case amongst yourselves. Do not do the investigation and receive the information.
All rise. Jurors exit.
jury's out of our presence. Any issue before we go on break?
Madam Court Reporter, do you have the question that Mr. Anderson asked marked? Or no? It was, anyway, we can find the transcript and deal with it later on, or nothing from the defense.
Judge, I'm going to clear. You know, Dr. Hannah's cross-references
Okay. So we're down to 9 minutes for our break.
Okay.
And just to take-
Nothing
We're
further.
in recess.
Cause a recess.
Please be seated. For our planning purposes, Wednesday will be another day of, we have to hit the 12 o'clock mark. But I think that's as I sit here right now, that's the only other day this week that I have to hit a specific time. Anything else before I bring in the jury?
Don't believe so, Your Honor.
No complaint, Mr. Your Honor.
Let's bring in the jury.
All rise. Jurors at jury.
Okay, please be seated. Members of the jury want to confirm while you're away you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct? And no one approached you about this case, is that correct? And you haven't seen any media coverage? Mr. Hunter, your next witness, please.
Defense calls Dr. Richard Elliott.
Dr. Richard Elliott.
Raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but?
I do.
Okay, please, court. Tell us your name, please, sir.
Richard Andrew Elliott.
And what is your occupation?
I am an anesthesiologist.
Okay. And by whom are you employed, sir?
Johns Hopkins, all children's specialty physicians.
Okay. Would you tell us where you got your undergraduate and medical training, please, sir?
Certainly. I am from Ohio, and I did a rather unique program, a 6-year BSMD program, where I did my bachelor's degree and my MD in 6 years rather than the traditional 8, and that was through Kent State University in Ohio, as well as a medical school there called Northeastern Ohio Medical University.
Okay. And you got your MD from there?
Yes.
And where did you go after that?
I moved to Baltimore for my postgraduate training. I did an internship at a MedStar hospital called Union Memorial Hospital in Baltimore, and then I did my general anesthesia training at the Johns Hopkins Hospital there with the School of Medicine. And then I subsequently spent extra time doing pediatric training for an additional year after that.
Okay. And when did you complete so you did a residency and then a fellowship?
Yes,
And when did you complete your fellowship training?
I finished my fellowship in 2003.
And fellowship was in what field?
Pediatric anesthesiology.
And did you become board certified in any specialty?
Yes, I have 3 board certifications currently. I'm board certified in general anesthesia, pediatric anesthesia, as well as medical acupuncture.
Okay. And where have you, tell us where you went to work after you finished your fellowship.
So after fellowship, I actually was in private practice for almost 2 years. I was in practice around D.C. At a community hospital there that I worked in conjunction with D.C. Children's for about 2 years. And then I wasn't doing as many children as I would like at that point. And so I ended up going back to Hopkins in 2004, end of 2004, really like December of 2004, to join faculty there doing both anesthesia and pain.
Okay. And how long were you at Johns Hopkins in Maryland?
I was there until December of 2013. That's how long. So basically, about almost 10 years, like 9 years.
And where did you go in 2013?
In 2013, I moved down to St. Petersburg and joined the group at All Children's Hospital.
Okay. And what is your role? Well, what role did you undertake at All Children's Hospital when you moved down?
So I'm an employed physician there, but my roles included really recruitment to do help enhance their regional anesthesia and pain management program was my main reason for going there career-wise.
Okay. And what do you do at Johns Hopkins today?
So today I'm currently the director of inpatient pain management, and I also so I split my time between the OR as well as inpatient acute pain management, and I also do outpatient chronic pain management.
Okay. And is that what you were doing in 2016?
Yes, except for we had not started. We were working on getting our outpatient clinic up and running at the time. It was not active at that time.
Okay. So in 2016, tell the jury what the scope of your practice was and what your professional activities consisted of.
Sure. So obviously my care for patients revolved around the perioperative period or peri-procedural period, putting kids to sleep and making them comfortable for surgery or other things, MRIs, other diagnostic studies, as well as managing pain on the inpatient side. We have a pain service that's a consulting service that we staff with both physicians and APPs, meaning advanced practice providers like nurse practitioners or physician assistants that we work to help manage pain in all its forms for hospitalized patients.
Okay. Now, tell the jury, if you would, what the scope of your practice is or was in 2016 in managing inpatient chronic pain consultations.
So back then, and as I say, we get a fair number of chronic pain patients in the hospital, whether they've had surgery or they've had other things going on. We get involved with their care. In most of the time, we're consulted by the primary service, meaning the pediatricians, to help with that.
So that would be pediatricians or intensivists?
Surgeons, intensivists, anyone that would like our advice on managing pain for a variety of reasons, acute and chronic pain.
Okay. Now, you mentioned that you now have a outpatient chronic pain practice.
That is correct.
Tell the jury about what that is all about.
Yeah, so just like any physician, we have a clinic in the outpatient setting where we make appointments with patients, and they can be referred to us to help manage their pain in an outpatient setting. And a lot of that also involves, we have a multidisciplinary pain program. So all our patients that come to us are met not only by one of the pain doctors, of which we have 4, they're also met by our pain psychologist, and they're also met by our physical therapy colleagues. And we meet with the parents as well as the child and do a 2-hour visit for our first visits. As well as then we do follow-ups from that, as well as follow-up appointments from patients that we've seen in the hospital that need further care that we manage.
So, but to be clear, that outpatient pain clinic was not in operation in 2016.
That is correct.
When did y'all start that?
I believe it was, don't quote me on this, but I believe it was around 2018 or 2019 that we really got that fully established. Somewhere in that. It was definitely not at that time, but probably at least a year later or so, but we were working on the logistics of that.
So as of 2016, there was not an outpatient chronic pain clinic per se.
That is correct.
At Johns Hopkins All Children's. Is that right?
That is correct.
Okay. But you were consulting on chronic pain patients on an inpatient basis.
That is correct.
Okay. And as part of your experience in training up to that point, had you had any experience with chronic regional pain syndrome?
Yes, of course. Throughout from day one of my training, throughout my career, from the time I finished my training in 2003 till now, and which has been 20 years, it's hard to believe. I've managed patients with CRPS. It's not a common condition in children, but certainly had and I interacted with in Baltimore. We had Kennedy. We were associated with Kennedy Krieger Institute, and they had a chronic pain program there that we were associated with and involved in during my time there. So yes, I've seen that, and now we actually have our own CRPS program.
Okay. As of 2016, were you familiar with the treatment of pediatric chronic regional pain syndrome?
Yes, I was very very familiar with that, and had obviously at Baltimore taken care of patients with that, but yes, well versed in that. Yes.
And what does the treatment of pediatric chronic regional pain syndrome consist of, or what did it consist of as you were familiar with it in 2016?
Yeah, it really hasn't changed in that time period, but the basis for treating pediatric CRPS really revolves kind of around functional restoration, meaning physical therapy, occupational therapy, as well as what we call cognitive behavioral therapy, which is a form of psychological intervention to name it. So those are pretty much the standard treatment for pediatric CRPS to this day at the children's hospitals throughout the United States.
Okay. In your chronic pain practice, did you also have occasion to encounter pediatric patients who were suffering from functional neurologic disorder or conversion disorder?
Yes, for sure. It's not uncommon for patients with CRPS to also have either have a comorbid conversion disorder or be misdiagnosed with one or the other. But it's not uncommon to have functional neurologic disorder with CRPS.
And how does strike that. As of 2016, what was the treatment with which you were familiar of pediatric conversion disorder or pediatric functional neurologic disorder?
The treatment is very similar to that of CRPS. It consists of very much, returning patients to function. And it's important to highlight that, whether it's CRPS or functional neurologic syndrome, we believe patients and they have true pain and issues. So the treatment really is the same for both of them, is really physical therapy, occupational therapy, and then cognitive behavioral therapy is the treatment for both of those conditions.
The treatment, strike that, conversion disorder, functional neurologic disorder, both of those are psychological factors, psychiatric conditions. Define what those are for the jury, if you will.
Yeah, the functional neurologic disorder or symptom disorder is defined in the DSM, which is really, considered a psychiatric diagnosis. However, when we see patients with that, we don't treat them any different, and we believe that they have pain, and we don't, say that it's in their head and this, and so it's treated the same. And we focus on that their pain is real, whether it's CRPS or functional neurologic disorder, and we move forward with those interventions and support those interventions, the cognitive behavioral therapy, the PT, OT, to really get them back to functioning and reintegrated into being a normal kid.
So can you give the jury some idea of what this physical therapy and occupational therapy that you're describing for CRPS and conversion disorder, what it consists of?
Yeah, sure. So it's important to understand that patients with whether it be CRPS or functional neurologic disorder, really the nature is that they want to avoid moving the extremity, avoid that pain, but the data in pediatrics shows that that's actually the wrong thing to do. That what happened in a lot of these, that the way the brain is firing is it perceives pain or other issues that aren't really there, and in order to kind of get that off switch, for lack of a better word, that off switch on again, you must do progressive physical therapy. And what I mean by that is you start very, very slow, and then basically work with them and increase that to get that extremity or what they need. Most often with CRPS or functional neurology, we're dealing with extremities. They need to use it. They cannot avoid to use it, because you'll never get that way your body works. Those way your body works, that on switch won't be turned off and start functioning normally until you do physical therapy with that. And there are actually MRI studies validating that, looking at kids.
Protection, bolstering,
Sustained.
Can you talk about what?
Moves and request for instructions, strike.
The jury will disregard the comment about the studies.
Can't talk about what the literature shows.
Sure.
Just talk about what your experience and
Okay.
your training has been.
Okay. No problem. So we do see that really, with support of both the physical therapy, occupational therapy, and with the cognitive behavioral therapy to deal with the stressors that go along with these conditions of missing school, not being able to participate, brings these kids most often to remission.
And when you say the focus is on function, what do you mean?
Well, a lot of times, and we're being honest, that in pediatric CRPS or functional neurologic disorder, functional reintegration is very, very important, meaning trying to get the kids back to school, trying to get their social activities up, doing things. And so a lot of times in pediatric CRPS, functional restoration will often precede pain reduction, meaning that getting them back to lives that they in those things in their lives, whether it be school, social, other things, is very important in progressing them to having that reduction in pain.
Okay. Now, is there a role for medication, for pharmacology, specifically ketamine, in the treatment of pediatric CRPS or conversion disorder?
So the treatment for it is as I shared. However, we do believe that medications can be used to facilitate some of those things, meaning we do give medications to help facilitate physical therapy in terms of helping with pain reduction in order to participate in those endeavors in that. In particular, ketamine, we don't routinely use ketamine for those endeavors, especially on the outpatient setting. We do use ketamine for low-dose ketamine for the treatment of some pain conditions, mainly as an inpatient.
Okay. And when you say low-dose ketamine, what do you mean?
It's described at what we call sub-anesthetic doses, meaning doses that are way below anything that we would give for, say, surgery or sedation for other procedures or anesthesia.
Turning, perhaps prematurely, we need to go back here, but turning to this particular case, how did you first get involved in the case of Maya Kowalski?
So, my first involvement was, I believe I was on vacation. I received a phone call from one of my colleagues about this, just had I ever really seen doses as such, meaning the doses, the high doses that Maya was receiving. And so my colleague reached out to me, most likely because I had the most experience with pain and was working on starting our chronic pain clinic, and was just wanting to understand and see my thoughts on these very large doses of ketamine that were reported to be given.
And were you given an understanding at that time? Who called you? Do you remember?
It was Dr. Dolan, my colleague.
Okay. And were you given an understanding at that point of what level of ketamine doses the patient was being treated with at the time that she was admitted to the emergency room on October the 7th, 2016?
That phone call really just was in regards to what I recall, the doses that she was receiving as an outpatient at Dr. Hanna's office.
And did you get an understanding of what doses were being used, what was being given?
Yeah, it shared with me the doses that were being
Objection, hearsay.
Sustained.
Offered to prove what he was told, Your Honor.
Sustained.
Did you acquire an understanding of what doses Dr. Hanna was using to treat Maya Kowalski with ketamine?
Objection, still hearsay.
Well, that question he can ask.
My colleague shared with me doses that were administered.
Objection, it's hearsay. Move to strike.
The answer stands. Your next question.
And did you, well, strike that. What was your reaction to the volume of ketamine this young lady was being given?
I was quite surprised and shocked at the amount of ketamine that was reported.
And why was that?
Because they were way higher than any doses that I had ever seen given to a child.
Okay. And now, at that time, were there certain guidelines in effect at Johns Hopkins All Children's Hospital regarding the use of ketamine in pediatric patients?
Yes, we have guidelines, especially for pain management. We have a policy that we have for the use of ketamine for pain, which is, again, as I shared, sub-anesthetic doses or lower doses that we will use on inpatients to help with pain.
And the doses with which you became familiar that were being used by Dr. Hanna, how did those compare with the doses that were in the guidelines at Johns Hopkins All Children's?
They were over 50 times higher than anything that we would recommend.
Okay. You mentioned something that we need to go into a little bit. You mentioned sub-anesthetic doses versus anesthetic doses. Can you make that distinction for the jury with respect to ketamine?
Sure. So ketamine is FDA approved as a general anesthetic, and we do use it to induce general anesthesia in pediatric patients. And so we use that as our benchmark. So when we say sub-anesthetic doses, meaning doses that are below that we will use to treat as an adjunct to treat patients with various pain conditions. So an example would be, I would put a child to sleep with a certain dose we base everything on weight in pediatrics. So I would use, for instance, ketamine 1 to 2 milligram per kilo to induce general anesthesia. To give them pain, to use it for pain, we would use anywhere from, say, 0.07 to 0.2 milligram per kilo. So much less is what is in our guidelines for that.
And by comparison, what doses did you learn were being given by Dr. Hanna?
Those were, if you when I did the math, it was up to, if you break it down by hour, it would be 25 milligrams per kilo per hour in some instances.
Now, you've told us that you got this phone call about Maya Kowalski's case while you were on vacation, off service. Did there come a point a day or so later when you became involved in her case on the job, so to speak?
Yeah, I believe when I came back from vacation, I was the doctor that came on service. We rotate; it's very normal. We rotate weeks on the pain service as the doc. So I came on the following week, following her admission. I believe it was the 10th, October 10th, that I came on service.
Okay. And at that time, were you the primary pain management anesthesiologist on her case?
Yes, that is correct.
Okay. And can you describe for us, if you need to look at your records, you certainly can do that, but can you describe for us what your evaluation and treatment of Maya Kowalski consisted of on that first day, October 10th, 2016?
Yes, certainly. It was very typical of my routine in that whatever patients we have on service from the week prior or the weekend, I usually take a look at their charts and review the records, and then at some point during the day, I will go and see them and see and examine them, and that's a typical. I believe in the afternoon that day, I was when I was able to go see her, and I met, I believe, Mr. Kowalski on that day, and really just took the time to have him share with me Maya's story and spend a fair amount of time listening to him, as well as sharing our thoughts that day as well.
All right. And at that point on October 10th, I believe that would have been either Sunday or Monday, what was the treatment plan in place for Maya Kowalski?
So the treatment plan had kind of been to give her several days of modified infusion of ketamine, and this is all in the ICU with ketamine, as well as another medicine called dexmedetomidine, and then begin to come down on those slowly in the ICU, watching for any issues, balancing, helping manage her pain with any risk of withdrawal from any of the medicines that she'd been receiving.
Okay, now, of what concern was the question of withdrawal at this point?
Well, in my mind, it was still unclear, all the medicines that we were still trying to gather information, unclear of all the medicines that Maya was receiving. At that point, I had not had a chance to reach out to Dr. Hannah, and so we were being extremely cautious in terms of balancing helping Maya with pain as well as making sure that she didn't withdraw from anything, and that was also for the reason for the addition of the dexmedetomidine. It's a medicine that we use for agitation, but it also works to kind of help with potential of any withdrawal that may be there.
Now, did you have a chance that day to speak with Dr. Hannah?
I don't know if I called him that day or it was. I believe it was on the next day, October 11th, that I spoke with him on the phone on the way in my car.
Okay. And did you get a history from him of what treatment he had been giving this patient?
Yes, I called him. One, I just wanted to confirm things because I was still quite shocked at the doses that were reported, and I wanted to confirm myself. So I did reach out to him at his mobile number and spoke with him, and he did confirm that those were the doses that he was administering, and he also confirmed that he felt that they were not working either, and he sent her to us as that the doses were not working.
I'm sorry. Objection. Hearsay. Move to strike. Move to strike.
The jury will disregard the last statement by the witness.
Did you receive, well, let me ask the question this way. At this point in your care of Maya Kowalski, did you have any records from outside treatment?
Not at this time, no.
Did you, for example, have Dr. Hannah's records?
No, we did not.
Did you have any records from Dr. Kirkpatrick or any of the other physicians she had seen in the preceding year?
No.
So were you basically attempting to gather information about what you were dealing with?
Yes.
And in the ordinary course of your practice, do you typically attempt to gather that information from physicians who have referred a patient to you?
Yeah, that is our typical practice, that we like to have information so we know what studies the patients have had, what conditions they've been diagnosed with, what medications they're on. Having that information is vital to our appropriate treatment of patients.
Okay. Did you, was it your understanding that Dr. Hanna had referred the patient to All Children's Hospital?
Yes.
And in the process of doing so, did he pass along to you what his treatment had consisted of?
Yes, he did.
And what did you understand?
That he had administered ketamine at large doses, as well as doses of another medicine called midazolam or benzodiazepine, another sedative, as well as clonidine.
And how did that information impact the care that you folks were trying to formulate for this patient?
Well, the care that, again, we wanted to be ultra-conservative and make sure that again, our ultimate goal was to keep Maya safe and make sure that nothing untoward happened to her. And so I shared that with Mr. Kowalski also on that day. And our goal was really to get her basically safely through a period where we had some unknowns, and just wanted to be conservative and make sure that nothing untoward happened to her.
Okay. Did you participate in a meeting among the Kowalskis, the intensivist team, and the pain management team regarding the plan of care and the outlook, so to speak, for how Maya Kowalski's care would be managed?
I think at multiple times we presented kind of a multidisciplinary focus to help take care of Maya, whether it was in the room. I believe we did have a conference one day as well. But as is my usual practice, I'm very transparent and share thoughts and ideas in a collaborative effort with the family.
And did you have an opportunity to discuss Maya's condition and status and plan of care with both Mr. and Mrs. Kowalski?
Yes, I believe on the 10th it was just Mr. Kowalski, and then I believe on the 11th I met Mrs. Kowalski.
Okay. As best you can, Doctor, could you describe to us what that conversation consisted of in terms of what recommendations you made, what Mrs. Kowalski wanted to do, and what the ultimate decision was?
Yeah, I will do my best. Mrs. Kowalski tended to demand more interventions, more aggressive of things such as higher doses than what we were giving, potential for intubation in light of giving those higher medications, meaning putting a breathing tube in to safely give higher doses of medicine, as well as requesting things such as implantable pain pumps to help manage pain. And I attempted to share with them some of the evidence for those things and why they probably weren't in the best interest of Maya at that time.
Okay. Let me ask you about two of those issues specifically. You mentioned the question of intubation of the patient. Why would that have been suggested, and why was it a good, bad, or indifferent idea?
I believe the context was around giving her more ketamine and more medicines, just basically to put her to sleep, to get her out of pain. And in order to do that, you have to support breathing, because the higher doses of medicines can affect your breathing, and they can affect potentially affect your heart function. So those would potentially require that to support the heart and lungs. And it's just not appropriate for CRPS to put the patient in a medically induced coma. That's not appropriate treatment.
Okay. Did you have an opinion at that time that you shared with them regarding whether or not it would be in Maya's interest to dose her with higher doses of ketamine, such as Dr. Hanna was contemplating, and intubate her to do so?
You know, we did not recommend that, and we're not going to offer that, and we made that clear at that time.
Okay, and why was that? Why did you not offer that?
Because it's one, there's no evidence to support that, and the standard of care does not change.
Objection, move to strike.
Overruled on that one.
And it's not safe to do that.
You mentioned there was no evidence to support that. What do you mean by that?
Well, as I shared, the standard of care for pediatric CRPS is really functional restoration, meaning that you engage the patient in the endeavors of physical therapy, occupational therapy, and cognitive behavioral therapy. The medicines are really used to facilitate those things, not for anything else.
And what are the dangers of intubation?
Dangers of intubation, one, sometimes it can be difficult to place that breathing tube. Two, it puts you at risk for other things such as infections, pneumonia, and basically patients, in order to tolerate that breathing tube, require additional medications and things that put them at risk for things, changes in their blood pressure, changes in the beating of their heart, and other things.
Okay. Well, what other medications does the patient have to be given to tolerate intubation?
It is variable depending on patient. These can include higher doses of sedatives, or at times, sometimes we have to give medicines to relax their muscles so they don't move their muscles to
basically paralyzed?
Yep. Yes, sir.
Now, there was a mention made of an intrathecal pain pump. Tell us what that is and what your recommendation regarding it was.
Sure. Intrathecal pain pumps are devices that are usually placed in patients, not very often in children, who are on such high doses of medicines that they can. Some of these medicines can be given around the spine so that they work more efficiently and can have lower doses. But these also entail significant risks. And at this particular, I believe Mrs. Kowalski was asking for clonidine, intrathecal clonidine pump, and those are not indicated for pediatric CRPS, and they also require basically a tube goes from the back in the spine around to an implanted pump that goes in the belly that has a motor and delivers medicine. And placing those things and maintaining those are not without risk, including appropriate dosing of medicine. You can also get significant infectious risk, especially in patients who, such as Maya, who may have immunocompromise or be undernourished. Those things would be contraindications to potentially doing that. They require a needle to fill them, and require to be filled every depending on the dose and things, 1 to 3 months. So it's not an endeavor to be taken lightly, and it's usually not used for pediatric CRPS.
Now, after your discussion with the Kowalskis first off, let me ask this. During your discussion with the Kowalskis on or about October 11th, did you talk to them about all of this?
I did share with them my thoughts on the intrathecal pump. I believe with Mr. Kowalski specifically on the 10th, as well as I believe the next day with Mrs. Kowalski, and shared with them my thoughts, and the team from the week before and the weekend had kind of put the path forward, and we agreed to continue on that, meaning a slow wean of the medicines, basically to get her progressively reduced to eventually medicines by mouth.
Okay. And was there agreement to proceed in that regard?
Yes, we made shared decision-making regarding that.
Were you ever aware of the Kowalskis wishing to leave the hospital against medical advice?
I don't recall specifically. I know that we talked about moving forward with attempting to, my goal at that time was to get her on medicines by mouth so that we could get her to a place that had a CRPS program at the time.
Okay. And was there, in fact, discussion of transferring her to another institution such as Nemours?
Yeah, I believe those discussions happened on the weekend and tail-ended into my tenure on service on that Monday, yes.
Okay. And were you ever aware of any indication that the Kowalskis wanted to leave against medical advice after your discussions with them?
No.
Were you involved in any direct communications with Nemours or their folks regarding a transfer there?
No.
Why would there be any interest in transferring to Nemours?
Nemours has an outpatient chronic pain program that they had at that time and still have today.
Okay. Now, at this point, when you were having these discussions, what was your working diagnosis with respect to this child?
So at this point, my working diagnosis was CRPS.
And was there a point at which you subsequently came to question that diagnosis?
Well, later on, as we were able to get off some of the medications and do a more proper evaluation, it definitely came to question that diagnosis, yes.
Okay, and on what basis did you question it?
Well, there were a lot of inconsistencies in the symptoms that were reported and things that were observed on behalf of Maya.
And what do you have? What are you referring to specifically?
So, in particular, there would be times where she would.
Objection, Your Honor. Is this by hearsay or is this by medical record? Objection.
As for his knowledge.
Yeah, can we just do legal bases overruled?
Based on hearsay.
My direct observations at times to see some of these things. Maya complained of what we call allodynia, or light touch to her legs, and couldn't tolerate things on there at times. At other times, she would have skinny jeans very tight on her legs, which was very inconsistent and incongruent with allodynia. Would be one example of those things. Or there would be times where I would see Maya with anklets on her ankles. But if someone would attempt to touch her leg lightly, then she would complain of pain. Just very much inconsistent with the diagnosis of CRPS. And
tell us, if you would, what dates that you were taking care of Maya Kowalski during this time?
It would be be hard to look at. We go on and off service over the course, so it would be time periods, probably weeks at a time. I believe maybe 3 other weeks that I might have, 2 or 3 other weeks that I might have been on service.
That was a lousy question. Let me try it again. During this particular first engagement with her,
yes,
you've told us you came on October 10th. When would you have gone off service with her?
It would have been the end of that week, usually, probably the end of that, whatever that Friday is, the 14th, I believe.
Okay, and was the pain service successful in weaning Maya off of her medications during that week?
Pretty much so. We were able to, if I recall correctly, able to wean her off, if not then shortly thereafter, the IV medicines.
Okay. And were you subsequently involved in Maya's care after this?
Yes, there were periods when I was back on service as the pain doctor, as well as occasionally we cover if someone is on call at night and they're out the pain doctor. If they're usually off the next day, I sometimes you may see a note for me in there because I covered for that day.
Okay. But during the period that you were initially taking care of her, were you able to make her comfortable with the weaning program that was followed?
Yes, and I worked with her parents as well, and we had continued, as you can see in my notes, agreement on the plan and closed that loop with them.
Okay. I have no further questions at this time. Thank you.
Mr. Anderson.
And please record.
Glasses. I won't use them, but they will.
In point of fact, Doctor, at the time that you first saw Maya Kowalski, you had records from Dr. Kirkpatrick in evidence at 1005-10016 to 18.
I would have to. May I see those?
May I approach you? I've got the list from.
Yeah, let's put it up. It's right there. 0016.
I have never seen this document.
Well, your records show that it was in the Johns Hopkins records. Did you go back and actually look at all of the treatments and visits and consultations that had gone on with this child by Johns Hopkins beginning on July 7th of 2015?
Objection, lack of foundation, Your Honor. He said he's never seen the document.
Do I need to respond? I'm asking him whether he went back and looked, and then I'm asking him whether he knows when it began.
I just have seen the question that you actually asked. That's all I've done.
All right. Did you look at any of the records preceding the October 7th, 2016 visit?
My routine practice is to look at the records that I have available to me and look at what I have, yes.
So is that a yes or a no?
Yes, I look at the records that I had available to me.
All right. So then those would include Dr. Kirkpatrick's records forwarded to you all after his September 23rd, 2015 consultation?
Objection.
Did you see that?
Foundation has been established.
I have not seen this record, sir.
Okay. The Sarasota Memorial Hospital record from June 15th, 2015.
Same objection, Your Honor, lack of foundation.
He hasn't answered the question on this one.
This page is hard for me too.
Well, it's a fax, is it not? From August 26, 2015 to all children's?
It looks like it is. I have not seen that document.
You haven't seen those. All right. All children's, let's see, the Loyola University Medical Center from the 7, let's see, this would be from 2006 to 2011. And that is at 1005-0024 to 0046. Do you see those?
Lack of foundation.
I have not seen this document before.
Did you note any of the visits to Dr. Kreisman?
I did see some notes from Dr. Kreisman, yes.
You saw Dr. Kreisman saw Maya approximately 2 months before she went to Mexico for the medical infusions there, right?
I believe I recall that, yes.
And then you saw, I'm assuming, the visit after that, approximately 5 months later, in May of 2016. Did you not?
I cannot specifically comment. I looked at a lot of records, whether I actually saw that specifically, but I looked at a lot of records, yes.
And this was the one where, for instance, he said, this is a new child. She's happy. She appears in no pain. I can put it up if you like.
I do recall that.
Well, what other records? Did you look at Dr. Jackson's endocrinology records?
I believe I saw some of Dr. Jackman's records, yes.
Did you read the records regarding Johns Hopkins putting in the port for the infusions of ketamine?
I believe I read that, yes.
Did you read the records for Johns Hopkins putting in the PICC line prior to that for the use of ketamine infusion?
I believe I saw that.
And did you then look at any of the notes from the endocrinologist and the prescriptions for Maya's lesions?
I believe I saw that at some point saw those, yes.
And so then, did you review then the brain scan, the MRI, in January 22nd, 2016, ordered by Dr. Jackman?
I don't know if I saw that one, but I saw several MRI. I know I saw another one, I believe.
I think you just said he didn't see it.
This one I don't believe.
And the Lurie Children's Hospital records?
I did see those, yes.
All right. And then the Tampa General Hospital records?
I have seen those as well.
Okay. And Dr. Wassenauer, the treating pediatrician's records?
I don't think I've seen many of his records.
Were you aware that there was a treating, that is an attending pediatrician for Maya Kowalski?
Yes, I was.
Did you have any discussions with him about the overall benefits of the protocol that Maya Kowalski was on prior to your intervention?
I did not.
So now, you are, as you sit here today, though, aware that Johns Hopkins told the Kowalskis on or about the 9th of October 2016 that they would not be able to leave, and if they did, security would be called. You're aware of that now, are you not?
I am aware of that, that's what they believe was said, yes.
Mm-hmm. And so you yourself then decided at some point to change the entire program that Maya Kowalski was on over to the Johns Hopkins program. Is that right?
No.
Did you not decide unilaterally to take Maya Kowalski off of any ketamine, off of the medicines prescribed by Dr. Hanna, and before that Dr. Kirkpatrick, and before that Dr. Cantu?
My priority was the safety of Maya, and I expressed that with her parents.
I understand. And by safety you mean, was she displaying any signs of physical harm, right?
I'm not sure I understand your question.
Well, when you say her safety, you're not talking about her safety in the next 20 years or 10 years or 15 years. You're talking about her immediate safety, are you not?
We were talking about the amount of medicines that she was getting and potential for withdrawal, other complications from those.
I see. And so it is true, is it not, that ketamine has limited, if any, withdrawal symptoms?
Ketamine can be associated with withdrawal. It is limited compared to some of the other medicines, but you can have some withdrawal. But our other concern was with some of the other medicines that she was getting.
The fact is that there are no studies outside of those that involve street ketamine that show any physiological withdrawal symptoms from ketamine.
Objection to proclamation.
Sustained.
Are you aware of any data indicating?
The data that is out there.
I will withdraw on that one. So now, you are worried then, I guess, when Maya came in about her health. And so what steps did you take to ascertain whether she actually was having any negative responses to the program that was already in place?
So I was not on service when she first came in. We continued the plan that was in place. So I'm not sure what your question is then otherwise.
Sure. If Maya was going to have some problems from the dosing of the medications, most likely it would be in the liver, would it not?
Ketamine can cause several things. It can cause neuropsychiatric problems. It can cause problems with the kidney and the bladder, as well as with liver.
Did you or did you not do any blood work on Maya Kowalski?
I did not personally order blood work.
Did you ever review any blood work
Yes.
on Maya Kowalski over the course of the first 2 weeks?
Yes, sir.
And her blood work came back all within normal range, did it not?
I believe so, yes.
So your concern then was for the future. How long had Maya been on the regimen that you took her off of? Or maybe not you, but Johns Hopkins took her off of.
It looks like that she had received approximately 50-some treatments prior to us.
All right. And over that 50-some treatments, she had never once complained, at least in the medical records, about any withdrawal symptoms. Is that true?
I don't recall that, yes.
From the history that you took, did anybody ever say on the various intervals between ketamine treatments that Maya Kowalski complained of anything like withdrawal symptoms?
Well, if you look at the presentation that she came with, agitation, she had nausea, she had anorexia, as well as motor disturbances, all can be related to ketamine, as well as potential for some of the other medicines that she was getting led to potential to significant constipation that she had.
What she had was a condition known as gastroparesis. True?
I did not see that documented.
Mm-hmm. Gastroparesis is, well, explain to the jury what gastroparesis is.
So gastroparesis is where the motility of your stomach is decreased.
And it can manifest in a number of different ways, isn't this true?
It can, certainly.
Yeah. And one of those ways is what? By nausea?
It certainly can.
And constipation is a constant one.
Gastroparesis has nothing to do with constipation.
And general unrest there? In the gut, that is.
I'm not sure I understand what you mean by that.
Well, the point being, if you are familiar with CRPS and its diagnosis, you are aware that gastroparesis is one of the complications of CRPS.
Objection foundation, Your Honor.
Overruled, you can answer that.
There is no association in pediatric CRPS with gastroparesis.
Let's just say maybe not pediatric, but in CRPS, the disease, gastroparesis is a known complication, true?
No.
Right. So she'd been in less than 6 days before with the identical symptoms, right?
Yes.
Okay. And at that point, nobody decided to take her off of all of the medications and admit her into the hospital, correct?
It looks like what's happened, yes.
All right. But this time, the decision was made, I guess, to admit her and change her protocol, right?
I believe she was definitely, I wasn't there during that time. I can't comment on that.
Well, at this time you can, though, and you can comment on what she was taken off of and what she was put on. Isn't that true?
I can share with you some of those things, yes.
Sure. One of the first things that she was prescribed was Haldol. True?
I believe she was given Haldol at some point, yes.
Tell the jury what Haldol is.
Haldol is a medicine that is used for various reasons, but agitation is one of those.
It's a powerful antipsychotic, is it not, Doctor?
That is one of its effects.
So one of the first things that the Johns Hopkins doctors did was take Maya off the ketamine and put her on an antipsychotic. True?
That was used for refractory agitation when other things did not work.
Right. Did you put her on Haldol as you were taking her off the ketamine?
I don't know if I wrote for that specifically or not, but that was in part of the treatment plan that we discussed.
And you put her on Tramadol. True?
Tramadol was one of her home medications that we continued.
Right. That's an opioid.
It's opioid and agonist-antagonist.
And when she came in, she had no opioids in her system. True?
I don't recall one way or the other.
And you put her on Ativan. What's Ativan?
Ativan was one of her home medications.
What is Ativan?
It is similar to midazolam. It's a sedative.
All right. And Valium, same thing. Those are both benzodiazepines,
family,
right?
Yes.
Okay. So whether you put them on or whether you continue them on, Maya's now having had opioids and benzodiazepines, no ketamine, but Haldol. True?
Those were some of the medicines that she was on.
Okay. Now, you put her on Haldol, or I don't know if it was you, but surely you had a pediatric psychiatrist that was involved at this point if you're using antipsychotics, right?
We use it for agitation as well as nausea, but there are other reasons to use it besides its antipsychotic properties.
Did you prescribe, either you or someone on your team, an antipsychotic without an evaluation by a pediatric psychiatrist as to its effects?
That would not be a standard that routinely occurs.
I'm not sure I understand. Is
We
that
don't-
a
if we're
yes
getting
or no?
something for agitation, especially in the intensive care unit, we do not necessarily get psychiatry involved in that.
So the answer is yes, you put her on an antipsychotic without a pediatric psychiatrist looking at it.
Well, I
right?
believe that psychiatry was refused most of the time.
All right. And so, Dr. Katzenstein saw her, right?
She's not a psychiatrist.
Dr. Cavett was, and he saw her, right?
Eventually he saw her, yes.
Right. All right, so at the time this all started, you were on vacation.
Yes, sir.
And when you were called, you were actually in your garden out back, were you not?
I believe I was in my yard, yes.
Right. Okay, and Dr. Dolan calls you and tells you about a dosage of this medication, of ketamine, right?
Mm-hmm.
And you say, that sounds high, or worse to that effect.
Yes, sir.
At that point, you did not know whether it was in, and what is a bolus, by the way? What is bolus versus an IV, an infusion?
So a bolus can be very things, but it's usually given faster than an infusion.
Okay, and so at that point, she did not describe whether or not Maya was getting all of these, the amount of medication related to you in one bolus as opposed to an infusion. True?
I don't recall the specifics that were told to me.
Well, there's a big difference, isn't there, between putting it all in at one time and an infusion over several hours?
It depends on the total dose.
And the total dose is determined by titration, is it not?
Total dose in pediatrics is based on weight.
Okay. And if you're going to infuse it, you titrate. True?
Depending on the reason.
All right. And if the reason is pain cessation, then you would titrate, would you not?
To limits, yes.
Right.
There are limits.
Okay. And in this case, who was best to determine those limits? The physicians who spent all of their time on CRPS pain patients and were actually part of foundations determined to do that, or you guys?
Well,
Object argument, John.
Going to sustain the argument.
Well, are you a member of the RSD Foundation?
No.
And you do not specialize in CRPS, do you?
There's no specialty at CRPS.
I understand, but you have published no papers, correct?
Not yet. That's correct.
And you have not participated in any studies, correct?
That I don't recall.
You have given no talks, no lectures on CRPS.
No.
Nor have you given any particular studies or lectures on the use of ketamine to treat CRPS. True?
That's correct.
But you, Johns Hopkins, had determined that whatever was going on out there, whatever was going on with those other doctors, you guys knew better. True?
Argument, Judge.
Overruled on that one.
Is that true?
No.
I see. So it was a mistake. You guys were actually going to stay with what was...
We were providing evidence-based care that we were comfortable with for pediatric patients.
Do you recognize as authoritative the consensus guidelines for use of intravenous ketamine infusions in chronic pain by the American Society of Regional Anesthesia and Pain Medication?
Yes, that is a guideline.
And have you reviewed any of their papers there?
I have looked at that, yes.
And would you agree with me that they're based on their papers, and I can show this to you if you'd like, there is at volume 43, number 5, the July 2018 paper that provides significant support for the use of ketamine, large dose ketamine, to treat CRPS.
Up to 7 milligrams per kilo, yes.
Okay. Now, in terms of what the ultimate load was, the ultimate amount, are you familiar with what a P450 enzyme is?
Yes.
Does a P450 enzyme break down ketamine?
It is part of the mechanism for which it is broken down, yes.
And is that P450 enzyme a result of the use of prednisone or others of that type?
I'm not sure I understand your question.
P450 enzyme will extended use of prednisone and other prednisones of which family again?
Steroid.
Other steroids will cause P450, the P450 enzyme in fairly high amounts.
It can do both. It can either upregulate it, but it also, you don't really know. It could also downregulate that enzyme.
All right. But you did not take that into account when you were trying to determine how much, right?
I'm not sure I understand your question.
Did you do any independent studies or any evaluation of where the latest literature was on the use of this type of treatment, that is, high-dose infusions of ketamine to alleviate pain in CRPS patients?
Yes, we did. We looked for literature and did reviews, yes.
Right. Your own literature, though, inside.
No,
Well, did you talk to Dr. Kirkpatrick on his papers?
I did not speak to Dr. Kirkpatrick.
Well, did you talk to Dr. Hanna on the reasons why he chose those amounts?
I spoke with Dr. Hanna, and he told me his amounts were not working.
Right. But not because they were ineffective totally, but because he had reached a limit to which he could go safely without intubation. True?
He told me they were not working.
Not because ketamine doesn't work, but because he had reached a limit to do it
He did not tell me
outpatient.
that.
He's saying he did not tell you that? All right. All right. So now, in your evaluation then, and let me get this straight. Does Maya Kowalski have CRPS or does she not have CRPS?
What do you mean? You can, so if you
Does
read my
Maya Kowalski
okay, if you read my
have a
notes,
proper diagnosis of CRPS or does she not?
if you read my notes, I never rule out CRPS.
Okay.
However, it is less likely given her clinical presentation and the inconsistencies, some of which I had already shared.
Well, she certainly meets the epidemiology profile, does she not?
She has some of those traits for both of those disorders, yes.
Well, she was 15. Excuse me, she was female, adolescent, right?
Mm-hmm.
She had epidemiologies. Oh, yeah, every time. Well, hang on. Can we pull up 2017-754? And let me ask you, Doctor, over this period of time, were you billing for CRPS?
What do you mean? You're asking for billing codes?
Well, I don't know that you need them here.
Okay.
Were you billing over this period of time for CRPS?
Yes.
Can you bring up 2017
Excuse me, Your Honor, that's a partial answer to the question and a partial question that was asked. In other words, the complete document speaks for itself.
Overruled. You can continue.
Thank you. 2017-762. All right. Were you billing for CRPS over this period of time?
Where are the dates on here?
I'm looking right now. Date of service, December 2nd, 2016.
So these are diagnosis codes, not billing codes?
Okay. Were you billing for
complex regional pain syndrome treatment over this period of time?
I would have to see. I'm assuming so, but this is a diagnosis code.
All right? Yeah. That's all I found.
Mr. Hunter?
Yes, sir. Could I ask that 2067762 be left up for a moment?
That was not 2. That was 2017. Is that what you want?
Yeah, whatever you had up there, I thought it was.
Put that back in.
Yeah.
I think it was 0.
I had 2067762, whatever it was.
There it is.
Okay. Can we put that nice little red ring around all the diagnostic codes, not just two of them? All the way down. So we've got here, the diagnosis code is chronic pain syndrome, correct?
Yes, sir.
Pain unspecified, correct?
Yep.
And then we get to complex regional pain syndrome of lower limb bilateral.
That is correct.
And then we have complex regional pain syndrome unspecified.
Yes.
Were all those codes being billed under?
Those are all diagnostic codes, yes.
Okay.
That would be-
Not just complex regional pain
That is,
syndrome?
that is correct.
Okay. There were some questions asked about the medications that this patient, well, let me strike that and back up. Counsel asked you about the consensus guidelines.
Yes, sir.
You indicated you're familiar with those.
Yes.
Now, when were they published?
Those consensus guidelines were published in 2018. They were not available during the time that Maya was in the hospital.
Okay. So they were published after all this?
That is correct.
Okay. And based on the evidence that was available to you folks, were you able to find any evidence that indicated that it was efficacious in the treatment of pediatric CRPS to give a patient 1,250 milligrams at 25 kilograms of weight over 2 hours?
No, we could not.
Have you ever heard of such a thing?
Never.
Is there anything?
Objection, hearsay.
Is there anything in the literature that supports this?
No.
Objection.
Sustained.
Move to strike.
Court will disregard the last question and answer.
Is there evidence, are you aware of evidence to support the idea that that level of ketamine is safe for a child?
Objection. Holstering.
Sustained.
Counsel asked you whether you had published on CRPS. Have you published on pediatric pain management?
Yes, I have, and I've been involved in talks and workshops at national meetings, all relative to pediatric pain.
What is the incidence of CRPS in the pediatric population?
It is quite rare. It's approximately one child per 100,000.
So would it be reasonable to think that someone could develop a specialty in the treatment of pediatric CRPS alone?
No.
Why is that?
There's not enough cases.
The counsel was asking you about the medications that you folks that were given to this patient when she presented to the emergency room. You weren't there.
That is correct.
Why would the patient be given Haldol and the other medications that were specified?
A lot of those we worked in collaboration with her parents and discussed a plan, and that was all documented. We were trying to balance her comfort with agitation and weaning of the medications.
Did you go back and look at the records from her visit to our ER on October 1st of 2016?
I believe so, yes.
Did she indicate the level of agitation that she did when she presented on October 7th?
No.
Was there any indication of a chronic pain crisis on that day?
No.
Had she been referred, according to the records, by her treating CRPS doctor to All Children's on that day?
Not that I recall.
Okay. And what was the occasion for her reference to All Children's on October the 7th?
Can you clarify that question?
Well, why was she referred there?
She was referred there from Dr. Hanna, I believe.
There was reference to some medications that the patient had on at home. That included tramadol?
Yes, sir.
In other words, had she been given tramadol by outpatient physicians?
Yes.
Not by All Children's?
That is correct.
Had she been given Ativan by outpatient physicians?
Yes.
Is gastroparesis associated with ketamine?
Ketamine can impact multiple receptors in the body, including opioid receptors, which do have implications for slowing down gut motility. Yes.
We've been talking about the extent. Well, let me back up a minute. We talked earlier about what records you had available when you saw this patient when you came on service. Counsel showed you several records. Were any of those available to you at the time that you first saw this patient?
They were not available to me that I recall.
Okay. And at the time that you first saw this patient, did you have any records available from either Lurie's or Tampa General?
No.
Okay. Why were you concerned about the ketamine doses that Dr. Hanna described to you?
Ketamine can have numerous side effects. She had already had a history of elevated liver enzymes, I believe, in the past, and then she was getting these large doses of ketamine. Ketamine is also what is called an NMDA receptor antagonist. And in developing brains, it has been shown to potentially cause brain cell death and brain damage. So that, along with the reported magnesium that she was getting and the large doses, very large doses of dextromethorphan that she receiving, all were NMDA receptor antagonists. So our concern was the potential impact it may have on her brain.
We talked earlier about conversion disorder and patients feeling pain and not necessarily telling them that it's in your head or they're faking it.
Mm-hmm.
Do you, in the treatment of these chronic pain syndromes in pediatric patients, do you folks take their complaints of pain seriously?
Yes, we always believe our patients. That's what I tell them when I first meet them, that we believe their pain is real.
Was there ever any point that you're aware of at which Maya Kowalski was told that it's all in your head or it's fake?
Nothing that I ever said to her.
Okay. And were you ever aware of her being told that her mother had put her in a coma or was in a psych ward?
No.
That's all I have. Thank you.
Mr. Anderson? Do you agree or disagree that the Kowalskis knew what was best for their own daughter's treatment?
I'm not sure I understand.
Good argument, Judge.
Overruled. Do you agree or disagree that Jack and Beata Kowalski knew what was best for their own child's medical treatment?
Well, I think that after reviewing the medical records and realizing that several other institutions shared with them the diagnoses.
Objection. Go ahead.
shared with them the diagnoses included conversion disorder, and that the treatment was psychology, CBT, PT, and OT, and yet they continued to seek aggressive interventions, was very concerning to me.
So the answer is, if I'm understanding you, correct me if I'm wrong, you think you and Johns Hopkins know better than the Kowalskis how they should have their own child treated. Is that true?
That is not what I said.
I'm going to sustain the objection.
Which
I had
is it?
concerns.
Same objection, Your Honor.
Okay, we understand objections. The question is, as between the Kowalskis themselves and Johns Hopkins, who had the right to make the ultimate decision on how they treated their daughter?
Objection, Your Honor. Argumentative, calls for conclusion.
Sustained.
A legal conclusion. Did you believe you knew better than the Kowalskis on how to treat their own daughter?
Argumentative, Judge.
I'm going to sustain the ask and answer, so how about that?
And so, was it true, and is it true, that the Kowalskis had the right, under the Johns Hopkins' own patient statement of right, to reject your treatment?
They certainly could.
Anything further, Mr. Hunter?
No, sir, Your Honor. Not at this time.
Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All right, there was extra.
Please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And you did not see any media coverage. Is that correct? And no one approached you. Is that correct? And we reviewed these questions outside of the doctor's presence. Dr. Elliott, the jury has a number of questions, so I'm just going to start reading. You testified your protocol is pre-anesthesia level not to exceed, I think you said, 2 to 3 milligrams per kilogram per hour of ketamine. We have heard testimony that Maya received 5 milligrams per kilogram per hour of ketamine at All Children's. Why would All Children's go against their protocol, and is it documented in her medical record as an exception?
Yeah, so those doses are a little bit not correct. Our pain protocol is 0.2 to 0.07 to 0.2 is our range, up to 0.5. The dose that was decided on, again, I wasn't there at that time, I believe, was a compromise with trying to balance what she had received before with some of the whatever evidence we could find at the time, and working with her parents at that time to try to come up with something to help her, and something that we were comfortable with based on the clinician's judgment at the time.
What was the dose of Haldol Maya was receiving, and how often was it given?
I don't want to guess. I believe it was 1 milligram, and I don't recall. It was probably every 6 or 8 hours as needed.
The next question, what was the route in which it was given?
I believe it was ordered intravenously.
Next question, how was it, in your opinion, possible Maya could be getting such large doses of ketamine and still be awake?
I know that there were times that she wasn't awake, given that. So that would be hard for me to answer, because I really did not see her right after those doses to give an appropriate evaluation of seeing her after she received those doses with Dr. Hanna. I was not there.
Okay. If these levels of ketamine are unheard of, then why are known doctors in CRPS able to use those levels?
This is a topic of controversy right now, the growth of ketamine clinics in the U.S., and it is not officially regulated. They are not regulated by the FDA and the government at this time. And so people use things off-label, and so there's no regulation by the government of this, although there's talks of that happening.
The next question. You mentioned you were able to wean Maya off of many of her meds over weeks with her parents' agreement. Were they cooperative with that plan?
With me, most of the time I am very honest with that, and I believe that I had a reasonable relationship with Mr. and Mrs. Kowalski. I was honest with them, and we attempted to work with them to have a plan that we could mutually agree upon, and I believe that's demonstrated in my notes in the record as well. And I tried to, as with all my patients, work together, engender their trust, and make them understand that I treat their children as if they're my own children.
Ketamine was being weaned, but one medication you added was Haldol, an antipsychotic with sedative qualities. What are some of the other known side effects?
Of Haldol?
Of Haldol.
Haldol, okay. So Haldol in large doses can potentially impact how your heart beats. It can also cause abnormal movements. Those are probably some of the two bigger things that can happen with it.
Did Maya have withdrawal after receiving the high dose of ketamine?
It's hard to say. Because we had put her on medicines to help withdrawal. That, for instance, that infusion of the dexmedetomidine is used to help ease withdrawal symptoms. So it's very hard to say if she had withdrawal or not because of that medication being on board. And that was the point of that medication, to make sure that we did not want her to suffer any withdrawal from some of the medicines that she was on.
Was the All Children's Hospital staff trained in CRPS before 2016 when you took over?
I'm not sure what's meant by that question per se. At that time, we were working on building an outpatient program, an outpatient clinic, as well as a CRPS program. At that time, we had a couple of inpatients with CRPS, so people were familiar with it, although we didn't have a formal program at that time. So people are, in general, familiar with it. In terms of the pain team, everyone was familiar with it, and its treatment in the pediatric realm.
And I cannot ask that next question. Dr. Elliott, in 2016, it appears ketamine is not your preferred form of treatment for CRPS. You mentioned more along the lines of two types of therapies to use for CRPS. Is this a correct understanding on this juror's part?
Yes. The standard across the country for pediatric CRPS at children's hospitals is physical therapy, occupational therapy, and cognitive behavioral therapy. Some of those institutions use those things alone. Others, like we do, use adjuvant medications to help facilitate, meaning pain medicines to help facilitate the physical therapy as needed.
Do you now see, as more research has been conducted, are you more open to ketamine as having a place in a possible treatment for CRPS in amounts larger than what you were accustomed to in 2015?
I think as those guidelines share, and if you would read them further, they talk that there needs to be more data. Those guidelines are based on very poor data. There's a way that you rate studies based on their quality, and most of those recommendations there are based on very poor level of quality. There's very few studies, even by people who claim to be CRPS experts, that are of any good size, none of which really are in pediatrics, to validate the use of that. And the data really shows, in these studies and the guidelines, that there is no benefit to ketamine beyond 3 months. And that is what is emphasized out there, and that is still what is described in especially the pediatric realm.
Have you ever been involved in medical research to find cures for illnesses using established or new drugs?
Yes, I have been involved throughout my career in trials for different avenues of medications or things, vaccine trials, as well as other medications, yes.
Are you a doctor that follows only set and or approved treatments for a known illness?
I think all of us use those as a foundation for the treatment of diseases. Do we look beyond that and look at each individual patient? Yes. Balancing, safety of treatments with outcomes in that regard. And so, especially in pediatrics, we have to be much more mindful of things because of the varying changes in body chemistry, and what we call physiology based on age is very different than in adult patients. So it's harder to do some of those things and go outside of that scope with pediatrics. Some of that is protected on state level. For instance, in Maryland, it's very hard to do drug studies on pediatrics because of the laws protecting children, and I experienced that when I was in Maryland.
Are you saying that diagnostic codes do not need to match the billing codes that is sent to insurance companies for payment?
So I don't claim to be an expert on diagnosis and billing, but usually for patients, they are submitted what are DRG codes or ICD codes, excuse me, is the newer term, and then CPT codes, for lack of it, which are billing. So there are two codes. A lot of that is determined by hospital billers who are expert in this based on the stuff that is in the note. We don't always assign that. We usually assign diagnoses of which we may have made or other people may have from their past medical history. So a list of diagnoses, and now in more modern medical records, we have kind of active diagnoses labeled and but historic, which we didn't always have in the past. So we try to be more of that, but we try to be all inclusive as well, so that when other providers are able to look at the record, they can see that at least was in the history, and take that into consideration when kids present with things.
Those are all the jury questions. Mr. Hunter, do you have any follow-up?
No, Your Honor.
And Mr. Anderson, any follow-up?
As we sit here today, you have no data showing systematic harmful effects of the use of ketamine in treating CRPS. True?
There is data on CRPS, on ketamine and potential neurotoxicity in children.
Only for children. That study is for children under the age of 3. Isn't that true?
It's not a study.
Objection to proper impeachment, Your Honor.
Overruled. You can answer.
It is not a study. The official FDA communication is for children now potentially 5 and under, but they also claim that they do not know. We do not know that the brain is developing up until upper teens.
Was Maya 5 and under at the time?
She was not.
Anything else, members of the jury? I don't see anyone writing. May this doctor be excused.
Yes, sir.
No objection.
Okay, Dr. Elliott, thank you for being here.
Thank you.
Members of the jury, we have a 16 or 17-minute deposition that we're going to play now, which should take us exactly to 5 o'clock. Do you want me to dim the lights or just leave the lights as they are? Leave them on? Who are we calling next?
It's the deposition of Dr. Walford.
Dr. Elizabeth Walker.
Hey, doctor. Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Doctor, can you tell us your name, please, for the record?
Nebby Elizabeth Terry Walford.
Okay. And what is your occupation?
I'm a pediatric surgeon.
Where do you presently practice your profession?
The name of our practice is Gulf Coast Pediatric General Surgery, and we practice at Gulf Coast Medical Center,
And where is that located?
Panama City, Florida.
How long have you been with Gulf Coast in Panama City?
Just over 4 years.
And prior to that, where were you?
I was at Johns Hopkins All Children's in St. Pete for 8 years, or almost 8 years.
Could you tell us, doctor, where you received your undergraduate training and when you graduated?
Yes, I did my undergraduate at University of Georgia. I was there from 1994 to I graduated early at the end of 1997.
Okay. And where did you go from there?
I went to medical school at Mercer University from 1998 to 2002.
And you graduated from Mercer?
Yes.
Where did you go after you graduated with your MD from Mercer?
So I did my internship and residency in Savannah, Georgia at Memorial Hospital, which is part of Mercer University.
And that was both. What can you tell us? Tell us about your internship and residency?
Yes, that was in general surgery, and then you have to finish general surgery before you can be a pediatric surgeon. So I did general surgery there, and then I did my pediatric surgery fellowship at the University of Oklahoma in Oklahoma City.
Okay. And when did you complete your fellowship training?
2010, and I went straight from there to All Children's.
Okay. Are you board certified?
Yes, I'm board certified in both general surgery and pediatric surgery.
Could you tell the jury what that means?
Yeah, so in order to be board certified, you have to finish a residency and pass for general surgery and pediatric surgery, both written and oral board certification exams. And you have to maintain those certifications by completing case logs showing the work that you've done in CME every year. The old system, which I'm still accredited through general surgery, involves a comprehensive test every 10 years, but they've changed it over to a CME and case log system now. So that's how I've maintained my board certification in both.
During the time you were practicing your profession at Johns Hopkins All Children's, did you have occasion to see a patient by the name of Beata Kowalski?
Yes, I did.
Okay. Do you remember her?
No.
Have I provided you certain records regarding certain records that you created when you saw her at Johns Hopkins All Children's?
Yes.
According to the records, how did it come about that you saw her?
So she was a patient who I saw in the office or clinic, if you will. She was scheduled through our office after she had, I assume, a referral from the referring physician. That's how we see patients. They come with referrals because we're not a primary care situation. They come from another physician, basically.
Okay. What was the purpose of the referral of Beata Kowalski to your practice?
Basically, she was referred to get a port placed.
Okay. And what is your role as a surgeon when a patient is referred for the placement of a port?
So as a surgeon with ports, we are basically mechanics. They ask us to do a job and we do it. It's not something where we treat patients other than putting in ports and ensuring in good faith that someone is going to take care of those ports, flush them, do the random maintenance that needs to be done.
In the case of Beata Kowalski, what history did she give you upon presentation? Or what, I should say, what history were you given upon her presentation?
So based on my review of the records from my office, that she had a diagnosis of RSD and needed the port for ketamine treatments and blood draws.
Were you familiar with the physician who referred her to you?
No, I wasn't.
Is that fairly typical in these situations?
Yes.
Did you ever consult with the referring physician in this case, Dr. Hannah?
No, the only thing we do is our office automatically generates a letter back to any consulting physician with the plan and basically our office note from that day.
Did you undertake to evaluate or confirm, or for that matter, comment on the diagnosis of RSD?
No, in fact, I barely know what it is. It's not my job to diagnose something that's out of my realm of knowledge.
Did you consult with Dr. Hannah or any other doctor for that matter regarding the treatment regimen for RSD?
No. Your question is, why did I not consult with someone about this treatment?
Yes, ma'am.
It's way out of my realm. If somebody comes to me that needs a port for cancer or whatever, I'm not going to say, first of all, I don't think this patient has that cancer or has a different cancer. And I'm not certainly going to say, well, this patient should be treated with radiation and not chemo. It's every physician has a different job in the management of complex patients. And my job is to put in a port when someone orders a port. It's not to second guess or change the treatment that a patient's undergoing.
Were you successful in this case in placing a port in Beata Kowalski?
Yes.
Did you ever see her again after that?
Not to my recollection. Sometimes we do post-op visits, like a patient will have an office appointment 2 to 4 weeks after a procedure is done. It's not routine for ports because usually those patients are already in the system seeing other physicians. And I haven't seen a note that I did. So I assume that I did not, but I can't say 100%.
Did you have any occasion to consult with any of the other physicians practicing at Johns Hopkins regarding Beata Kowalski?
No, the only conversation I would have had is, and I don't remember anything, but during a procedure, and I even saw my order speak with anesthesia about if the patient needs like a pre-medicated steroid for surgery. We discussed the history with the anesthesiologist as we're going to the room, but not really. It's more just like, do we need to do anything specific for this case? It's not about her overall condition or treatment.
So would you have been discussing with them any overview or oversight of the RSD diagnosis?
No.
On here, obviously, it says there's a sticker for Beata Kowalski and your name, and then it says 020316, and then under chief complaint, what is that? Is that eval port placement?
Yes, that's what our office staff writes down for the reason why the patient has come.
What is an eval?
It just basically means to see if it's something that we can do.
What are you looking for there?
Several things. One of them is a history of what lines the patient has had in the past and whether or not we need to work them up for clots in their venous system that might have a problem with putting ports in. Another thing is evaluating their chest wall based on the age and size of the child, whether or not they can fit a port on their chest wall. Those are the main things.
I got it. That's fair enough. Okay, let's go down to new problems. Can you translate where it starts with what I think is a W, or it could be an L/O, or
history of RSD.
That's history.
HO, history of.
Okay. And for the benefit of the jury, is that the same thing as CRPS, complex regional pain syndrome?
So I have that in my past medical history right there. My guess, because I've never heard of CRPS before or after, is that whoever was providing the history told me that.
Got it. All right. Since that time, are you aware that RSD is an older term for CRPS?
Only because of this case, someone told me that over the phone.
All right. Now, underneath that, needs port. Is that what it says?
Yeah, it says needs port, frequent ketamine infusions, IVs, blood draws.
And have you, strike it, I gather you have done more than one port placement in your career.
Yes, hundreds.
Right. And
if not thousands.
What is the typical, if there is a typical, reason for a port placement?
There is not a typical reason. Usually it's some sort of infusion or patient with poor access that needs access for either infusion or blood draws. I would say the most common reason is for chemotherapy, but certainly there's no typical reason. We place them for other reasons as well.
Have you placed a port for RSD or if not that, then long-term chronic pain patients to receive medication before or after?
Not that I recall. But for patients with chronic conditions that are in and out of the hospital multiple times.
Well, the purpose of the port then is to receive medication and or fluids generally?
Yes, or frequent blood draws for patients that are very difficult sticks.
Okay. And in the reference here of ketamine infusions, is that your handwriting, by the way?
Yes, it is.
And where would that information have come from?
Whoever was providing the history, the family member, I assume the mother.
Oh, there you go. Now, is part of your pre-surgical preparation with the patient, if it is known that they've been treated at All Children's previously, to review the medical records
at least from Johns Hopkins?
No, and as a matter of fact, I'm not sure from a HIPAA standpoint about access to old records. That would be a good question for you guys. Actually, I don't know the rules about that, but usually I only look up the patient's information if it came from the whatever the referring physician might have sent. But I usually don't dive into other things unless there's some reason. For instance, she told me she had lots of central lines placed before with scar tissue and problems, then I may look up old studies related to that, but I would have no reason to dive into her medical record unless it pertained to what I was doing.
So was it, at least in your part of the pediatrics specialty, a common or accepted procedure to rely on the patient's description of the history in determining what treatment you were going to initiate?
Well, I wasn't going to initiate any treatment.
I understand, to the extent putting in a port is a treatment, but
yes, basically the family provides the history and the physician provides an order for it. The family can't come in and ask for one without a physician's order.
got it. And then the next paragraph.
Maya and her mother are very specific about where they want the port placed. They want it in a cosmetic location, probably on the lateral chest wall in the lower bra area.
Nothing unusual about that, I would take it.
It's not a great place to put a port, honestly. And so if they ask for that, we try to make a note of it because we will not put them there routinely.
Why is that?
Because it's a longer tunnel for the catheter to make, and they often become kinked or retract in the tunnel, and they have problems.
All right.
And so we have to have that discussion with them and make sure they still really want that. And from my language, I can tell that they were a little demanding, if you will.
Well, hey, there's nothing unusual about a mother and daughter being concerned about having this port stick out and be noticeable in a t-shirt or low-cut dress, not low-cut, but you know.
I mean, from your perspective, maybe, but it's actually very unusual for patients to specifically ask for a port to be placed somewhere.
Would these notes that we just went over, exhibits 1 through 4, would they be available online within the Johns Hopkins system so that if Maya and her mother came in later, another doctor, assuming it was necessary, could access these records and find out about this?
When I was there, this note would not have been available. I do not know if it is now. Her surgical records from the hospital would have been, but clinic notes were not available on the main system that I can recall.
And why would that be?
It was a separate paperwork system from the office to the hospital.
How much information would be in the surgical record?
You mean the surgery office or the hospital?
What kind of things could a Johns Hopkins physician pull up within their records to know a little bit about this surgery?
So as I recall, it would be the patient's H&P that's done by the nurse practitioner in the pre-op area, and their op note and their anesthesia record. That being said, this was a while ago, and computer systems are constantly changing and adding stuff, and I'm not sure now what's available versus what was available then.
That concludes the playing of the... Okay, members of the jury, we've just got one more minute before 5 o'clock. You want to call another witness? Okay. Do not discuss this case amongst yourselves. Do not do any investigation. Receive no information, and we'll see you tomorrow at the same time. Have them ready to go at 9 a.m.
All right.
the jury is out of our presence. Everyone can be seated. Did I overhear Ms. Croyles say that you were taking all the time for that last doctor, or was there?
That last 16 minutes? Yes, correct.
So assuming that that was correct, I can tell you the plaintiffs consumed 1 hour, 30 minutes today and are now at a total of 51 hours. The defense consumed 2 hours, 55 minutes and now stand at 26 hours, 45 minutes. I assume that's what you wanted to know.
What?
I assume that's what you all wanted to know.
Yes. Do we have time to do the Alexander Depp, Judge?
Yes.
Issue?
I assume there were a couple things we had to do before we left today.
Okay.
So I still don't know who's someone else.
May I?
Yes.
Judge, I'm actually not sure what their, I'm not quite sure what their objection is, but I understand from when we tried to put the records in. This is a doctor who was a resident at the time and took the history from Mrs. Kowalski that she was giving ketamine. And so I think the concern was...
This was done in the ER room, the ICU?
No, this was an admission. Is it an admission? ICU admission. In, let's see, where, at Arnold Palmer Hospital.
Orlando.
Okay, so if I could direct the court's attention to page 74. I only gave you the pages that were going to be, that we had designated. Okay, so if you look at page 12, or line 12, it says, mother states that she has been doing ketamine injections through the patient's port at home of 50 milligrams up to 30 minutes PRN. Mother states the patient will occasionally go days without needing ketamine, but sometimes she needs it multiple times a day. That's what I relate to me by the mother. And then if you go to page 81.
When was this admission?
April 2016.
April, thank you. If you go to page 81, let's see. That's a question. Hold on, let me find the page 82. Sorry, in answering the question, because there's all this exploration of who said this and where'd you get it. The witness says on line 3, the way I documented this means that when we were speaking, we talked about getting the ketamine boosters every few weeks, as she does with Dr. Henna. However, I stated that she's been doing ketamine injections through the patient's port at home. And if you read on, I documented several things. I said ketamine injections, which means IV. I stated through the port, which means I was told through the port, and I say at home. So he reiterates that the mom was talking at home. And then on 136, again being asked about that statement, line 24, I say mother states, meaning mother is telling me that she has been doing ketamine injections, and then he goes on to explain what that means. There's no question, Judge, but that this is a party admission, if not medical history, and it is a statement that the doctor is testifying he was specifically told by Mrs. Kowalski, which he then documented in the medical record as mother states. So I'm not sure what the objection is at this point. He says it again on page 140, on line 14. I say the mother states that she has been doing ketamine injections to the point. I specifically state it was the mother. So I'm not sure what the objection would be.
You're taking this for the, were you finished, Ms. Quarles?
Yes.
The objection is relevance 403 and along the lines of what was discussed on Friday afternoon and this morning. This is a resident, and it all the way to the Chapter 39 issues. is a resident who's not competent to give these opinions. His record also indicates that Maya had a normal gait during this admission at Arnold Palmer Hospital, so his records are completely unreliable. The prescriptions at the time were for IV ketamine at home. So it's confusion on the resident's part. And again, none of the supposed knowledge of this resident in April of 2016 was ever communicated to or made aware to Johns Hopkins All Children's Hospital in October of 2016. So it's irrelevant to the medical malpractice claim. It's not even relevant to an intentional infliction claim. It's not relevant to any pending claim in the lawsuit, and it's a 403 issue. The court on other occasions has refused to admit evidence that would be along the same lines as this. Those are our objections, Your Honor.
He also works for Johns Hopkins.
Oh, he now works for Johns Hopkins, by the way.
At the time.
And he joined them in 2017 and worked for them during this deposition.
Not sure the relevance of the last comments, Judge, but this clearly goes to credibility issues with the patient, with the plaintiffs. It goes to Mr. Kowalski's testimony that they would not be ejecting at home. I mean, it's a credibility issue that the plaintiffs are under anyway. It also goes to past medical history. It goes to several issues in the case.
Well, there's already testimony that for the Kowalski family, both Jack and Maya, if I remember correctly, that she was receiving ketamine at home orally.
Correct, but they specifically denied that there was any injections of ketamine done at home.
Just out of curiosity, though, other than, how is this not a collateral issue? Well, y'all love that safeguard, don't you?
I'm sorry, it's not a microphone.
Yeah,
my apologies.
It's not collateral, Judge. It goes, again, to the jury's assessment of Mrs. Kowalski's state of mind. It goes to the Munchausen's concerns that are being raised. It's support of that. It's a impeachment of the plaintiffs directly involving their testimony with regard to what type of care that she was having at home. They just asked Dr. Elliott, don't they have the right to make these decisions? They're putting this issue in front of this jury. And the jury, I think, needs to understand, as part of their assessment of this case, what types of decisions were these parents making? And at this point, there's evidence that Mrs. Kowalski was, contrary to the testimony that's been presented to this jury, was in fact injecting ketamine into Maya.
And are there any records, prescriptions that were filled with IV ketamine?
Yeah, I can handle that. Do you mind if I handle that question, Joe?
Go for it.
Okay, yes, oral ketamine and IV ketamine can both be used in the same way, and this is why it goes to the heart of the case, is because when the Kowalskis came to All Children's, part of our medical team's concern was they weren't able to access some of the outside records. And as I rushed to the bench during one of the questions of Dr. Katzenstein with, when they're asking, does any of this show a dangerous practice, that the Kowalskis continued to inject into this litigation that everything that they did on an outpatient basis with other doctors is safe. It was the whole theme with Dr. Elliott. What we did was safe, this was normal, you just weren't used to it. In fact, this goes right to the heart of the defense. For us to be able to say to this jury, we had concerns, they weren't turning over records, we had concerns with over the safety, and in fact, on both real-time and retrospective review, we're right. This is, respectfully, an extremely dangerous practice for a mother who's an infusion nurse with access to these supplies and access to ketamine and knowledge of how to access a port to be able to infuse an anesthetic on her daughter through the port. Now, if they want to cross-examine and say, what other evidence you have, it's not just this record. This is not an outlier. In this exact same time period, we have the admission through the note from Mr. Kowalski, who turned over his wife's diary that says she gave ketamine through a port, and we have Dr. Hanna 2 days after that record having Mrs. Kowalski sign a contract. So as the Kowalskis inject these themes into the case. These are parents' rights. They get to do, you don't have a right to second guess it. This goes right to the defense of our case to be able to explain that there were things that raised red flags, including the refusal to give outside records, which show exactly this.
So where is the prescription for IV ketamine?
We have those records that we're willing to put in. We can put in evidence through quorum, including one of them that was filled by Mrs. Kowalski while Maya was in the hospital.
The prescriptions are for IV ketamine for oral use. They all say this. Right. And the testimony of the pharmacist is that this is the way that this has to be filled. It's IV ketamine for oral use. So it's intentional confusion by the defense. Can I respond to some other things we just said?
Yes.
Regarding, okay, so this is a record from April 2016. So the assertion is, well, this was extremely dangerous for Beata Kowalski. The question of the defense is, where is the evidence of any harm from this alleged use by one resident at any time? This is around the time when Dr. Kreisman comments on how well this child is doing. There's no evidence between January and August of 2016 of any harm to this girl during the time that this resident alleges that there was IV ketamine going through the port at home. And then I have to address this rushing to the bench idea. Again, that question was specifically targeted at Dr. Katzenstein's diagnosis of psychological factors affecting other medical conditions. And the question was, with this diagnosis of psychological factors affecting other medical conditions with an underlying physical condition of CRPS, does not pose a danger to the child. Does it, Dr. Katzenstein? She said, no. That's nothing to do with a resident's opinion about ketamine and misunderstanding the prescription.
Judge, this goes to weight and credibility. It doesn't go to admissibility. This is a medical record, prior treatment. The predicate's been laid by the testimony of this doctor that he got it from Mrs. Kowalski. It's not a question of the source. There's an admission. Their arguments can all be made, but this is about admissibility, and this should be admitted.
Anything else, Mr. Whitney?
Let me ask the question. What claim would it go to? They didn't have no knowledge at the time.
And none of those, there is no evidence in this record.
To Mr. Whitney.
Oh, sorry.
I still am concerned about the 403 issue in this particular case. And knowing for years this concept of she being Beata Kowalski used ketamine in her suicide, and the reality is Maya and Jack Kowalski already testified that she had ketamine at home orally, and I'm not seeing the huge prejudice here that you seem to be suggesting, that if we don't show that it was done via infusion versus orally, that somehow makes or breaks the case.
It is a significant fact, and just because I don't understand the court's reticence here. I really don't. Just because it's
for years I've been hearing about this and questions about suicide and mom using it, and
we're here, Judge, on this issue.
Well,
this issue goes to their credibility. The Kowalskis took the stand and testified completely adverse to this. This is credible testimony. The doctor, although I want to say he now works for us, the doctor is testifying as to what occurred with his interaction with Mrs. Kowalski. There's nothing to call into question this doctor's testimony.
The practical concern, and this is not a defense, this is a both plaintiff and defense. I feel like I give 1 inch and then 4 or 5 feet later I'm trying to rein everybody in. And so that's my concern, that given the history of this particular issue, and I know, Ms. Krause, you weren't part of the 2 years that I was dealing with this particular issue. I am really concerned that if I give 1 inch here, this is going to turn into something completely different. And that's based on lots of hearings on this particular issue.
I understand that, Judge.
And-
We've been
and-
through those hearings, and this is where we are now, and this is an issue in this case. And we're not going to start trying to say, and that means she used ketamine to kill herself. We've already stipulated that she committed suicide. We didn't even want anything in about the records about the suicide. Plaintiff's the one that put all that in. We were willing to say she committed suicide. They're the ones that wanted to put in all the records about it. And put in the picture of with the IV in her arm. They're the ones who put all that in.
I still maintain this is a 403 problem, and I'm going to exclude it.
Judge, can we make one last record? And I promise I'll sit down. I know it's very frustrating in the court, but again, as Mr. Hunter noted, they made 5 references in opening statement that we have no basis to suspect Munchausen, no basis to take the child away, despite the court telling them not to do this. These records go right to the heart of a healthcare provider's concern. Ketamine through an IV can be lethal if not properly managed. This is not about oral ketamine being taken with Gatorade that can cause some nausea and vomiting. This is exactly what our experts are going to come into this court and testify that there is a valid concern for this. They have made their entire case about there was no valid concern for Munchausen's. You had no right to put it on the transfer codes. You had no right to blame these poor parents. This is among the 3 biggest pieces of evidence for the defense to be able to turn to this jury and say, we have the records that we can line up that show mom told a doctor as an admission against interest she was giving IV ketamine to report. We have her own handwriting that says she was giving IV ketamine to report. And 3 days after her own handwriting, Dr. Hannah makes her sign a contract. And to cut the defense off from being able to say that gives the plaintiff this unfettered license to have told this jury over 3 weeks that All Children's has no basis to accuse Munchausen, to suspect Munchausen. This is the evidence of it.
And I go back. I have already instructed this jury that Johns Hopkins All Children's Hospital had a reasonable basis for the DCF hotline call and that the hospital is not responsible for that. It's going to be reiterated again in the subsequent. I continue to remind we are not trying the Chapter 39 case. And as much as the last few days I feel like that's what the defense wants me to do is to try the Chapter 39 case, I continue to believe that the 403 problem with respect to this evidence vastly outweighs whatever probative value it has for the defense. It's not coming in.
May I ask the court, is the jury going to get an instruction that the defense had a reasonable basis to put Munchausen by proxy as a suspicion on the transfer code? Because their whole argument is we have no reasonable basis to put that, and that's why they refused transfer. And this all goes to the reasonable basis that the defense has in real time and in retrospect that would support that.
I continue to maintain my ruling. What's next?
Judge, what, okay.
A question regarding that. Just mechanically, Your Honor, if the court please. Can the deposition that has been proffered that we wanted to play, is that a sufficient proffer, or do we have to haul this guy down here?
Well, I don't know what you mean. I mean, I'm talking about the specific questions that Ms. Crowell's just went over that reference the statement against interest of Beata Kowalski saying something to the effect of, I administered ketamine via IV. I think that issue you have told me about. If there's something else that you were going to call this doctor for,
No, there's not.
then I can't say that the proffer is complete. If that's the only reason why you're going to call this witness, then to me, I think you have completed the proffer.
Okay. Did you just?
I did.
But I mean, obviously, though, we have not heard all of the statements from the plaintiff's side as to why they would believe that he made a mistake. It's a he, right? Brandon made a mistake with respect to what he heard from Beata. But regardless, I don't need anything more on the IV ketamine issue at home.
I just wanted to talk schedule, Judge, and what the plan of action was.
I have something substantive to discuss, which is Dr. Crane is going to be testifying tomorrow, we're told. That's the defense expert, anesthesiologist, and pain management physician from Stanford. We filed at DIN 3497 on October 14th our motion to limit his testimony and exclude certain parts of his anticipated testimony. Based on the court's previous rulings limiting our experts in the same fashion. We have from Dr. Crane and attached to that motion his report, which is 10 pages, and vast swaths of it are, if the court's previous line drawing exercise is to be consistent, not relevant to this lawsuit. So I don't know the best way to go about this. I think the defense probably recognizes that there's several portions of this that will not be discussed. So maybe we could ask for what it is he will be testifying to so that we can respond to see if there's any ruling the court needs to make.
I guess I'm not clear as to what it is you're asking me to do and rule on.
Well, okay. For example, under 766, as we've heard from the defense, this physician is an anesthesiologist and pain management physician. He has offered in his report standard of care opinions broadly.
Are you saying he is not qualified under the Med-Mal statute?
He's not qualified to offer standard of care opinions for the pediatricians, the hospitalists, the neuropsychologists, the psychiatrists, anyone outside of the pain management team at the hospital. There's other issues I'd like the court to address, but I'll give you a moment if you want me to stop.
Well, tell me what Dr. Crane is. He's a pain management doctor?
Pain management and physician and anesthesiologist.
If the court please, it goes beyond that. Dr. Crane is board certified in anesthesiology, pediatrics, pediatric anesthesiology, critical care medicine, and pain medicine. He is qualified by virtue of those board certifications to address pediatricians, critical care specialists, anesthesiologists, and pediatric anesthesiologists. Those are the ones he's going to be addressing. He is not going to be talking about standard of care for psychologists or psychiatrists, but he will be talking about standard of care for the rest of the specialists I just enunciated, much as he did without objection during his pre-suit affidavit that plaintiffs have been provided in addition to his 10-page report. He has testified at length regarding his view of the standard of care in his report and in his affidavit. He has also opined on the standard of care with respect to anesthesiologists, specifically doctors Cantu, Hanna, and Kirkpatrick. He is board certified in that specialty as well as the subspecialty of pediatric anesthesia and is qualified to do that. Plaintiffs have raised the issue of whether he has addressed the issue of causation. His report expressly addresses that question on page 8, where he states that one of plaintiff's experts, who has since been withdrawn, indicated that there was no harm caused to Maya by the ketamine. He expressly states that is incorrect, and then he goes on for a paragraph about the harm that was caused. Counsel is correct that he is not going to be addressing the report of child abuse and the basis upon which the child abuse was reported. His report, after all, is dated back in 2021, but we respectfully submit that this question has already been addressed in plaintiff's motion in limine, or excuse me, their Daubert motion filed a while back here. If I can find the DIN number, Your Honor denied it on 3412. The DIN number for that previous motion is, now I can't find it, but the point is not only has this already been hashed out, it's been considered by the court and denied.
and Dr. Crane is fully competent to address the areas of standard of care that we intend to elicit testimony on with regard to him tomorrow. And I would also point out to the court that part of this is based upon the failure of plaintiff's counsel to conduct a deposition of Dr. Crane when they had it set to do so in this past June. So we respectfully suggest this should be denied, Judge. On their motion before with DIN 2496, it was styled at that point as a Daubert motion.
Your Honor, he just responded to arguments I hadn't yet made, so I've had an opportunity to respond.
Sure.
Just like the defense filed a Daubert motion and then converted it to a motion to limit the testimony, we're doing the same. In his report, he offers opinions on conversion disorder and functional neurological disorder. He's unqualified to do that. This Fabre notion, there's no causation opinion in this report. On page 8, there's no causation opinion. To a reasonable medical probability that doctors Cantu, Kirkpatrick, or Hannah caused any harm to this patient, the closest he gets is to say that the polymicrobial pneumonia, which is incorrect, it was a culture during intubation but never progressed to pneumonia, could have proven fatal. That's the closest he gets to a causation opinion. Nowhere in this report does he express causation opinion with the certainty he would need to testify against these physicians. I think appellate counsel for the defense has recognized the report's deficient by nearly stipulating that there would be no Fabre defense in this case. And then throughout, he also laces in opinion.
I guess I'm trying to find the guy's report.
Oh, I'm sorry.
Where is, I'm looking at 3497.
Your Honor, I've got a copy of it here.
And this is
It's Exhibit H to our motion, I'm told.
I'm going to get something from Dr. Alexander. Well, on the question of whether he would meet the qualifications under Chapter 766.102, or I should say Section 766.102, paren 5.
We're not challenging as to his specialties, under that basis. We're challenging to specialties he's not qualified in, such as psychology, psychiatry.
Well, and I think he just said that they weren't.
Okay, then there's no issue over that.
So then the next issue is that he being Dr. Crane is not making a statement to within a reasonable degree of medical probability
As to causation of harm caused by Doctors Cantu, Kirkpatrick, Hannah. The criticism that defense counsel just mentioned was of a former expert of ours that has been dropped and was dropped long ago, Dr. Webster. So that can't get them over the hurdle there. And then the last issue is that he wants to comment on both the suicide and Chapter 39 duty to report issues.
You were talking about something on page 8.
The first full paragraph on page 8, Your Honor. And
that says he stated that ketamine?
Yes, he stated that ketamine caused no harm to Maya. That is incorrect. She contracted a polymicrobial pneumonia in Mexico as a complication of ketamine use that could have proven fatal. During her subsequent treatment, she was significantly underweight, probably as a consequence of appetite suppression by ketamine. In my opinion, she also became physically dependent on ketamine and experienced withdrawal symptoms. In my extensive experience with ketamine use as a treatment of pain in hospitalized children and as a sedative in children with intensive care, I can state categorically that children do exhibit physical dependence on ketamine, and withdrawal symptoms of ketamine is not tapered or weaned. Judge, he didn't say the magic words reasonable medical probability. but he certainly said that there were complications of ketamine use that he was criticizing that were probably the result of the ketamine use. I suggest that by Your Honor's previous statements about notice in the report, that nails it.
Well, to me, the question of notice, it's there. Did you all take a deposition of this doctor?
No, Your Honor.
Okay, so, look, if he doesn't testify to a reasonable degree of medical probability, then it's going to be out. You can't use it for any sort of Fabry. I don't even know if you're going there anymore.
I understand completely.
Yeah.
I raised my questions accordingly.
So, the report is, put you on notice, at least you're in the ballpark, so it's up to you to take the deposition.
Thank you.
What's next?
Then the other issue, I assume they'll agree he's not going to comment on the reasonable duty to report as he did in his report
That's
here.
out.
That it's not an issue in the case.
He also, sorry, Judge, he also has an opinion that she did not really commit suicide.
That's not what he said, and he's not testifying about suicide.
Okay, what's next?
As far as I'm concerned, Judge, there's also this issue with respect to Dr. Alexander. Dr. Alexander is not, we're not calling...
Different Alexander.
Yeah, different Alexander, sorry. Not the one you just ruled on. Another Alexander. We have another expert whose name is Alexander, who is a board-certified pediatrician. He's also board-certified in child abuse pediatrics. His principal purpose is to testify about general pediatrics, and once we get straightened out where we can go with it, what Dr. Smith did. The baseline of his opinion has to do, again, with child abuse pediatrics and Dr. Smith's involvement in the case, as well as standard of care for pediatricians. He's not testifying about Fabry issues or criticizing other doctors. He's just testifying about standard of practice, whether it was reasonable to suspect Munchausen by proxy, whether it was reasonable to suspect factitious disorder and conversion disorder in this patient, and he's qualified to do all the above. The counsel, I think, is also concerned about Dr. Kelly. I've told him he's not coming. There are not any other witnesses that I think we need to cover at this time.
Maybe. Why don't we rather talk about that?
So I'm not sure what you're asking me to do.
I'm not asking you to do anything, Judge. I'm asking you to let us go home. If
Let's second that. Let's rally.
Yeah, Judge,
Judge, I guess it would be then our motion, and the problem that we've got is exactly what the court has been dealing with over the whole weekend. They're going to try to drag this case back into a Chapter 39 debate about Munchausen by proxy for Beata Kowalski, as opposed to anything having to do with the treatment of Maya Kowalski. And the court's made that very clear, I think.
That's right.
So
Judge, can we talk exhibits?
No.
No, I don't mean deal with them right now. I just mean, what's the game plan? We're going to be, I don't think we added any yet. We're going to be adding some, but since it's past, we'll be doing it tonight, so we don't need to address any of them, I don't believe, for any of the witnesses tomorrow. But we're going to need some court's time with some exhibits.
Well, I think as far as exhibits, tomorrow morning, I'm going to hopefully make rulings with respect to a whole bunch of those that we discussed on Friday.
Okay.
And then hopefully at some point tonight, I will turn to Dr. Malik deposition designations.
Yeah, I don't think there's, have you filed?
And then I'll get to...
Filed their objections? Yeah.
I'll also try to get to to Mr. Elegant and Mr. Altenburn the statement about the dependency orders.
Okay.
That's on my plate tonight.
Okay. What time would you like us here tomorrow?
Let's go with 8:30. And do you want this back?
Yes,
I wrote on it.
I'll take it back.
I only put lines. And do you want this back as well? I don't know who gave that to me.
I don't know what that is.
And we do appreciate all the hard work, even though we never say it.
I concur with Mr. Anderson. Thank you.
Have a good night, everybody. We'll be in recess.